effective by the scheme's operation. The objective of reserving the quota for LBC is to facilitate accelerated promotion for meritorious judicial officers, allowing them early entry into the district judge cadre. If the time taken for LDC eligibility equals that of regular promotion, the intended incentive is lost. We therefore consider it appropriate to reduce the eligibility requirement for LDC from 5 to 3 years of service as a civil judge senior division. We also hold that the total required experience should be minimum of 7 years cumulatively, inclusive of service in both junior and civil senior divisions. Issue number 3 and 4 we are considered together. The issue number 3 is as to whether a quota needs to be reserved for meritorious candidates from the civil judge junior division to civil judge senior division, so that there is an incentive for merit in the cadre of civil judge senior division. If yes, then what should be the percentage thereof, and what should be the minimum experience as a civil judge junior division? We are of the view that 10% of the posts in the cadre of civil judge senior division should be reserved for promotion of civil judge junior division through the LDC mechanism. The said seats would be filled up with the same mechanism adopted for filling up the vacancies reserved through LDC for entry into cadre of district judges. The minimum experience of a judicial officer in the cadre of civil judge junior division for appearing in such an examination should be 3 years. As to whether the quota to be reserved for the aforementioned departmental examination in a particular year should be calculated on the cadre strength or on the number of vacancies occurring in the peculiar retirement recruitment year. We are of the view that a uniform practice needs to be followed by all the states in the country. Since most of the states are already filling up vacant posts as per the total cadre strength, keeping uniformity in mind, we are of the view that the quota to be reserved for LDC should be calculated on the basis of cadre strength. Issue number 6, as to whether some suitability test should also be introduced while promoting the civil judge senior division with the cadre of district judge against the existing 65% quota for promotion to the higher judicial service on the basis of merit cum seniority. How that will come to 50%. We have the view that though every high court would be required to frame the rules for determining the suitability of a candidate for being promoted to the cadre of higher judicial service from the cadre and civil judge senior division, no straitjacket formula can be laid down for the said purpose. We however find that in such of the states where the rules have not been framed for determining the eligibility, suitability of a candidate for being promoted to the cadre of higher judicial service from the cadre of civil judge senior division, such as the high courts and the state governments should frame the rules forthwith. We further find that the high courts and the state government shall examine as to whether the rules already existing are sufficient to determine the suitability of a candidate for being promoted to the cadre of higher judicial service from the cadre of civil judge senior division. We find that for providing a rule for determining the suitability of a candidate, it would be relevant to consider various factors. We are referred to the factors which are required to be taken into consideration for determining the suitability. Then the seventh issue as to whether the requirement of having minimum 3 years practice for appearing in the examination of a civil judge junior division, which was done away by court in 2002, CJI case needs to be restored, and if so, by how many years? Then issue number 8 is also interconnected. The requirement of certain minimum years of practice for appearing in the examination of a civil judge is restored. Should the same be calculated from the date of the provisional enrollment, registration, or from the date of passing of the All India Bar examination? They refer to the all judgments and also the reports of the Law Commission. From the affidavits of almost all the high courts, we've seen that for the last 20 years, during which the recruitment of fresh law graduates, judicial officers without a single day of practice at the bar has been permitted, the said endeavor has not been a successful experience. The appointment of such fresh law graduates has led to many problems, as have been enumerated by us in the judgment on the basis of the affidavits filed by the High Courts. We are conscious of the fact that in the initial years, the opportunities available to a young lawyer fresh from college will be minimal. However, the exposure to court, and more particularly litigants and their briefs, would acquaint them with the onerous duties and responsibilities of every stakeholder in the judicial system. It will bring in sensitivity to human problems, more clarity in the decision-making process, and educate them of the role of the bar in justice dispensation. The judges from the very day on which they assume office have to deal with the questions of life, liberty, property, and reputation of litigants. Neither knowledge derived from books nor pre-service training can be an adequate substitute for the first-hand experience of the working of the court system and the administration of justice. This is possible only when the candidate is exposed to the atmosphere in the court by assisting the seniors and observing how the lawyers and the judges function in the court. The candidate should be equipped to understand the intricacies of the functions of a judge. We are therefore in agreement with the views expressed by most of the High Courts that the requirement of reintroduction of a certain number of years of practice would be necessary. Regarding the question of calculation of minimum experience, the court will have to balance the requirement of having a minimum experience at the bar and also provide an opportunity to the young meritorious law graduates to appear in the state examination. There could be various reasons as to why the candidates are not in a position to appear for AIB. Different universities may declare the results at different times, which may lead to a candidate losing the opportunity to appear for such an examination in a particular year. Therefore, we are of the view that the experience should be counted from the date on which provisional registration has been granted to a candidate. Another concern that was expressed was that a candidate may not actually practice even for a single day and may only on the basis of the provisional registration apply for the civil judge junior division examination. And this would in turn frustrate the very purpose of providing an experience. We find that the state concern can be addressed by providing certain safeguards. It could be provided that a certificate by an advocate having a minimum standing of 10 years, duly endorsed by a principal judicial officer of such a district or principal judicial officer at a station, certifying that such a candidate has actually practiced for the requisite number of years, would take care of the concern. Insofar as the candidates who are practicing before the High Court or this court, they shall be certified by an advocate who has a minimum standing of 10 years, duly endorsed by an officer designated by that High Court or this court. Insofar as AIB is concerned, we are not agreed with you. Yeah, because after the provisional, if one does not clear AIB, he doesn't get extended. So that's not
provisional.
So unless he gets AIB, he doesn't get a permanent registration.
Get the continuity.
We have issued the following directions. And the state governments, the country shall amend the relevant service rules to the effect that the quota of reservation for LDC for promotion from the cadre of civil judge senior division to the higher judicial service is increased to 25%. All the High Court and the state government, the country shall amend the relevant service rules to the effect that the minimum qualifying service required to appear in the LDC for promotion from the cadre of civil judge senior division to the higher judicial service be reduced to 3 years service as a civil judge senior division, and the total service required to be undertaken, including service rendered as civil judge junior division and civil judge senior division, be set at minimum 7 years of service. All the High Courts and state governments in the country shall amend the relevant service rules to the effect that 10% of the posts in the cadre of civil judge senior division be reserved for accelerated promotion of civil judge junior division candidate through LDC mechanism. The minimum qualifying service required for appearing in the said LDC shall be 3 years service as a civil judge junior division. Needless to say that if any post reserved for LDC either for civil justice senior division or for higher judiciary, remains vacant, the same shall be filled through regular promotion on the basis of merit cum seniority in that particular year. Filling up of the vacant post, the ratio considered for LDC will have to be carried out from the simultaneous selection process carried out for the regular promotion in the very same year. The High Courts and the governments of the state, where the vacancies for the LDC are not being calculated based on the cadre strength, shall amend the relevant service rules to that effect, to the effect that the vacancies for LDC be calculated on the basis of the cadre strength. All the High Courts and the state governments in the country, where the rules are not framed, and if they are framed but are not adequate to judge the suitability of a candidate for being promoted in the cadre of higher judicial service from the cadre of civil justice senior division, shall frame fresh rules or amend the existing rules, keeping in mind various factors like: 1. Whether the candidate possesses updated knowledge of law. 2. The quality of judgments rendered by the judicial officer. 3. ACRs of the judicial officer for the preceding 5 years. Disposal rate in the preceding 5 years. Performance of judicial officer in the YOC, and general perception and awareness, as also the communication skills. All the High Courts and the state governments in the country shall amend the relevant service rules to the effect that candidates desirous of appearing in the examination for the post of civil judge junior division must have practiced for a minimum period of 3 years to be eligible for the state examination. To fulfill the state requirement, the rules shall mandate that the candidate produces a certificate to that effect, duly certified either by a principal judicial officer of that court or by an advocate of that court having a minimum standing of 10 years, duly endorsed by the principal judicial officer of such a district or a principal judicial officer at such a station. Insofar as the candidates who are practicing before the High Courts or this court, they shall be certified by an advocate who has a minimum standing of 10 years, duly endorsed by an officer designated by that High Court or this court. We further direct that the experience of the candidates which they have gained while working as law clerks with any of the judges or judicial officers in the country should also be considered while calculating their total number of years of practice. The rules shall also mandate that the candidates who are appointed to the post of civil judge junior division, pursuant to their selection through the examination, must compulsorily undergo at least 1 year of training before presiding in a court. It is directly that the number of years of practice completed by a candidate winning the post of civil judge junior division be calculated from their provisional enrollment registration with the concerned state bar council. It is further directed that the state requirement of minimum years of practice shall not be applicable in cases where the concerned High Court has already initiated the selection process for the post of civil judge prior to the date of this judgment, and shall be applicable only from the next recruitment process. All the amendments in terms of the opposite direction shall be carried out by the High Courts within a period of 3 months from the date of this judgment, and the concerned government, state government shall consider and approve the same within a further period of 3 months. We place on record our deep gratitude for the assistance rendered by Shri Siddharth Bhatnagar, Learned Amethyst Puri, ably assisted by Mr. Yanki Razo and Mr. Aditya Siddra. Shri Bhatnagar has tirelessly consolidated the stands of various High Courts and various state governments and also given his valuable suggestions with regard to the direction which is issued by this court. We also place on record our appreciation for the senior counsel and the counsels appearing on behalf of the various High Courts, state governments, and other stakeholders. I must also appreciate the contribution of both of my learned brothers, Mr. Basi and
The processes will go ahead with this modification.
They'll have to frame that.
The judicial recruitment which have been stayed,
Yes,
which have been kept in appeal, will proceed with this.
we have said needless to spread that all such recruitment processes which were kept in abeyance in view of the pendency of the present proceedings shall proceed in accordance with the rules as were applicable on the date of advertisement.
Incidentally, may I make one small.
Yes.
Yesterday's judgment, Murad, the judicial High Court judge's pension matter.
Yesterday's matter.
Yes, Murad. Murad, earlier, Murad, the previous bench was ordered for payment of 6% of interest, Murad, for the arrears, and a timeline was fixed. Murad, we brought the same to your lordship's notice, Murad.
A timeline, I think we have already framed the day.
Timeline not given, Murad. One regarding arrears, timeline not given. Two, Murad, the interest, Murad, 6%. Your lordship, kindly have a look at this judgment.
एक काम कर रहे हैं, जो कल का जो है उसमें भी ऐड कर लीजिएगा. It is further directed that. So, Amazon did not remind us yesterday. It is further directed that all areas to the High Court judges, we worked on the basis of the opposite direction, shall be paid to them in a period of 6 months from today, along with the interest calculated at the rate of 6%,
6%.
from the rate of entitlement till the rate of actual payment.
Great.
Be very quick.
Grateful. Very good. Very good.
This appeal which has come to this court against the order passed by the division bench of the Bombay High Court, we have found to be in accordance with law, and we have found that there is no statutory rules violation or any principles of natural justice as was alleged. You dismiss the present.
Obliged. Obliged. Lordship, this is a matter.
Yes,
Yeah, the Lordship had issued notice in February last year, with returnable within 4 weeks. Its service is complete long back. It's not got listed. We need a
what
date.
is it about?
It's about sawmills operating inside a prohibited area of reserve forest Odisha.
You-
Lordship may give us a date.
No, you are for the,
We are the PIL petitioner.
yeah,
PIL.
we will have it in the next week. You are copy to us for permission.
We'll do that. Great.
So these are two applications, one for intervention, one for directions. The state of Uttar Pradesh had announced a night safari in a forest called Kukrel in violation of an interim order passed by this honorable
It was
court.
already listed on 28th of May.
Yes, Your Lordship, those are the state of UP's applications. I am for the PIL petitioner who had already approached the NGT. I am only seeking to be listed on the same dates, these two applications.
Lordship, my house and property is sealed. Matter could not be listed despite listing. Could that reach? Lordship, we are out of our house and office from last 1 year, Lordship.
803. You are mentioning 803.
803.
It has something to do with the Bar Council.
No, it is not bar council.
कोर्ट में बार काउंसिल लिखा आफ्टर वेकेशन आफ्टर वेकेशन.
I'm seeking a lordship liberty to mention a fresh IA in the TN Go Government matter, my lord. It is pertaining to the Aravalli Hills. The other issues pertaining to the same issues are coming on 26th. All I am requesting this IA to be taken.
Yes, we'll keep it in the next week.
Yes, my lord. Along with the batch matters that are much obliged.
Your Lordship, I'm appearing 805. Lordship, the urgency is that the admission process has already begun and it is likely to be completed in the next month, Your Lordship. Once the admission process is completed, I'll be denied the benefit of institutional quota, which have been consistently being denied since the past academic years, Your Lordship. Therefore, considering the fact it may be listed tomorrow, Your Lordship.
What is the urgency?
Your Lordship, I am an college who has been denied the 15% institutional quota which I have been entitled to Once the admission process begins, Your Lordship, which it has already, then what happens is the state government will not be able to accommodate my quota which I am entitled to.
Okay, we will have it in the next week.
Obliged, Lord.
Not to be delayed at all.
Likely to be listed on 23rd may not be this.
Not to be.
Value.
My lords, in 808, I appear on behalf of the respondent. My lords, I am the founder of this particular society, the president, my lords. And my lords, I have got concurrent findings in my favor with regard to the respondent having resigned as vice president, wrongly inducted 5 persons, my lords. And my lords, the elections were also pursuant to the High Court's order, already directed to be held in 2020. I'm just seeking listing of this matter. My lords, the other side, that is the petitioner had filed an IA for directions, which is coming on the 28th of July, which is a Monday. My lords, the main civil appeal, my lords, is something which I would request, my lords, to kindly have it on any day, my lords, as per my lords' convenience, subject to my lords.
Let the main matter be along with that.
But that is a miscellaneous day on Monday.
On that date, you make a mention that it should be kept on a.
My lords may then kindly have the, my lords, because it's a connected batch of 4 appeals. Grateful, my lords. Obliged.
Yeah. Lord, it's for a PSU appeal. It's a PSU appeal, my lord. We are losing close to 500 crore a day. Orders have come, my lord. We have filed the appeal. Maybe listed on Friday, my lord. We want to.
Next week.
Next week.
That 811, Lord, is a fresh MA in a matter where the judgment is passed on an application of the state of UP without making us party, where the substantive litigation was pending before the Honorable High Court, my lord. And in the same judgment, my lord, the court has directed taking away the fund of the temple. This relates to Vrindavan Vakya Bihari temple, my lord. And the state is taking away the fund from the temple's, which is temple's account, which is kept pursuant to the direction of the High Court, is kept in abeyance, Lord. And we have not been heard at all.
Okay, next week.
Lord.
Please, my lord. My lord, this is fresh matter regarding the election of Sahadra Bar Association, which is fixed. Election of Sahadra Bar Association, your lordship.
Yes.
Your lordship, election is fixed on 24th. Your lordship, my candidature has been rejected.
Already listed on 23rd.
Your lordship, tomorrow.
23rd.
Please. Your lordship, 24th is election.
So 1 day prior, it is
my candidature was rejected, your lordship. Tomorrow, your lordship, kindly, your lordship, consider tomorrow.
23rd. Yes.
Kindly, your lordship. Again, I request your lordship.
Next week. Yes.
There's a demolition matter, these premises have existed as far as 2003, my lords. Sadly, on a PIL, my lords, directions have been given, my lords, for the structure to be removed, failing which demolition would happen, my lords, in Bombay, my lords. Therefore, my lords, the anxiety is because the demolition was supposed to start any time from yesterday onwards, my lords. The 2 weeks expired. The High Court passed the order on 5th of May, my lords, uploaded, my lords, ultimately after 4 days.
Demolition of?
Plus demolition of a structure which has been constructed by MADA. MADA accepts this, but somehow the High Court, my lords, urges and says it's not authorized.
Day after tomorrow. Day after tomorrow.
Day after. My lords, I'll seek liberty to be online, my lords, only for this purpose, my lords. Of course, my lords, I had this. Wait.
Lord, my lights can't leave millets if I'm permitted to make an unlisted mentioning millets. One common order, 3 SLPs were filed. One is listed on 23rd. The remaining 2 have been numbered. If they go along, one adjudication will take place.
The reason
I'll give the numbers.
The reason I'm mentioning an unlisted mentioning, I and Mr. Devan are mentioning 2 matters on the same side. Millets is that at 10:30, a formal dismissal order was passed today.
Same matter, both on the same side.
Different tenders. Today, a dismissal order was passed. I just wanted listed urgently for the reason that we were declared ineligible without giving reasons, hearing or calling us or notice, despite those rules being there. My learned friends on the other side say the rules are not required to be applied. Having done that, they're about to open the financial bid for a 8,000 crore or 7,000 crore contract, MMDRA Mumbai. I'm only saying that a lot should be listed, if not today, at least tomorrow. We've asked the learned judge today at 10:30 for a stay. The stay was refused.
Bombay High Court.
Bombay High Court. That's why we've just come straight out. That's why I couldn't get a token.
Tomorrow.
Same thing there.
Grateful.
No, may I mention unlisted?
Obliged. Deeply obliged.
The urgency is that my land, my lord, which I actually have got a decree for possession, that possession is being interfered with on the basis of subsequent suit, which was dismissed by the trial court. In appeal court, they got it restored, subsequent suit. And they come here and they get an order without actual hearing us. I may not be mentioning it to the bench of Justice Karol. He said I have to take liberty from your lordships. Not any day, this Thursday or
next week.
Next week.
My lord, may I mention this matter? On 9th of May, Justice Narasimha's bench listed my stay application to be listed next week. It's not been listed. I mentioned in the morning before Justice Bagchi. He said that I should mention before your lordship. Lord, if it could be on Friday, I'll be grateful. My stay application, only my stay application.
Next week.
I request fresh matter, one fresh civil appeal before this side of vacation. Otherwise, there will be disruption of the supply to the entire state.
Disruption of?
Supply, electricity supply. For electricity supply to this one, to the grid. Yes, before vacation, fresh matter.
Monday?
Before vacation.
Well, it is not only that judges should work in the vacation. If there is urgency, I would in the next week, otherwise after vacation.
Can I request?
Monday. Registry is already overloaded. Yesterday, I was also required to sit till 11.
I know.
Your lordship, they were working from morning till
I know.
till 9:30.
I know there's a lot of burden on this one.
Your lordship, may I mention
Monday.
Criminal appeal, your lordship, it was dismissed.
We have decided that if anybody has any urgency, it will be only now in the vacation, unless there is something alarming, somebody is being hanged tomorrow or somebody's house is being demolished tomorrow. Otherwise, all matters will come in the name.
Your lordship, may I
Everybody who is mentioning, please note that no circulation would be granted for tomorrow or day after tomorrow. All those who want urgent circulation, I ask the registrar to grant them circulation in the next week.
Your lordship, may I mention?
And at the time of mentioning, if I find that there is no urgency, still it is being orally mentioned, then it will be directed to come in the regular course. So please note this while mentioning the matter.
Your lordships, can I mention a criminal appeal? It was dismissed in default, your lordships, on Friday, your lordships. I could not appear. I'm seeking restoration, your lordship.
You can come in the next week.
Next week, please. Next week.
So whoever wants in the next week, the matters would come. So don't mention for the next week. If somebody wants for tomorrow or day after tomorrow, they may mention it. If there is some genuine urgency.
Well, it's a fresh transfer petition criminal. The magistrate is said
Telling that it can come in the next week. What is the alarming urgency that it can't wait for 2 days?
cognizance will be taken on 30th because matter before the trial court is.
When was the order passed?
Well, it's a fresh transfer petition criminal. I'm seeking transfer of criminal complaint merits.
Next week, please.
Your Lordship, allow me to mention unlisted item. Your Lordship, the illegal river sand mining has been taking place in Rajasthan in Aravali Hills, and lease has been granted to more than 300 sites without any considering DSR or without replenishment.
When were they granted?
It was granted, Your Lordship.
When?
Last month, Your Lordship.
Last
month, Your Lordship. This year, Your Lordships.
Can't it wait till next week?
Yes, Your Lordship.
We are telling don't mention for the next week. We will be getting circulation for the next week.
Please, Your Lordship.
There's an application for withdrawal. The reason I'm mentioning is because there's no quorum as of now. Next week, there's an application for withdrawal and 2 connected IAs in a transfer case. The reason I'm mentioning is because there's no quorum as per the registry. That's why it's not getting listed.
Lordships, one writ petition civil, 381 is the pending since last 1 month before theirs. Lordship, this matter is not listed by the registry that 2 days. These similar types of the matter are already daily taking theirs before the appropriate benches. Lordships, I am seeking to give the direction to this matter be listed because this is the suffering since after the verified after 1 month. Lordships, please give the directions, please. Lordship.
Lord, may I mention a matter? Lord, may I mention a matter, my Lord? This is the doctor's child custody matter from Bangalore. Lord, your Lordship have directed it to be listed on 15th of July. It's coming up on 15th of July. Lord, since it was heard by your Lordship and Justice K.V. Vishwanathan, and the children and the mother and father were interviewed, would it be, my Lord, possible your Lordship may consider constituting a bench so that, my Lord, because since your Lordship had interviewed the child.
We'll consider it, yes.
Very well. I'm so.
There's item 31 today, Milos. These are those BCCI matters, Milos. There, Milos, still the counters need to be filed, Milos. The Lordships have.
Anyways, those matters, they may not reach today.
That's right, Milos. Therefore, I was requesting, Milos, if some time may be granted.
Marshal, go beyond vacation. Milos. I don't think BCCI has any essence.
After vacation.
Pilot item number 1.1 and 1.2 are bail applications. In item number 1.1, 15 years and 1 month has been undergone. In item 2, that woman who is 6 years and 1 month has been.
Lordship, we have not
undergone. 6 years and 8 months the woman has undergone.
Lord,
In 1.1, 15 years and 1 month has been passed.
Yes, Mr.
Lordship, we have not received the application for bail or come from the complainant.
My Lord, for the state, only one matter I have received the application.
Give him the copy at least.
Have it on Friday, my Lord.
Friday.
Have it on Friday or next week, my Lord.
Next week.
Yes, my Lord.
8 months.
Oh, that's this.
तो खाली बेल बेल
इस कॉपी में टू आइए टू कोई है
Your Lordship, I appear for the petitioner. Your Lordship, I move in IA pending my SLP. The maximum punishment which was awarded was 10 years. Out of 10 years, I already undergone 6 years, 7 months. Your Lordship may recollect this was the same matter. State has filed a reply said that I jumped the bail condition. But Your Lordship, there are 2 matters. In one of those matter, I already got acquitted. Second matter, I was only a pillion writer. And that is already pending. I will be getting that benefit.
Oh, what is here on merits is a concurrent finding.
No, Your Lordship may see there are lots of developments, further development were there in the evidences, including the statement by DSP. Yeah, and there is only sole independent witness who was never examined. So rest all were all police parties. So only the sole witness he should have out to have been examined. That was very important. Second, Your Lordship, there are according to our cases that this comes below the commercial quantity. And apart from that, Your Lordship, the CFL report was not sent on time by the police official. So there are lots of improvements were there, and these are all evidences are in my favor, my Lordship, that benefit can be given to me.
Concurrent findings of trial court and the high court, everything is being discussed. There was a recovery of 51 kilos of poppy seeds, which is a commercial quantity.
85 kg.
51 kilos. And then, my lords, there are, in fact, the trial court has dealt with all these arguments and say that the police officials, if you don't ascribe any mala fide, those can be the witnesses which can come. And in fact, every procedure has been followed. 52A was followed. He was taken to the magistrate. Magistrate has done a list of what has been seized. The seal was put. The samples were sent to CFSL. CFSL report has come back. And my lords may see the antecedents. He was convicted in the similar offense in the other case also.
But that is acquitted, my lord.
No, one is conviction. FIR 362.
Page 32 CFL report was not prepared, my lords, and not signed also, handed over to official SHO. So lots of evidences are in my favor. Let that main appeal be pending, my lords. And my bail can be decided today.
While on bail in this matter, he has done another crime, my lords, FIR 41, which is 2010, 22/5/2010, which we put in our counter.
Put it for hearing then.
Yeah, at least bail can be decided, your lordship. Bail, his wife is in hospital for surgery. 6.5 years already undergone for maximum.
What surgery?
Stomach say some I'll put that on record, Your Lordship. But I just got instruction from the local advocate there. His wife is admitted. At least this bail can be decided. Appeal can be put for.
We'll direct the appeal to be placed in the vacation. Yes. Vacation में आपको final hearing. तो वक्त के बाद आप
Please, Your Lordship. Lordship, by order dated 12th of July 2000. Your Lordship, by order dated 12th of July 2024, Your Lordship had granted me ad interim bail in this FIR. This pertains to an FIR under the SC/ST Act, my Lord.
Yes, who is for the...
I am for the state in this matter, my lord. He is already cooperating with the investigation.
We are appearing for respondent number 2 and we are seeking some time to file the counter affidavit.
What counter you can file in there?
On 34.
Waiting for some.
This is all this is gross misuse of SC/ST Act.
Yes, Your Lordship. Kindly grant us just a week time.
Material instructions.
Your Lordship, there were 2 occasions granted to the respondent number 2.
2 occasions.
2 occasions. But they could not file the counter. In fact, on the last date, Your Lordship, the learned registrar also noted that this is the last opportunity of 4 weeks that is being granted to them. 21st of February, they entered their appearance, and till date, there is no counter for 3 months.
The contents of the FIR are in the SLP are
payment imposed by the learned counsel for the state.
No, my lord.
And the learned counsel was a complainant. The learned counsel was a complainant seeks further time. However, the perusal of the order passed by the learned registrar, dated 17th of April 2025, would reveal that 4 weeks time was granted by way of last chance. Sorry, in that view of the matter, we are not inclined to act on the matter further. It is not in dispute that the petitioner, in pursuance to the interim order, has cooperated with the investigating agency. Application is allowed. The order response stands confirmed.
I'm so grateful.
Lord, in this matter, item number 4, with respect to co-accused, bail, Lord, has been listed by your lordship on its. It has a scam of 10,500 crores, my lord.
Look, I think the learned additional solicitor will allow me to open every time this matter is adjourned again and again by saying so and so co-accused, so and so co-accused. This is 34 months, Lord. The maximum sentence is 10 years. 34 months I've been in jail. The High Court notes that there are 90 accused, 125 witnesses, 1 lakh page charge sheet, 1,02,000 page charge sheet has been filed. Charges are not, for the last 1 year, they have not filed replies. I have not made a single application. Various other accused have made applications. I'll just hand up that to your lordship. Not just see the Roznama. For 1 year, they don't file replies to applications and the matter is adjourned in the trial court. Please just see the progress in the trial court.
We have.
If my lord sees, if I can just take it step by step, notes. I am arrested more than second of, in so far as the ED offence is concerned. I've been enlarged on bail. The CBI predicate offence there has been quashed. Now this is the SFIO under section 22126 of the Companies Act, read with section 447. Maximum sentence is 10 years. Now, my lord, your lordship will kindly see from 2nd of August 2022, I'm incarcerated. Now, just see this list, my lords. If my lord just kindly sees, the first date is 25th March 2024 at the top. Page. Now, page. I've just handed up the Roznama of the Sessions Court. About the middle, your lordship will see all those numbers. After all the numbers, criminal MPs 4189 pending for reply, objection of SFIO side, call on so and so. All these various applications by various other accused, not me. I don't have a single application. Now, your lordship sees the last date, 26 March 25, 1 year later. The last page of this sheet. Same applications still pending, 4189 of 2023 for reply objection of SFIO side, call on so and so. All those applications are pending of various people. 205 applications have not been decided. 207 stage has not reached. 90 millards accused, and there are some accused have not even been served, millards, with 3 of them. Your lordship will see service pending. So what is predicate?
predicate offence has been quashed by the CBI offence.
No predicate offence, it is SFIO
That,
matter.
that is not in the ED.
matter.
In the ED case, predicate offence is quashed. I'm enlarged on bail in ED.
But is it pertaining to the same transaction or?
Same transaction, the loan taken by a company. Some loans have been taken. I have not, I was never in charge of that company. That's my case. But I have anyway resigned as a director and sold my shares to my brother-in-laws in 2012. And the last company in 2015, I had resigned, and it is their own case. This SFIO starts in 2018. 2022, I am arrested. And I've never been a director. I have no connection with the companies from 2012 for 2 companies and 2015 for the 3rd company. There are some other 12 companies with which I've never had any connection ever. No shareholding, no directorship, nothing. 15 companies and all. The issue is with regard to non-payment of loans, non-repayment of loans, which has been made into a criminal thing. But I'm not concerned with merits, my lords. I'm on a simple thing here. Your lordship may just see the High Court judgment. The prosecution itself says.
How much amount has been recovered?
I'm sorry, Mills?
How much amount has been recovered?
10,000.
According to them, 100 crores. Your lordship will see that at page para 4 at page 5, Mills. Nothing, not a single penny recovered from me, not a single property attached, nothing. I've been behind bars for 34 years. Para 4, Mills, at page 5. The learned special public prosecutor would further submit that now the case is ripe for trial and all the accused were given copy of charge sheet. He would submit that total 90% were arrayed as accused, in which the petitioner is arrayed as A5, and nearly about rupees 100 crore were recovered, and so far no property was attached. He would also submit that as per section 2126 of the Act, any person shall be released on bail unless the public prosecutor has been given opportunity to oppose the application for such arrest and the offence on the ground of belief. However, in the present case in hand, the court is to be satisfied that there are reasonable grounds for believing that in future he will not indulge in any such offence. As per section 2126, the materials may be placed, etc., etc. Then para 5. Considering all the above facts and circumstances and on perusal of records, it reveals that the statements furnished by petitioner, which were relied on by learned special public prosecutor, prima facie proves that the petitioner is involved in the aforesaid offence. However, according to the petitioner, he has not committed any offence. He resigned from his post on 4/11/2015 by relying on the order of quashing the CBI's FIR before the High Court of Karnataka and also relying on the long period of incarceration of more than 2 years, 4 months. Petitioner's counsel paid for bail. But according to the prosecution, they have to examine 125 witnesses and it will take some more time to commence the trial. Furthermore, while dismissing the petitioner's earlier petition seeking for bail on 8th December 2022,
for grant of bail, the applicant is facing
Trial under section 447
447
of the Companies Act.
Companies Act 2013.
Section 409?
47, Ballots.
47 of the Companies Act.
2013.
And which other offences?
No other offence. 212 is
there are offences
212 is a
IPC
procedure
as
for
well, Milord.
investigation and
Yes, incorrect statement is being made. Milord, apart from 447, Milord, it is also 420, 120.
Yes, yes. Therefore, that we are asking you which are the other offences. So.
Lordships. So,
SFIO is only SFIO offence is only concerned with the offence under 447 of the Companies Act. Those other.
So far as the.
What are the offences? That's what we are asking. There may be other FIRs also, but as far as the present FIR.
So far as this FIR is with respect to the offences under the Companies Act, my lord, as well as IPC. My lord, they are, my lord.
Where is the FIR?
My lord, they have not enclosed the FIR, my lord.
There's a charge sheet filed, my lord.
They have not enclosed.
Charge sheet.
Yes, the charge sheet, my lord, your lordship will find.
Now, if your lordship will. 358. No, sorry, I'm sorry.
Sir, where's the charge sheet?
Lords, we have also filed our compliance affidavit, my lord, in a connected matter, wherein, my lord, the date of charge is fixed on, my lord.
No, the charge
23rd
sheet is not filed, because the charge sheet runs into 1 lakh, 1 lakh.
At least the front page of the charge sheet should have filed.
Sumlat, if your lordship sees the arrest memo,
All the documents.
in this case is at page 79.
Compliance under 207 has already been made, my lord. And the next date is 23rd June, when.
And if your lordship sees page 82,
Therefore, the court has fixed it in August. So that by the time the.
page
charges will
82,
be-
para 10, you have knowingly indulged, directed, involved and a party in the process and activity connected to the siphoning of funds borrowed from banks and projecting the siphoning of money as a legitimate business transaction. You have committed fraud as defined 447 of the Companies Act, punishable under the same section.
Other officers of the IPC. The application is vehemently opposed to a hurt receiving the learned counsel for the petitioner. And then the learned ASD for the respondent. The learned ASD vehemently opposes the application on the ground that the petitioner is involved in a scam which involves an amount of rupees thousands of crores.
10,000.
10,000 crores.
Gotcha.
Right. The perusal of material placed on record would reveal that there are 90 accused persons, and the prosecution, the list of witnesses given by the prosecution is about 125. Apart from that, voluminous document evidence would also have to be taken into consideration at the stage of the trial. Also, it can thus be seen that the trial is not likely to be concluded in the near future.
If your lordship permits me.
Mr. ASG, how many times you have been telling that don't, you have been requesting the bar so many times that don't interrupt when we are dictating the order.
I'm sorry.
Well, I completed 6 years, but
I'm sorry. I apologize.
every now and then I have to remind that for our Mofasil judges, it is very difficult to discipline the court here. At least those who are coming from Mofasil, at least from them we are expecting that they will practice some discipline. There is no discipline in mentioning somebody stands in this corner, mentions somebody stands in that corner, somebody rises from middle. In the near future, if trial get to commence, very good. This court, in cadena of cases, has held that the prolonged incarceration pending the trial should not be permitted to be a sentence without trial. Question. Paragraph. Insofar as the apprehension of the prosecution is concerned, the same can be taken care by imposing stringent conditions. Paragraph. The application is therefore allowed, the applicant is directed to be released on bail on such terms and conditions as being paid by the learned trial date. However, it is directed that an additional condition that the applicant shall deposit his passport
Already done.
with the trial court, and that we shall not leave India during the pendency of the trial or be imposed by the trial court. Needless to say that the applicant shall not make any attempt to influence the witnesses or tamper with the evidence. Yes,
Now, Lord,
Just one,
placing-
so
now,
sorry,
Lord,
just one thing, my lord, may note the passport was already deposited and it has expired. I don't have a valid passport today. It's deposited with ED.
It's not so deposited.
my lord, only one indulgence, my lord, that the next date is fixed on 23rd June, my lord, for framing of charges. My lord, we have all apprehension. The moment these people comes out, my lord, they influence because all the 90 accused persons are either they're part of their family or their own employees, my lord. So, my lord, they will try to scuttle, my lord, by some way or the other. So, my lordship may just put them to strict condition.
Let us said that the applicant shall cooperate with the expeditious disposal of the trial. Any attempt on the behalf of the applicant to protract the trial shall entail in cancellation of bail.
Grateful.
Please, my lord. My lords, I appear for the petitioner, accused number 7.
Yes.
All the other accused, other than me, my lords, who were hangers-on without any specific role attributed, have already been granted bail.
What are the...
My lords, accused number 1 and 2.
Conduct Millers, the witness number 4 who identified him in the PIP Millers was threatened. And there was an NC registered.
No.
My lords,
Whether the role of the present applicant and the other accused who are released on bail is same or not.
accused number 8, my lords, who my lords have granted bail.
Your application for grant of bail. The application is vehemently opposed by the learned counsel for the state. However, taking into consideration that the other co-accused against whom similar allegations have been made has already been granted bail by this court, we are inclined to allow the application.
Grateful.
Grateful.
Come here. You can come here. No, sir.
May it please your lordship. This was adjourned the other day, my lord.
Yes.
As rightly told by your lordship that I need to attack the judgment which was relied upon. My lord, what we had argued is this, that section 6 and 7 run contrary to section 22(3) of the UGC Act. That was our argument, if your lordship sees at page 98 and at page 100. 98, if your lordship sees, that was our argument before the High Court. Page 98. The High Court comes to a conclusion that it does not run contrary to each other. Now, my lord, I need to show your lordship what the High Court doesn't consider is section 22 subsection 3. Please have a look at section 22 subsection 3, my lord. It is at page 96. And that's what the UGC also files an affidavit and takes that stand, that we are empowered to allow the universities to issue degrees.
96?
96, my lord. Section 22, clause 1, I'll read first. The right of conferring of or granting degrees shall be exercised only by a university established or incorporated by or under Central Act, a Provincial Act, or a State Act, or an institution deemed to be a university under Section 3, or an institution specifically empowered by an Act of Parliament to confer or grant degree. Subsection 2 says, save as provided in subsection 1, no person or authority shall confer or grant or hold himself or itself out as entitled to confer or grant any degree. Now, subsection 3 is very important, which the High Court doesn't consider. For the purpose of this section, degree means any degree as may, with the previous approval of the central government, be specified in this behalf by the Commission by notification in the official gazette. Now, what we need to see is the notification which is issued by the UGC. That your lordship would find at page 72. And then I take your lordships to the affidavit filed by the UGC. Now, if your lordship sees at the top, in exercise of powers conferred, am I with your lordship? Yes. By subsection 3 of section 22 of the University Grants Commission Act, and in superstition of all earlier gazettes, so and so. Now, your lordship may please see from item, just below item 5. These are the degrees which all universities are entitled to issue. If your lordship sees agricultural and allied disciplines, then your lordship may see 6, 7, 8 and 9. BSc in agriculture, MSc in agriculture, BSc so and so. Now your lordship may please see the affidavit of UGC. at page number 183. And at page 184. Now, my lord, it refers to 2F of UGC Act, says that I am the university, page 184, para 5, if your lordship permits me to read. May I read, madam? Yes. That in the instant case, Bharati Vidyalay, Chandpuri Durg, of state legislature of Chhattisgarh as a state university, the university is empowered to award degrees through its main campus in regular mode with the approval of statutory bodies of the university and statutory council. So what it says is you are entitled to issue degrees in the campus, not out of the campus. Now please have a look at page 185. It refers to section 22 at page 185. And then at page para 7 on the same page, may I read, my lord, para 7, that in consonance to the power conferred in section 22(3) of the University Grants Commission Act, the answering respondent has issued a notification on specification of degrees of 2014, the notification which I just showed you to your lordship. It is notable here, the power to frame regulation so and so is traceable in entry 66 so and so. Now your lordship may please see para 8 also. Para 8 is important. In the middle, if your lordship sees, the petitioner university can impart agricultural education.
Issue notice.
I am so glad.
The regular bail application, Melons. 27 months is regular bail application. I'm in custody since 2 years, 6 months roughly. The offense alleged, my lords, is under the NDPS Act of Alprazolam, PCM and Tramadol.
My lords, I appear for the state in this matter. My lords, the commercial quantity is 250 grams. However, there was 6,700 grams which was seized with the petitioner, and that too at the petitioner's house, not even at the chemist shop, my lords, which he has a license. And my lords, he does not even have the bills.
He's having a license.
My lords, he does not even have the bills to prove such a huge quantity of the tramadol.
Cough syrup. The application is vehemently opposed by the learned counsel of the state. I would take into consideration facts and circumstances and the period of incarceration we are inclined to allow.
Great.
But I'm for the petition.
Please. Yes.
Lordship have already taken cognizance.
Back then also.
It's only one with permission of government. But on the earlier occasion when the matters were heard, your lordships were pleased to earmark 3 issues. And I have filed my affidavit, my lord, on these 3 issues. The written submissions filed by the petitioners, my lord, contain several other issues, my lord.
Yes.
Lord, my apologies. My lord, initially, my lord, when the matters were heard, there were 3 issues identified for the purpose of stay. Because prayer is praying stay of the statute. Lord, I have filed my affidavit mentioning specifically that in view of the discussion which took place, I am filing this reply for the 3 issues. But the written submissions have come, which deals with, my lord, many other provisions also. My request would be, my lord, that kindly confine it to the 3 issues as already identified.
Well, I'm sorry, Malad. This is entirely, I'm sorry to say, my great regard for my learned friend, Malad. Matter was listed earlier, then it came up. later saying, the judge saying that the Chief Justice said, I will hear the matter and see what further interim orders are to be passed.
No,
That's how the
all
matter
of
came
us
up.
were there.
I don't want,
All of us
we have made our submissions. We gave them in time to him. Those matters are already in the petition. My learned friend can't say that I will only argue on 3 issues. I'm going to argue on the issues that are, in fact, most important in the case, because this is a case of capture of the entire Waqf properties. That's what it is. But I'm going to argue on all the issues. My learned friend can't say. He can.
Well, Lordships cannot be asked to have a piecemeal hearing. The Lordships really cannot be asked to have a piecemeal hearing.
Hear on this.
Plenty of issues. 7, 8, 6, 7. That is my request.
Hearing only on the question of grant of interest.
Correct. That's also broadly, I tell your lordship that.
3 points I have said, my lord, contemporaneously in my affidavit in reply, para 4, that at the outset it is respectfully submitted.
Where is that order? Where is that order?
Only a minute, Mr. Sibal.
No, but you are saying there's an order of the court. The court said that.
This is not disputed. It is stated on affidavit.
His statement was
by an
limited.
officer who was present in the court, filing a prelim only to deal with the issues flagged during the earlier hearing on 16th April 25.
We were there, Madam.
This is contemporaneously filed, contemporaneously reported everywhere. I leave it to your lordship. I wanted to flag this. This may not be fair to the court, and fair to the.
Neither of us is party to those. We are not aware of what happened.
There was no truncation of issues.
There is none, Malad. In fact, the order said we clarify. We clarify that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed. This is nothing to do with the issues.
The first order. The first order which Mr. Sibal is reading, 17th April.
Yes.
25.
Yes.
Yes, I'm reading that.
Please do.
Lord, please see. Your lordship, say, Lord, I'll, Lord, please.
Let him say what he has to say.
Lord, can I read, my lord? I'll just read, my lord, and leave it at that, my lord. This can't be not that we don't have answer to other questions, but this would be unfair to the court and unfair to the other side. During the course of the hearing, Mr. So-and-so, that is myself, stated that respondent would like to file a response within a period of 7 days from today. He assures this court that till the next date of hearing, no appointments would be made to the Central Waqf Council and Waqf boards. That was the first issue flagged, Section 9 and Section 14 respectively. Then I'm skipping because that's Section 19, 14, etc. is mentioned. It is also stated that till the next date of hearing, no Waqf, including a Waqf by user, whether declared by way of notification or by way of registration, shall be denotified. This is pertaining to Section 3R, where we have deleted the Waqf by user prospectively from hereafter. We take these statements on record, rejoinder to be filed. Thereafter, my lord, the court directs that 5 will be the lead petitions. And it was 7 days because, my lord, it was 3 issues, my lord. And thereafter, my lord, the court at the end said, we clarified that the hearing fixed on the next date will be a preliminary hearing, and if required, interim orders will be passed.
That's all.
Lord, this is what, my lord, all of us were present.
So were we.
The court had flagged these issues, but my lord, I don't wish to embarrass the bench. It would be unfair, my lord. That's all I'm saying.
Can we go into that? Because if you are saying, all of us are saying that it was decided, they will deny it, and we can't go now.
The denial would be unfortunate, but
Well, in fact, the statement is unfortunate, not the denial.
And we can't go and ask or other senators.
My lord, I don't wish, my lord, your lordship.
We will have to go by whatever is the record.
Yes, my lord, but I have said on affidavit that since these 3 issues were flagged, my reply is confined to 3 issues.
My lords, what happened was in the
And there is no denial in
my
the
learned
rejoinder.
friend will realize what happened was the court came and the court said, look, give me an answer on these 3. The court did not say, and that's why the court later said, you please argue the whole matter, and that's why it was fixed for interim orders.
Afternoon
That
hearing
was an
was
afternoon.
proved.
What is we-
It is not that there were truncation of issues like this. This was done. It was then for continuation, in fact, for extending the order on other points. Either way. Not any limitation.
Anyway, as it is, we have paucity of time. Let's go on with the matter.
Plus today the written submission is as virtually reading, arguing the entire writ petition itself. Yes. With all due respect. When the reply is confined only to 3 issues, plus to their written submission.
You have given them 2 hours. They have to decide as to how they will.
That's why we want to start and just finish, Mullah, in 2
But
hours.
I just flagged it and leave it at that.
We can't go into that inquiry.
I understand.
We can't ask the running judges.
It's unfortunate, but I leave it at that.
Normally we go by whatever is there in the black and white in the order sheet.
Yes, Manoj, we sometimes trust, Manoj, the other side will not
Come
take
on,
us.
no,
that's an unfortunate statement to make.
I don't know why.
That's an
Let's,
anyway.
Mr. Mehta,
I leave it to Manoj, let them argue.
I'm feeling happy that I have only 6 more months left here.
We are not happy, Manoj.
So by experience of 18 years in the High Court, compared to the 6 years here, that's been much better.
Malord, that I can also say, Malord, for High Court, Malord, because I have also come from High Court, so is my learned friend.
But those practices are not being followed here, Malord, despite the fact that people come from the High Court.
Yes, Malord. So we learn wrong things, Malord, from our seniors.
That's a problem. Yes. Anyway, Malord, I think.
Then let's proceed, yes.
Let's proceed. No, Malord, kindly just leave your paper book for the moment. I'll tell your lordships what the contours of my submission are, Malord. Malord, this is a case in which the 2025 Act has been framed, Malords, for the purposes of protection of Waqfs. But in reality, it is designed to capture Waqfs through a process which is non-judicial, through a process which is executive, through a process in which those to whom this property belongs, because Waqf can't be created without except through private properties owned by the individual concerned. So private properties are being taken away only because there is some dispute. We don't know what the nature of the dispute is. And when that dispute happens, Malords, a person is appointed who is higher than the collector, and that person will decide the dispute on his own. He will give a report, but by the time, Malords, that report is given, we don't have the time frame. And within that, Malords, while that report is pending, the Waqf property is taken away. And
taken away without following due procedure?
Yes, and without following any procedure. I'll demonstrate all that to your lordships. Taken away with, and Malords, the dispute is whether this is government property or my property. He will decide that. He is a nominee of the government, Malords, who is higher than the collector. So the government decides its own dispute without any judicial procedure. And while that dispute is pending, while that report is pending, the property is taken away. It is no longer Waqf property. And there is no procedure. And anybody can create a dispute. So this is one aspect of the matter, which is in the context of what I say, it was designed to take over and capture Waqf properties. That's number one. Number two, Malords, what is a Waqf? A Waqf, Malords, is a endowment to Allah, to God. A dedication to Allah, to God. And that, pursuant to that dedication, that property can't be dealt with in terms of transfer. You can't transfer that property to anybody. Once a Waqf is always a Waqf. That's the very concept of a Waqf, Malords. In other words, if I have, Malords, in fact, dedicated my piece of property, because I cannot dedicate somebody else's piece of property. And the historical reason behind it, let me just tell your lordships that, is that, as your lordships know, under our constitution, Malords, the state cannot possibly finance religious institutions. Cannot finance, Malords. If there's a mosque, Malords, the state cannot finance it for its upkeep. If, Malords, there is a burial ground, this has to be created through private property. So what happens is, Malords, that people at the end of their lives, Malords, give their private property dedicated to God, so that those who come later, Malords, can take advantage of that property. There are no earnings there, Malords. If you go to a burial ground, Malords, nobody earns. People come to bury their dead bodies, Malords, and they charge a certain amount through which they maintain that. If you go to a mosque, Malords, there's not a chadhava, Malords, like in temples. They don't have 1,000 crores, 2,000 crores, 3,000 crores, Malords. There are no chadhavas in mosques. So those have to be maintained. And how are they going to be maintained? Through the kind of monies that we collect through processes, Malaj, of charity. That's all.
That happens in other religions also. When temples are...
No, but temples, Malaj, people give, as your lordship knows, Malaj, there are charavas that are given, Malaj, and temples are, in terms of Malaj,
but even in the...
mosque?
I visit dargahs also, I visit churches also, everybody...
Dargahs and mosques dargahs and mosques are different. Dargahs and mosques are I'm talking about a mosque, Malaj. Your lordship is right. On dargah, it's different. But I'm talking about mosques. So what I was trying to say was, Malaj, the ways to preserve these properties is through these kind of efforts that are made by the community. Right? Now, Malaj, what they say is that if anybody, supposing an encroacher creates a dispute, that property will lose its character as Waqf property as long as the dispute is pending. This is what the Act says. So you have a situation, Malaj, where actually there was a Waqf Act. You just note this, Malaj. There was a Waqf Act of 2013. 2013. 19, huh? Will you allow me? 2013, then, 1913, 1923, 1913, 1923.
What's in 1923?
1913, 1913, then 1923, then 1913.
1913, 1913.
1913, then 1923, then 1954, then 1984, then 1995, then 2013 and 2025. This is, Malaj, the history of it. Yes.
Just factually, 84 and 2013 are amendments, not the...
No, I'm talking about the Act.
Yes.
Correct? So, Malaj, therefore, and I will demonstrate to your lordships that the 2025 Act is a complete departure from the past. I tell your lordships how. There are two concepts in law called Waqf by user and a dedication which is made. Right. If you give a dedication, Malaj, and you pass away, and that property is used, Malaj, for the purposes of the dedication, it becomes a Waqf by user. And it's perpetuity. That's the concept of Waqf. Once a Waqf, always a Waqf. Correct, Malaj? Now that Waqf by user has been done away. A concept that is recognized in the Babri Masjid case, saying Waqf by user is a practice, a religious practice, that has continued for hundreds of years. That's the 5-judge bench, Malaj. And whether it's a Waqf by user or not is a matter of evidence. But they've done away with it. How have they done away with it? They say that in the 1913 Act, the 1923 Act, the 1954 Act, and the later Acts, there was a requirement for registration. And because you did not register, Malaj, therefore, any Waqf which is not registered will not be regarded as Waqf. So many of these Waqfs by users were created 100 years ago, 50 years ago, 200 years ago, Malaj, 500 years ago. Where will you get them?
Is it a matter of fact that under those enactments, 1913, 1923 and so on, is there a requirement for registration?
There was.
So is it a mandatory or?
They shall be registered, they said. But unless the consequences of non-registration were not set up in the Act. The consequences of non-registration, this is the first time in the 2025.
I have not gone through anything because I had...
That's why, Manoj, I'm broadly telling your lordships what my submissions are going to be.
I have not gone through... I'll be frank, so you'll have to start from ABCD.
Yes.
Just as a matter of information, as whether under the old Act,
yes,
the provision was for registration was mandatory or directly?
The expression used was shall.
Merely using shall may not make it mandatory.
Correct.
Were there any consequences provided in those acts for non-registration? If consequences are provided, then it will be mandatory. Whether word shall is used or not.
No, Manoj, the consequences were not that it will not be regarded as a Waqf. That was never the consequence.
Was there anything that on account of registration of a particular?
You won't be regarded as, no,
something will happen.
no, there's no consequence that you will not be regarded as a Waqf. It will continue as a Waqf.
But there were consequences.
No, not this consequence.
But there
For
were other
the caretaker, there may be consequences, but not
please,
this.
we'll record your submission.
Yes, please.
That though under the old act, there were requirements for registration, but they were not mandatory because the consequences for non-registration were not provided under the act.
For the purposes of deciding.
On account of non-registration,
Yes.
nothing was to be happen.
Yes.
Like suppose if there is under certain act, mandatory duty is there. You have to do such and such thing within a particular period.
Correct.
And if you don't do that, then you will be required to pay 1,000 rupees fine or 1 lakh rupees fine. So no such provision is there.
No, no. The only thing was, Malas, that the act said that the Mutawalli who has not done it is made culpable. That's all. He loses his right to continue as a Mutawalli.
That's all.
That's all. That I said to your Lordship, and I stand by that. There were no consequences provided that it will no longer be regarded as Waqf.
No,
which is
no other consequences were there.
No other consequences. Which is why the 2025 takes that away.
So
therefore, it's a complete departure.
So do we record that?
Yes, your Lordship may record it. It's a complete departure from the
1913, 1913. Till order, the last one, 1913 till 2013.
Till 2013. The status of the Waqf.
2013.
Yeah.
Though
the status and character of the Waqf.
No, though there was a provision.
Yes.
For registration of.
Yes.
A Waqf.
Yes.
No consequences were provided.
Right.
Were provided for non-compliance.
Right.
Except removal of a Mutawalli.
Correct, because he is responsible for registration of the Waqf.
So there, except removal of a Mutawalli.
Yes. Consequences qua the Mutawalli.
Not a trust, not a Waqf.
Correct. Well, that's for the community, Malat. So because he did not register, he will suffer the consequences, but the character of the Waqf will not change and cannot. This changes it. I'm just giving you Lordship broadly. This changes the character of the Waqf. It says if you're not registered under these acts, then you're no longer Waqf. That's number one. Number two, if you are a Waqf by user, you must tell us as to who is the one who established the Waqf. Well, how do we know? If it is established 200 years ago, how will anybody tell you today who established it? Because there was no registration at that point in time. They were user. That is why Waqf by user is a matter of evidence held by the Constitution bench of this court.
1913 to 2013.
Yes. Well, that's 23 was the first one actually.
Whether during 1913 to 2013, registration was not necessary insofar as Waqf by user is concerned.
Yes. They have now removed it completely.
Was it permissible under the?
Yes. Throughout, Manoj. Otherwise, I wouldn't be making this submission. Waqf by user, this is established practice recognized by the Constitution bench of this court.
Second submission is that prior to 2025, Waqf by user was not required to be registered.
What happened was, Manoj, in 1954, for the first time, there was a requirement of registration as such. Otherwise, 23. Yes. मैं कह रहा हूँ यार तुम बता रहे हो गलत बोल रहे हो
2020.
Your Lordship may say prior to 1923 or prior to after 1954, Manoj, what happened was when the British were here, they didn't want to interfere in the practices, religious practices. control provisions or management provisions, Malaj, in those acts. But in 1954, it became mandatory that you must register. Now, who was to register? The Muttawalli. The Muttawalli was not
Prior to 1954,
Yes.
the registration of work by user was not necessary.
No, nobody was questioning Waqf by user ever. Till date, Malaj. Nobody is questioning, except this act. Except the 2025 Act.
Probably you have not understood the question. What we are only asking you, was it mandatory or required to be registered as a Waqf under the acts prevalent at that relevant time as a Waqf?
After
Maybe by
1954,
Waqf
yes.
by user.
After 1954, yes.
Yes. So
Yes.
after 1954,
Yes.
the registration was mandated.
Mandatory.
And it had
Even insofar as work by user is concerned.
Yes. Even by Waqf by user. All works had to be registered. Muttawalli had to register them. If he did not register them, then consequences followed way here. But the Waqf property did not lose its character as Waqf. That's the point.
So according to you, prior to 1954,
yes,
registration of work by user was not necessary, and it became necessary after 1954. Was not necessary.
2025.
I'm saying that, but these fellows are either saying 23 or...
Only after 1954 it became necessary.
Yes.
Only after 1954 it...
Malaj, there is some confusion on this, maybe after 1923. Your Lordship may write 1923 because...
Okay.
Yeah.
We'll write...
Say 1923, Malaj, not 1954.
We are recording everything so that we can call upon them to answer all.
1923 because I've read the act myself. That's why I was saying 1923. 23, Malaj.
Problem is that so much of pressure.
Yes.
Not only builds pressure on us, but also on you.
Yeah, exactly, Malaj. I got different discordant voices here.
23. So therefore we are...
Yes, just I show you that the 23 Act says within 6 months from the commencement.
First we'll record your proposition.
Yes.
So that...
Yes, so that we know, Malaj, what...
Friends, not to disturb Mr. Sibal, Malaj. He's continuously being disturbed from all...
That's all right, don't worry, I'll take care of it.
Yes, sir. You must...
He is trying his best. We can see it in a better manner.
Yes, may not disturb.
We can see it in a better manner. Yes, right, at least half a dozen times.
So therefore, that's the proposition. Let's make it 23, not 54.
After 23, it was necessary.
Yes, necessary. But no consequences square the dedication.
So that we already recorded.
Yes. So, Malaj, that's the second proposition. You take away Waqf by user. Third proposition is, Malaj, just note two dates, 1904 and 1958. These acts relate to Ancient Monuments and Archaeological Sites and Remains Act of 1958. And there is the 1904 Act, which is also here, which is the Ancient Monuments Preservation Act of 1904.
Ancient Monument
Preservation Act 1904. So two acts, 1904 and 1958, both dealing with ancient monuments.
Both 1904 as well as 58.
And 1958. So, Malaj, when this 1904 Act came, Malaj, as your Lordship knows, Waqfs were there. The
Waqfs were from centuries, you are saying that there.
Waqfs have been there, Malaj. So, what the Act did not interfere. For example, Malaj, you have, say, the Jama Masjid or any other places of worship. It's a Waqf, but it's getting dilapidated. Right? So the government can say, we want to preserve this property. We want to make sure it doesn't get dilapidated, Malaj. And therefore, they give a notification saying that for the purposes of preserving the property, it is declared as an ancient monument. Right, Malaj? But it doesn't lose its character. It doesn't mean that you can't go and pray there.
So, though it is preserved as an ancient monument, but
no ownership was transferred to the government. And it doesn't, you couldn't stop the user of the Waqf property for the purposes of the dedication. You couldn't change the identity either.
Like like in Khajuraho.
Correct.
There is an
Exactly.
ancient temple.
Correct.
Where, though it is in the custody of the
Exactly.
archaeology department,
Correct.
being a heritage structure, still the people can go and pray.
Exactly. Exactly. So, Malas, now the 2025 Act says, moment it's declared or it has been declared as an ancient monument is no longer a Waqf. That's why I said it's a complete taking over of Waqf properties of a community. Complete takeover, including ownership. Before or after?
No, but does it take away your right to practice your religious practices?
Yes. I will demonstrate to the declaration itself is void.
Are you stopped from going and praying there?
Yes. Declaration of the Waqf is void. It's not about whether I can, it is void.
Should we record that?
Yes, that's the third proposition.
Fourth. Sorry, third.
Yes.
On such declaration.
Yes.
On or
before.
On such declaration as an ancient monument.
Yes. As a protected monument. Or protected area.
Mr. Singh, we would appreciate if there is only one voice from one side. It has been difficult for me to
area under the ancient...
last 6 years too. But then...
No, it says Ancient Monuments Preservation Act 1904.
So on such monuments as a protected monument.
Yes. Or protected area.
Protected area.
Under the Ancient Monuments Preservation Act and Ancient Monuments and Archaeological Sites Act of 1958, at the time of such declaration...
Under the State Act?
Yes. And Waqf property shall be void.
No, but does it also take away your right to go and practice?
Once the Waqf is void, Mullah, I can't go there. The Waqf itself it becomes void. That's what the section says. Any declaration or notification issued under this act or under any previous act in respect of Waqf property shall be void if such property is as a protected monument or protected area. So once it is void, Mullah, how can I possibly go and...
Like, Khajuraho, I know because I had visited recently. It's all now under the custody of archaeology department because all those structures are heritage structures. But still there is a temple wherein all devotees can go and pray.
Yes.
So therefore, I'm asking whether this declaration would also take away your right of going there and praying, offering prayers and all that.
Well, the problem is...
Maybe because it will be declared cease to be work because the maintenance and everything of a heritage structure is on a different yardsticks.
But if the Waqf is void itself, that means it's no longer a Waqf. And it's not my right anymore, Malaj. When you say Waqf is void, it's no longer a Waqf.
No, but is it your also... Is it your also condition that on such declaration, all religious practices which were being undertaken earlier would also not be permitted?
Malaj, it's my case that this provision is violative of 25, Article 25 of the Constitution.
Should we record that?
Yes, please. It's expropriatory.
What will be void?
Yes.
And the right of the citizens to continue with their religious practices.
That's correct. Article 25 and 26.
Their religious practices. Will be taken away.
Therefore, it is expropriatory.
Mr. Mehta, you can ask someone to record all this.
But I am recording it. It's factually incorrect in my...
We are not asking you. We are not asking
I am recording.
You argue when your turn comes.
Yes. I'll argue when my turn comes. I am recording.
We are only asking because since we are recording, we will be calling upon you to answer this thing.
Obviously, I have to answer.
The rights of the citizens to continue with their religious practices will be stopped and therefore violative of 25 and 26. So what we are recording on such declaration under the Ancient Monument Preservation Act as a protected area. The
monument or area.
The work will be void.
Yes.
And the right of the citizens to continue with their religious practices will be jeopardized and therefore violative of Article 25.
25, 26 and 14, Malat, because how do you declare something to be void, because the perpetuity of the dedication is lost.
Article 14, 25 and 26.
Yes, I'm good.
Yes.
Because only Muslims are there.
Yes, sir, I know. Only Muslims, of course.
So
Don't want.
you should have invited all of them for dinner yesterday and so that that would have been better. Now everybody is advising you here.
I forgot.
Well, that's the other important thing that your lordships will know. This is a corollary to this proposition, is that under the Ancient Monuments Act and these two acts, my right to religious worship was preserved.
So that,
despite its declaration, under the acts themselves, it was preserved.
And now it has been taken away.
And now it is taken away.
Under the said act.
No, it was preserved.
Right to religious practices preserved.
Yes.
Yes.
Right. I mean, it says that a protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. It was preserved, taken away.
16.
That's 3D, Malaj. 1 second.
Section 3D.
This is the present 2025 section is 3D. D, capital D. Next proposition, Malaj. That I have to be a practicing Muslim for 5 years before I can create a waqf. So, Malaj, at 77,
one has to be a practicing
Muslim for 5 years before I can create a waqf. So, who will decide that? I guess they will come home and ask me.
Section
3R.
3R.
Yes.
R capital or
small R, Malaj. So, Malaj, I have to ask whom? And if I am on my deathbed, I'll have to say, and I want to create a waqf and dedicate it to God, then I'll have to demonstrate to them that I'm a practicing Muslim. I mean, it's per se unconstitutional, per se. It's my right under 25. It's my right under 26. And you take that away through a definition of this nature. Then, Malaj, you have scheduled tribes in tribal areas, Malaj, where Muslims are scheduled tribes.
Yes.
Correct? They say in those areas, these properties will be declared not to be waqf properties. That's 3 capital E. No land belonging to members of the scheduled tribes under the provisions of the 5th schedule or 6th schedule shall be declared or deemed to be waqf properties. On what
old
basis?
ones also go, according to you?
Yes. Everything goes.
Assuming there is one waqf and registered, that also is.
Yes, absolutely. Shall be declared or deemed to be waqf property. I'll come to that. No, this is just the proposition. Right? So therefore, 3E is per se unconstitutional.
3E.
Yes.
What is your proposition so that we can record it?
3E, Malaj, sets out, states that...
Tell us your proposition.
The proposition is that if a scheduled tribe, Malaj, who are Muslims, they have waqf property and they are practicing, Malaj, or willing to create waqf, then that waqf is deemed to be, not deemed to be waqf property at all. So therefore, that's also expropriation on the face of it. And their right under 25 is taken away.
Will be deemed not to be
waqf property. And cannot be declared as waqf property. And we've given a schedule of all the of the tribes, Mullahs. of Muslim population. We've given a list. We'll give
This is according to you, by virtue of this, all works created earlier
Yes.
of
Even,
properties
yes,
come to SP and SP will also be.
Everything goes.
Muslims, that is his case.
I'm not saying, I said scheduled tribes. Did I say anything else? I said scheduled tribes.
Yes.
That's what the section says. According to us, per se unconstitutional.
The 5th and 6th schedule area.
Then, Malads, the next one is the right of management of Waqf properties has been taken away. Because the Central Waqf Council members of the Central Waqf Council, majority of the members of the Central Waqf Council are non-Muslims, maybe non-Muslims.
Because majority of
the members of the Waqf Council may be non-Muslims. 12A.
Of the
There is section 9, Malads, related to, yes, Central Waqf Council.
Would be non-Muslim.
Majority can be non-Muslims.
Can be or would be?
It can be, Malads. That means they will have a majority if they choose to nominate Malads.
Can be non-Muslims.
Yes. And on the calculation, it is 12 non-Muslims and 8 Muslims. Not sorry? And 10. Sorry, 12 and 10, not 8.
12
and
non-Muslims.
12 non-Muslims, 10 Muslims. And nominated. And then section 14 also, Malads, relates to...
This is section?
14 relates to the composition of the board.
But this council is...
This is 9. This is section 9. 14 is for the board.
And 23 for the CEO.
Composition of the board. Earlier, Malads, the board members were elected under the previous act. And they were all Muslims. And now, Malads, it's fully...
Elected by whom?
And now it's elected by the various organizations through which they came. I'll just show to your lordships that. Electoral colleges, Malads, of Muslims. They elected members, they were all Muslims. Now they're all nominated.
In the boards.
Yes, on the board, all nominated.
Even in this Central Waqf Council also.
Yes. Those were also nominated under the previous acts. But they were Muslims. There the majority was 12 to 10, as I told your lordships. Here they are all nominated.
In the board.
Yes, all nominated. And it will be 7 to 11. 7 will be maximum, will be non-Muslims. 11 will be non-Muslims.
11
It will be total.
7 can be.
11 total, 7 can be non-Muslims. But all nominated. So the electoral college process has been done away. So they were, in a way, they conceptually capture the waqfs. They expropriate the property.
Out of 11, 7
can be non-Muslims.
Can be.
Yes. And all nominated. So, Mullah, that itself is violative of 25 and 26. Your Lordship knows management has to be done by the community.
Well, also the CEO.
Yes.
CEO.
Yes. And then section 23, the CEO is to be appointed by the state government.
CEO of the?
CEO of the board shall be appointed by the state government who actually runs the board. And he'll also be a non-Muslim. Earlier Muslim, now non-Muslim. So the government will, in fact...
It's not mentioned non-Muslim. I think it should...
No, it just says nominee of the state government.
That's right. Only nominee.
Yes.
Can even be a Muslim. That's for them.
Earlier it said Muslim, has to be Muslim.
They were specifically...
Yes, that's why I'm saying, Manas. It's an absolute departure. Original said there shall be a full-time executive officer who shall be a Muslim. Therefore, Manas, all I'm giving your lordships is that this has nothing to do with all the legislations that happened earlier. This is an absolute departure and an attempt to take over through creeping acquisition Waqf properties.
And section?
This is 23.
23, my lords.
23.
23. So broadly, my lords, broadly, these are the issues. Right? That out for the moment. There are other issues, my lords, but what is this?
Today we have
only
for the interim relief.
That's right, that's right. Now, my lords, now
the presumption is with regard to the constitutionality.
That's correct.
And normally the court should not
correct.
pay the...
Correct, absolutely.
So unless you make out a very, very
strong case.
Hearing case.
Yes, correct. And your lordships have done it in the past, so I won't go into that at the moment. Now, let's kindly have a look at the act. Now, I'll demonstrate each
We are
one.
not saying we are powerless, but then the case which has to be weighed out.
Absolutely, absolutely. Which is why I'm trying, which is why I'm trying.
Otherwise, the presumption is with regard to constitutionality of a statute.
But what?
That's the law which we have been taught from the colleges.
The problem is you have to decide it on the basis.
And in the light of the present.
Not say anything more.
I won't say anything more.
Well, therefore, we have to make a prima facie case, which is what I'm trying to do. We have to demonstrate to your lordship the balance of convenience in our favor, and irreparable injury will be done if these provisions are activated. That's what we have to demonstrate. So if I can't create a waqf, unless I demonstrate 5 years of being a Muslim, and if that is operated, it's an immediate injury, it cannot be. It's irreparable. If a government officer above the rank of a collector is to decide a dispute between the government and the waqf without reference to any judicial procedure, it is irreversible. The question may come from anywhere.
So there's a finality to the decision of that officer.
Yes. No time period, finality. Let me just now.
Finality to the decision of the collector.
Well, what happens is, under section 3C, if there is a dispute to a government property or a property of a government organization, supposing the district collector or the government feels that this is our property, let's assume, then an officer is designated above the rank of a collector, right, Mullah? He will then give a report. The time frame for that report is not set out. While he is contemplating to give a report, the nature of that property as waqf is done away with.
So even before that report is
there? Even that report is fine.
Shall not be treated as
It shall not be treated as waqf. So this is irreparable.
So this is under section
3C. 3 capital C. Proviso.
Under section
3 capital C proviso.
The
Capital C.
What is called designated officer?
Yes, designated officer above the rank of a collector. It says that he'll conduct an inquiry, quote, unquote, as per law, no law, whether this is government property or not, and that property shall not be treated as waqf property till the designated officer submits a report. So therefore, before the inquiry...
So, designated officer, when he conducts an inquiry,
yes.
So during pendency of inquiry, that property can be taken away.
It is no longer waqf property. It can't be treated as waqf.
The moment the inquiry is initiated.
Yes, it can't be treated as waqf.
For all intents and purposes,
yes.
it ceases to be a...
Ceases to be a waqf.
Without any declaration.
Without even an inquiry, because he is yet to have the inquiry. He is yet to conduct an inquiry. And there's no adjudicatory process there.
Waqf property.
Yes. There's no adjudicatory.
So without even somebody raises a dispute.
anybody.
Yeah, anybody can raise a dispute.
We know that we know your enthusiasm. Give him benefit of his experience of more than 50, 60 years at the bar. You can be comfortable if some chair is available, otherwise you'll ask them to provide.
Just take seat.
Sit down.
During pendency of the inquiry, it will cease to be a work.
Yes.
And everybody would be stopped from continuing their practice.
Absolutely.
or whether they are also entitled to take away the possession during the pendency of the inquiry.
Nobody says no longer a waqf, that's the end of the matter. It's not be treated as a waqf. So how do I exercise my rights under 25, 26?
So the citizens cannot exercise their rights of religious practice.
That's not going to do. Now, once he submits a report, now the procedure in law is not prescribed under 3C as to what inquiry is to be conducted. He doesn't have to go to a tribunal. He doesn't have to go to...
There's a finality to his decision.
There's a finality. Once he submits the report, the revenue records will be amended accordingly for him. And the board will be given a direction that you also correct your records that this is no longer waqf property. That's the consequence. I will. I'm just hold on.
Revenue record and board records will be required to be...
Yes, will be required to be amended. And this is without any judicial process at all. Now, what's more interesting, and this connects to Mullad's a very important argument, that under 83 of the 2025 Act,
under
Section 83 of the 2025 Act deals with constitution of tribunals.
Section
83.
83.
Yes. Now, what happens is that once under 3C, it is no longer a waqf, then I become the aggrieved party. Only I can go to the tribunal. Government is not required to go to the tribunal to find out whether it's waqf or not. So through an executive process, you decide on what the nature of that property is. You don't go to a judicial process, and then you force the waqif or the person aggrieved to go to the tribunal and say that, no, this decision of the collector was wrong. Now that will take 5 years, 10 years, 15 years, and even if it comes in my favor, the nature of the property is gone. The most egregious provision, well, it's inconsistent with 14.
Is required to go to the tribunal.
Yes. He doesn't have to go. So now, Manas, let me just read the provisions to support the...
During the proceeding under Section 83,
yes,
the status of the property is already changed. That is it taken away by the government?
Correct. And I have to go to the tribunal to demonstrate.
Status of the property is changed.
Under 3C, it's already changed.
Okay. And the Waqif also loses possession.
Yes. Then whoever aggrieved, whichever is the aggrieved party.
The Waqif will also lose possession of the property.
Naturally. Yes. Because before the inquiry starts, it's no longer waqf. Now, let's kindly have a look at the definition of waqf in 3R. Just take the act now, let's. The amended.
R.
Let's.
So now, as compared to Learned Solicitor's 3 propositions, they become 10 now.
But he'll have 11 solutions for that. Never three mothers, but anyway, be that as it may. So may I just read the definition with their lordship's permission? Waqf means the permanent dedication by any person showing or demonstrating that he is practicing Islam for the last 5 years. Lordship has that? Page 7 of this book. Lordship sees that? Lordship has that? May I read it? It says, Waqf means the permanent dedication of any person showing or demonstrating that he is practicing Islam for the last at least 5 years, of any movable or immovable property, having ownership of such property, and that there is no contrivance involved in the dedication of such property for any purpose recognized by the Muslim law as pious, religious, or charitable. So I don't know what this means. I have to demonstrate that there is no contrivance involved in the dedication of the property. So that's, according to me, Mullahs, on the face of it, unconstitutional. Why should I have to show them that I'm a practicing Muslim? And to whom am I to show that? And what inquiry is to take place? Who is going to decide that matter? In what manner will they decide that I'm not a practicing Muslim or I'm a practicing Muslim? And why should I have to wait for 5 years? On the face of it, Mullahs, it's violative of 14. And it's directly violative of 25 and 26. Leave it there. It's time. Show them later. Yes. Now, Mullahs, kindly see, immediately after this, over the page, you small I, your lordship sees. Mullahs, just sees small I on the top of page 8 of this book.
Yes, I is deleted.
It's deleted, Mullahs, your lordship sees that? Kindly go to the footnote. Kindly go. What was it in the earlier act, Mullahs? Prior to omission, stood as under a waqf by user, but such waqf shall not cease to be a waqf by reason only of the user having ceased irrespective of the period of such cessor. Removed. Waqf by user removed. That's why I've been saying it's capturing waqf property throughout the country. Creeping acquisition of waqf properties throughout the country. Through executive fiat.
Not all. It is only limited to one category. You may say so.
No, I'll show the others also.
That's a different
Yes.
thing. But as of now, it is with regard
yes,
to one category.
only one category.
Whatever you are saying would be relevant as far as the
Yes,
one category.
fair enough, fair enough, fair enough, fair enough.
A work by user, but such work shall not cease to be work by reason only of the user having ceased irrespective of
period of such.
So, in addition to this, there are other grounds.
Yes, I'm going to show.
Even under the earlier act,
Yes.
it could cease to be a work. Only by reason of non-user it could not.
No, it never ceased to be a waqf by user. Never. Because it's a dedication to God, Mullah. There's no question of it ever ceasing. Because somebody else will use that property. But it can't be transferred. Kindly, Mullah, this is the whole difference between waqf as a concept, Mullah, and trust as a concept. Waqf is a dedication to God. And therefore the community will use it in whatever manner. If you have a place, a small place where people come and rest, a little small rest house, Mullahs. Now, if the person ceases to exist,
Musafir Khana.
Yeah, Musafir Khana. That's a waqf. No, it can't cease to be that. This was the provision that protected it. They took it away. Now come to the proviso. Provided that the existing waqf by user properties registered on or before the commencement of this act. So now, Mullahs, you are now ensuring that only waqf by user which are registered are the ones that will remain. Page 8 middle. provided that the existing Waqf by user property is registered on or before the commencement of the Waqf Amendment Act as Waqf by user, will remain as Waqf properties except that the property wholly or in part is in dispute or is a government property. So, Malas, if any third person raises a dispute, for example, Malas, an encroacher raises a dispute, it will not be Waqf property.
Last one, after they're abolished.
Can you see, Malas? And Malas, government property means what? Government property is defined. Now see, Malas, that definition in section 3, small fa and fb, page 6 of the statute. Kindly read 3FB first. Government property, page 6. Government property means movable or immovable property or any part thereof belonging to a government organization. Right, Malas? Then government organization is defined in 3FA, just above this. A government organization includes the central government, state governments, municipalities, panchayats, attached and subordinate offices, autonomous bodies of the central government, state government, any organization or institution owned and controlled by the central government or state government. So, Maharaj, in fact, every organization is covered under this act. A panchayat is covered. So, if a panchayat raises a dispute, that's the end of the Waqf. I just read that proviso to your lordships. Any dispute, local panchayat, municipality.
But will it automatically cease to be a Waqf property?
It is. I'll show you 3C, Maharaj. That hones into 3C, capital C. Now just read 3C with me after having seen this. Then I'll come back to Maharaj, section 3B.
So we'll
Just come to 3C after this.
So according to you, in view of proviso, to 3R,
yes,
if any dispute is raised, the same work property will cease to be work property.
Yes. And it's Maharaj, any local authority or any dispute raised by anybody. Yeah, even a company controlled, Maharaj. So now kindly see. And Maharaj, in 3R you have is in dispute or is government property. So it may not, dispute may not relate to government property at all.
Maybe between
It's a private person.
two individuals. So
Exactly. Then also it ceases to be Waqf. By virtue of the statute, Maharaj.
At Aurangabad, there are so many disputes with regard to work property.
Correct. It's in our DNA, Maharaj. Yeah. And it says wholly or in part. Well, let's just see Maharaj the submission. Waqf by user abolished. 3R deals with registered Waqf by user. Registered Waqf by user, if there is a dispute, Waqf goes. That dispute may be with a private party or with the government. If it is government, the designated offerer will decide under 3C. He starts an inquiry. Before the inquiry is no longer Waqf. So in effect, you are expropriating all the Waqf property.
What about a dispute within a private property?
That also no longer Waqf. What are you trying to do? Any private party will raise a dispute. We see that happening every day, Malas. So any private party will raise a dispute, it will no longer be above. What are you trying to do? You are actually throttling.
So is it relatable to any particular nature of dispute?
No, no.
Simple dispute.
Simple. It doesn't define.
Doing a lessee.
Relate to that property only.
Whatever.
Relate to that property only. That's correct.
That would also include.
Yes.
That may not be. It would relatable to the.
But it's not Malas, clarified. Your Lordship is right, but it's not clarified, Malas. Malas.
Answer, you are saying that he has 11 answers, so maybe it's 12. So.
Now, Malas, kindly read 3C, Malas. Capital C. That's at page 9. It says any government property, now government property now defined as government organization and all local bodies. They're all government property. All companies identified or declared as Waqf property before or after the commencement of act shall not be deemed to be Waqf property. If any question arises as to whether any such property is a government property, the state government may by notification designate an officer above the rank of collector, as I mentioned to your lordships, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law. Now, which is that law, Malas? Doesn't go to the tribunal, because only the aggrieved party will go to the tribunal under 83. We don't know what this law is. There is no procedure set out. And determine whether such property is government property or not, and submit his report to the state government. So he's a government officer. Dispute is between government and the Waqf. He will decide the dispute without any procedure. He'll be a judge in his own cause, and proviso, provided that such property shall not be treated as Waqf property till designated officer submits his report. Which is what I was indicating to your lordships at the outset, as a proposition. Yes, it's a determination, Malas. Yes. Subsection 3 says, in case the designated officer determines the property to be government property, he shall make necessary corrections in revenue record and submit a report in this regard to the state government, which is what I told your lordships. And the state government under subsection 4 shall, on receipt of the report of the designated officer, direct the board to make appropriate corrections in the records. Now then, who is then the aggrieved party? Us, the Waqf. Then under 83, I go to the tribunal. So a dispute which is judicial in nature, decided through the executive, after being a judge in his own cause, and before the inquiry starts, this is no longer a Waqf. After the inquiry is over, the revenue records are corrected, and I have to go to the tribunal for an adjudication, and God alone how long that will take. And in the meantime, my right is taken away. It's expropriatory. It's violative of 25. It's violative of 14. It's manifestly unjust and arbitrary. So that's that one point, Malas, which I placed before your lords. Now, Malas, kindly come back to 3B. And this 3C applies to all forms of Waqf. Not just Waqf by user. All forms of Waqf. The moment this dispute is created. Now kindly come to 3B, Malas. Which is perhaps even more problematic. 3 capital B at page 8. May I read it, Maharaj? Every Waqf registered under this Act prior to the commencement of the Waqf Amendment Act 2025, shall file the details of the Waqf and the property dedicated to the Waqf on the portal and database within a period of 6 months from commencement. Right, Malaj? Now kindly come to subsection 2. What are those details that have to be provided? The details of the Waqf under subsection 1, amongst other information, shall include the following. Kindly come to B. The name and address of the creator of the Waqf, mode and date of such creation. How will people have that, Malaj? In a Waqf by user. Waqf created 200 years ago. How do we know who the creator of the Waqf is? What is the date of creation?
Can never have a creator. Waqf by user can never have a creator. By definition, it cannot.
That's exactly the point. That's why, precisely the point. This is about the registered work we are talking about. Because even after registration, our Waqf by user can be registered, Malaj, he still may not know. And if I don't give it, Malaj, I can go to jail for, the Matwalli will go to jail for 6 months. Read it with 61(1)(a). Because it deals with every Waqf registered, Malaj. It may be a Waqf by user or otherwise. It applies to every Waqf registered. Kindly come to page 51, Malaj. Section 61. Page 50, section 61. If a mutawalli fails to, and kindly straight away come to Roman small 5 at page 51, upload the details of Waqf under 3B. Those are the details I mentioned to your lordships. Now what will happen to him? He shall be punishable with imprisonment for a term which may extend to 6 months and also with fine. So if he doesn't know the name of the creator, Malaj, he shall suffer imprisonment. He would. Now kindly note, sorry. Kindly note, let's go back to 3B2. Instead of B, kindly read C. He has to also produce the deed of Waqf. But after that,
keep available.
Correct. But it doesn't apply to B.
Yes, if he is not known, then they need to.
Then how can it doesn't? It should have been. Because, Malaj, if he doesn't give the name of the creator and the date, he will be imprisoned.
We could have been better worded if available was also there.
Correct, correct. Right, so Malaj, I have taken care of 3C and 3B, Malaj. And also the proposition that I have to wait for 5 years as a Muslim. So those 3 I have taken care of. Now kindly come to 3D. That's at page 10. That's on the protected monument and protected area. May I read it, Malaj? Any declaration or notification issued under this Act or under any provisions, any previous Act in respect of Waqf properties shall be void. This is what I was trying to show to your lordships when I made that proposition. if such property was a protected monument or protected area under the Ancient Monuments Preservation Act 1904 or the Ancient Monuments and Archaeological Sites and Remains Act 1958 at the time of such declaration or notification. Taj Mahal is a protected monument, Mullahs. Under the Ancient Monuments and Archaeological Sites. At the time of such declaration or notification. At the time. So it is retrospective. So this section operates retrospectively because many of these monuments were declared as ancient monuments even prior to independence. So retrospectively, they lose all their character. Quite frankly, I haven't ever seen an act so generous to a community as this one is. Yes. Before, correct. 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 Now kindly see, Mullahs, kindly come to the Ancient Monuments and Archaeological Sites Act. No, let's go to the 1904 Act first, Mullahs. Ancient Monuments Preservation Act 1904. That's in this book itself, Mullahs, which your Lordship has. And your Lordships will find it at page 54. A 1904 Act is part of the 1958 Act, Mullahs. Now, just kindly have a look at the definition, Mullahs, of ancient monument at page 55. It starts at page 54, the 1904 Act.
It is United Work Management Empowerment.
No. In the same book, at the end, you will have that. Oh,
Ancient Monuments book.
Ancient Monument books, your Lordship is to have.
Ancient Monument Act.
Yeah, I'm sorry, yes. If it's a 2000, I have the 2022 edition.
Yes, right.
Then it will be page 54, Mullahs. Your Lordship has the 22 edition? Yeah, then the page is 54. Well, this will give you an indication that the intent was never to interfere in rights of minorities under 25. The definition itself. Ancient monuments, that's at page 55. Mullahs. Preamble says, Mullahs, an act to provide for the preservation of ancient monuments and objects of archaeological, historical, or artistic interest. So preservation, Mullahs, that's the intent. Ancient monument means any structure, erection, or monument, or any tumulus or place of interment, or any cave, rock sculpture, inscription, or monolith, which is of historical, archaeological, or artistic interest, or any remains thereof, and includes site of an ancient monument, such portion of land adjoining it, it may require fencing or covering in, or otherwise preserving such monument, means of access to and convenient inspection of ancient monument. So your Lordship notices here, it doesn't have any religious tone to it. A religious structure can also be an ancient monument, but the intent is to preserve it. But what they've done in 3D is to say that the moment there's a declaration, then it ceases to be a Waqf. And the Waqf is void. and retrospectively. How do you defend something like this? And then, let's kindly come to page 58, section 10. Yes. Yeah, come to 6 first, Mulats. Or kindly see section 4 first, ancient monuments. Page 56. The collector, with the sanction of the central government, may purchase or take a lease of any protected monument. Collector, with the like sanction, may accept a gift or bequest of a protected monument. The owner of any protected monument may, by written instrument, constitute the commissioner the guardian of the monument. And when the commissioner accepts the guardianship of the monument, owner shall accept, as expressly provided in the Act, have the same estate, right, title, and interest in or to the monument, as if the commissioner had not been constituted guardian thereof. Whereas the fundamental theme, as far as the Waqf is concerned, is that it is my property. I cannot create a Waqf unless it is my property. And this my property is taken away through a legislative diktat. In other words, a person's property is acquired without
Section 6.
Section 4, Mullahs, I was showing to your lordships. Declarations are under section 3 or protected monument. 4 says that, look, it can be purchased, it can be taken on lease. 5 says there has to be an agreement for preservation. I don't want to read all of it, Mullahs, because there's not enough time. It's only prima facie. And then section 10 says compulsory purchase of ancient monument if the central government apprehends that a protected monument is in danger of being destroyed, injured, or allowed to fall into decay. The central government may direct the state government to acquire it. This is not the case. Here, pursuant to a declaration, the acquisition takes place. And the Waqf is void. And says the powers of compulsory purchase conferred under 1 shall not be exercised in the case of any monument which or any part of which is used for religious observance, or any monument which is the subject matter of subsisting agreement executed under 5. So the intent of the Act is to preserve my right. 2025 destroys it, takes it away, expropriates it, and through a diktat. And the definition itself, Mullahs, actually doesn't talk of a religious construction. Now kindly see, Mullahs. Let's go to the other Act now. Now kindly see the 58 Act. At page, Mullahs, 3 of this book. Now, if your lordship looked... Yes. All these declarations, Mullahs, were made in 1904 and continued in 1958. And they are giving them retrospective effect to take away the Waqf character. Now kindly see, Mullahs, the definition itself at page 3 is the same as in the 1904 Act. So I won't read it, Mullahs. It has no religious color to it. And then, Mullahs, kindly come to section 5 at page 7. It's the same, Mullahs. It is exactly the same as in the 1904 Act, section 4. Acquisition of rights in a protected monument, exactly the same. And it says subsection 6, just note that, Mullahs, at page 7, nothing in this section shall affect the use of any protected monument for customary religious observances. So the intent of both these acts was never to take over, Mullahs, the rights of a minority community for religious purposes, using this property for religious purposes. Never the intent. But the 2025 is a complete departure. And then kindly come to section 13. Yeah. Mullahs, you may have a protected monument. Mullahs, actually, there are many of these which have nothing to do with religious purposes also. So it may be dilapidated. The owner may be, he says, I can't really keep up the maintenance of this protected monument. So under 6, they can have mullahs an agreement. That's the spirit of the act. And then section 13 is acquisition. It is the same one. The definition is almost the same. Yes. Now, let's kindly see 13. If the central government apprehends that a protected monument is in danger of being destroyed, injured, misused, or allowed to fall into decay, it may acquire the protected monument under the provisions of the Land Acquisition Act. The intent was never to take away property. Otherwise, this provision would never be there. Because as I said, Mullah, the underlying purpose of a trust, of a waqf, is that I create a waqf through my ownership of that property. So if I'm taking away somebody's ownership, even if you were to acquire it, you'll have to give compensation under the Land Acquisition Act. Now again, through legislative diktat, they've done away with this. So it's violation of 300A, it's a violation of 14, it's a violation of 25 and 26, per se. And section 24 is identical, 20 is power to acquire protected areas. The same thing as Mullah's protected monuments is in 13 and protected areas are 20. And kindly now see 16, very important section, Mullahs. This is at page 10. A protected monument maintained by the central government under this act, which is a place of worship or shrine, shall not be used for any purpose inconsistent with its character. So these statutes preserve the character of either the ancient monument or the protected area. And you have now destroyed that character by directly encroaching upon the minority's right under 25. There has to be a legislative rationale which must be evident by reading the provisions of the Act. I'll continue it. One second.
But
not too much time, but some my learned friends may also give.
I would also like.
Yes. Not too much time.
While not repeating anything you said.
That everybody said. But always in breach.
In his case, the proof of the pudding is in the eating, Mullahs. He always deeply obsessed. कर दूंगा.
my lord, now that that's a judicial order, my lord, we can do nothing.
Rather than having any matter as a lead matter, let us have the issues which are required
Exactly,
to
my
be
lord. Let there be written note, my lord, consolidated.
are required to be gone into for consideration of interim relief.
Perfect.
Lord,
That's
there
what
can,
we'll do.
Lord, there can be one written note on their side and one written note on our side. We will sit together and prepare a note. They can sit together and
Prepare it and we'll file it.
When can it be? By when we can?
My lord, by
Monday we'll,
By Sunday, my lord. No, it's ready.
by Sunday.
Mr. Sibbal's note is ready.
Yes, by Sunday.
Just give it to me. We will respond to that, my lord, by
To consolidate our arguments this side, my lords, by Sunday. So by Monday we are ready.
Circulate it to all of us.
We'll circulate to everybody.
No, I had created a whole.
Circulate it to us also.
Yes, of course. We'll be in difficulty if we don't, Minister.
That's also into confidence.
Continue. Perhaps if the lordship could consider it.
Once we decide those issues,
transfers would be covered. All petitions will be covered, my lord, either way.
Discuss it.
Today I think your lordship only concerned.
Let's not, Manas, discordant voices, Manas. We'll do a unified note,
Yes.
taking note of
Yes, one
everything.
on each side. Yes. Yes.
you're from which side?
It's our side, Manas.
We are with the similar side.
Our side.
Both of us are, although more on this side because of lack of space.
They have,
Some of you appear to be in the aisle.
no, my lord.
We are all
They,
firmly on
even
this side
they,
of the
my lord, they
mic.
have encroached on this side.
If I may say so, it's like a Mumbai train. You enter the court and then you are taken whichever side.
There's a lot dimension, my lord. The middle is sometimes called the cross benches, my lord. They're from the cross benches. They are on the well of the court.
Third set of petitions.
Manas, you may give any.
Lord, our writ petitions, Lord, we have filed the writ petitions, which have been treated as impeded application. Now, Lord, why just say
So that's what we are requesting. Mr. Sibal has also agreed that.
very nice. Lord, only one request. Lord, from the very beginning of the Joint Parliamentary Committee, I was there, my lord. I spent my 8 months for that. Just kindly allow me to speak for few minutes after anybody.
Not the difficulties.
At any
I'm not on Mr. Banerjee.
Mr. Banerjee, you would like to address us as a lawyer or as a parliamentary?
Lawyer, of course, as a lawyer.
Lord, I'll tell you a lot.
I,
Lord, may I say something? Lord, Mr. Banerjee was also not there. Your lordships were also not there. Let me make it clear. Lord, because of several interventions and several petitions, this honorable court directed that let 5 petitions be treated. Rest would be interventionists and they can assist the leading arguing lawyers. So, my lord, that's otherwise it becomes unmanageable. My lord, we have 40 people on this side, 40 on that side.
very nice. My lord, I am requesting to give me a chance. 5 plus 1. Just one. My lord, I was not there.
The court has only directed those 5 petitions to be.
Exactly. There was a purpose, there was an intent.
It has not restricted the number of lawyers that would address.
That's right.
And at least in Supreme Court, no judge can do that. We'll maintain, and at least after the live telecasting has started.
Yes.
That's, we'll share our points with Mr. Sibal and Dr. Dhawan. We'll share our points as far as possible so that we don't have to individually address your lordship.
And sir, if we choose, then
Yeah, because let Dr. Dhawan and Mr. Sibal point out the main issues.
So we have lawyers, we have a parliamentarian, we have an academician.
Parliamentarian come lawyer, not only parliamentarian. Lawyer first, then the parliamentarian.
Lord, there are states, my lord, we are also, my lord, on our side curtailing. And my lord, now, my lord, in the intervention applications where, my lord, not considered, my lord, that is a fact. Now, if your lordships would like to hear them, my lord, I can't come in the way, I will not object to it. But that would be breaching the discipline agreed upon.
Many of the writ petitions were turned into IAs.
All the.
Yes. So then those must be heard. Those must be heard anyway. We're consolidated.
Sir, may I submit, sir, that 30% of the around 130 parties, may I just...
1 second. My lord, the Chief Justice wants to say something. Could you...
Yeah, 1 second, sir. May I just say that on the issue of the 5 writ
Teaching us, so therefore he has an.
Sir, may I
He has been teaching us in the academy, so he has that right.
But he has not forgotten that fact. So that's
I did not want to say that.
Sir, I have a particular submission on the 5 writ petitioners chosen, sir. 30% of the nearly 130 parties are non-Muslim parties.
all 5 writ petitions are Muslim parties. It should not give a polarized impression to the archive.
Nobody is giving any polarized.
No, sir.
Petitioner is a petitioner, but he is
Please allow.
not a Muslim.
Sir, please allow the intervene.
No, don't bring this angle at all.
Sir,
Names have been removed from the title.
Please allow the interveners, if they wish to
Sybil is right.
file writ petition, sir. Give liberty to file writ petition.
Would you
sir.
please?
That's all.
That's not possible, Mr.
Well, that is the reason why
Then on what basis these?
there is the name is now Ray validity of.
So let the archive show, sir, a fair picture.
Can at least now can we have your permission to say something?
Yes, of course, sir. Of course, sir.
I think you are saying 2 hours, but do you think that it will be possible in 2 hours?
Yes.
So,
Because I'm worried, Malad, but this is the kind of thing, it is not good. Yes.
But this way, I don't think we'll be able to do it.
with this way, we will not be even in a position to begin.
Yes.
That was the reason 5 plus 5. My lord, I agree with Mr. Sybil. And that was the reason this A religion or B religion that this court considered that the name of the now nomenclature would be Ray challenge to the Waqf family.
We will grant you 2 hours.
Yes.
We will grant them 2 hours.
Fair enough.
You decide how to share that time amongst you, sir. I was done by you in that sub-classification matter.
Yes,
exactly.
Yes.
We did that last time also.
Amongst us, there's no problem. We'll divide our time. There's no difficulty.
Lord, there is no issue on our side also.
But it should be done in a fair
Whereas
manner.
what we'll try and do is we'll have a consolidated note and we'll divide, if at all, Malad, other council to take some points, some council to take the other.
But sir, there's a third dimension I was indicating. There is a substantive challenge to the 95 Act because the batch of the interim matter.
We are only considering on interim relief.
Interim relief. Please don't push. That's not on interim relief.
So, you want an interim relief on a 1995 Act in 2025?
Post amendment, there is a consequence which you would like to address lordships in a substantive.
We will go by the earlier order passed by the.
Yes. We are here to argue on interim relief.
May I just point out that we are also aggrieved by certain provisions of Waqf Act 1995 as amended in 2025. So there is a third dimension. Lordship may give us half an hour so that we can also make our submission. We are also aggrieved. We are also aggrieved.
Never end.
We are also aggrieved by the present Waqf Amendment Act. Certain
Whether in the last order that is mentioned.
mentioned in the last order.
No, it's.
It is mentioned in the last order. At 2 writ petitions.
Lord, if it is shown, it is shown. My lord, why are we arguing if there is already a judicial order?
Those 2 writ petitions.
Item 16 and 17.
Item 16 and 17, my lord.
So what is your grievance?
My lord, my grievance is that so far as the certain provisions of Waqf Act, so far as taxation is concerned, Section 8, it is still there. Waqf Tribunal, which is completely unconstitutional, it is still there. So there are various other sections which are completely draconian, which still exist in the statute.
They are existing since when?
1995 and 2025 also.
If they are existing since 1995 and if you are not challenging them.
Well, we challenge it. We challenged it.
When?
We challenged it.
Challenge them when?
Lord, let us not deviate from the order passed. Mr. Jain, please. Let us not deviate from the order already passed.
Challenge earlier.
No interim relief required.
Asked us to go to the High Court. We filed around 140 petitions which are pending in different high courts, and now we have filed the present writ petition, which is a fresh matter, challenging various provisions, my lord. It was challenged earlier.
Challenging provisions of 95 Act or 2025 amendment?
1995 Act as well as certain provisions.
How can we permit you to raise a challenge to the provisions of 95 Act in 2025?
Interim relief.
I appreciate. May I just explain, sir? Just.
At least no urgency for interim relief.
Interim relief, my lords.
Sir,
After 30 years.
Lordship, I kindly appreciate. There are, may I just, I am also seeking interim relief, sir. It is there in my petition.
Are you seeking interim relief of the provisions of 95 Act or 2025?
95 Act, Section 3R.
That's the common issue which we are.
There is certain deviation, Lordship.
But we argue when your turn comes, the deviation can be argued. It is taken care of in the earlier order.
Saying I must be given half an hour to, my lords, make my points.
We'll sit on that date.
Section 3R, my lord, Shamlat Da, village land. That has not been repealed.
Shamlat De, I think is pre-independence act insofar as my learned brother would know it, but
it's in Punjab or.
That's right.
I have dealt with one of the litigations from state of Haryana with regard to that.
Give us some time.
That is a pre-independence act.
Lordship, that's what I'm. Lordship may kindly.
It was. Don't mix the issues and this.
I'm not mixing the issue. Lordship may kindly appreciate.
How can that be interim relief, my lords?
We will not consider any request or stay of any of the provisions under the 95 Act. We are making it clear. Just because somebody is trying to make a challenge to the amendment of 2025 and somebody just wants to jump in and challenge 1995, that will not be permitted.
I think I am not able to communicate what has actually.
Well, let it be on, my lord, whichever date your lordship considers proper, my lord, Tuesday or
Court asked
Wednesday.
us to go to High Court.
Mr. Jain, please.
They've never had a stay since 1995.
Can I say my lord, one line he wants to say that we have been waiting for that stay since long, but this court directed us that you go to the High Court and never considered our prayer for 95. I am saying what he is saying.
95 is considered in 2025.
Yes.
That's what my lord, he has yes, my lord, there is some difference, but he is to be heard, my lord. There is no point arguing that today. That's all I am saying.
Tuesday.
So the intervention applications may be allowed, sir.
Tuesday, fine.
Considered them.
Interim assurance.
Intervention applications are, Mr. Jain is a nodal AR for that, so you have to approach him.
Lord, there are three, I'm one of the nodal councils.
Mr. Ejaz and Mr. Kanu
For
Agarwal.
interveners, it is Mr. Jain.
No.
Yes,
They are writ petitions, all writ petitions converted.
There are three nodal councils. There are three nodal councils for the private interveners.
Yes, Mr. Kanu Agarwal, Mr. Ejaz and
Mr. Jain, that third dimension, but interventions, my lord. They can give their suggestions, my lord. That's all, my lord.
Earlier writ petitions were converted into intervention applications, barring 5.
Yes, Mr. Vishnu Shankar Jain is a
That's right.
Yes.
for applicant. So you just ask the waiver to contact him.
Lord, can it be on Tuesday?
Yes, Tuesday.
Tuesday, but and the assurance continues because it's only till date.
Yeah, of course. Of course.
SG has made a statement.
Yes, my lord. It must be. Well, it will continue.
The court order says only till, that's why, otherwise I would just.
No, that's.
To continue.
He is before the court, you are also before the court.
It possibly even doesn't say till today it has expired, but it is continuing. Well, that I can't remain on that technical.
reflected.
Anyway, my lord, it continues. Let's not go into that.
Last order, sir.
Mr.
They are not an issue, not an issue.
Till the next.
The direct solicitor is before the court.
Yeah, that's right.
If somebody, some officer tries to play with technicalities, we are here.
No, my lord, before that, I am there. Don't worry, my lord.
My lord, may I just request? My lord, may I just request one small thing? My lord, five petitions were identified as lead petitions. The rest have all become intervention applications. My lord, I'm all requesting is that 5 petitions may not be limited to 5 senior counsel.
No, but that is decided and everyone else.
My lord, it's not been decided.
Otherwise, then it will not be possible for
Lord, I'm just-
here this side of
One of the 5, my lord, we can't object to that.
My lords, I'm saying this that in previous practice of this court has been to give a certain amount of time.
Thanks.
And then,
Mr. Sibal has said that he will take 2 hours. So we request him that he should have a meeting with all of you and you decide as to how.
I think we have to subordinate our personal thing for a larger issue. Let one or two councils.
That's what we say, that it is very difficult to control the. I'm sorry,
No, I'm
I also belong to.
I'm saying we have to suppress our own personal urges.
After 24th November, I will also be that side. But our experience of all the judges who come from opposite court, I think that the bars there are much more disciplined.
That's right.
lords, if we could combine 5 or 10.
Really difficult to.
I agree. But I think when from Madhya Bharat in particular, even the high courts, the decorum is something which is unbelievable because
you also have the experience. The Learned solicitor has an experience.
Coming from Gujarat, follow my lord, Bombay practice and it's completely different.
Bombay bench and Nagpur bench is like one is like a circus and one is like a bench with great decorum.
But I must say that
we always see that
this has changed now. It never used to be like this.
Here it is. We are taking so much time.
Yes, I know.
Only to fix a date.
On a lighter note, can I suggest, my lord, to remove this difficulty? Please stop live streaming of this matter.
That's what I said.
I've advocated that all for a long
What
time.
should we fix the time? Why should we fix? What should we fix? Each hour.
We are giving 2 hours, this side 2 hours to that side.
Correct.
And now, Tuesday, then we'll keep only this matter.
That's right.
But then it should not happen that for A reason or B reason, it doesn't go ahead and then we are left with no work.
No.
No.
No question. No
Lord,
question.
Mr. Sibal may share his note with us today.
Yes,
And we will file it by, my lord, Sunday, my lord.
Yes, Sunday morning.
Since we live at a distance of 16-kilometer distance, I live in 16 kilometers distance.
From here? No, but why? You will be in Luton's.
But that is I could not.
No, but you must be in the Luton's.
Yes.
The Luton's is not 16 kilometers away. Yes.
My lord.
I can attest to the proof that he's a very good Lutyens. No, but you are living in Lutyens. You are living in Lutyens.
But Lok Sabha also is in Luton's zone.
Yes.
India and Mr. Simple, that's my distance. Sir. I have to go back. Today I will do, again I will go back.
We are all accountable, my lord. We are all accountable in some way or the other.
The constitution.
I was not against fight. Can you reconsider me?
There's already a member of the Joint Parliamentary Committee in the 5 also, ma'am.
Anyway, let's leave.
No, you have already contributed. Now let others.
Coming, please, stay, madam.
Mr. Banerjee, your contribution would be either used by this side or that side. So
Correct.
it will be there.
States also.
Kerala.
Yeah, he's right. He's supposed to be right. The rest of the states are not having any problem.
No, that's not right. That's not right, my lord.
I will try and echo his sentiments, but he should not be worried. I'll try and echo that.
Tuesday.
Grateful, my lord.
Lord, they may give it today so that we can give them on Sunday. They get enough time.
Need a
So you can just hand it over to.
time to accumulate.
No, it is ready. Mr. Sibal has made it ready. You must trust Mr. Sibal's note.
The note I have to.
That note we can hand it over to the learned solicitor.
Yes, we will. We'll circulate, mother.
Okay, you make the note final by tomorrow evening. Make the note final by tomorrow evening and give it to the learned SG and let the learned SG give it by Sunday evening. Or Monday evening.
Saturday, my lord.
Saturday we'll be able to give, not tomorrow, mother.
Okay, Saturday, but then you will have only one day or
Saturday,
Then
Sunday,
Monday morning, my lord. We can one day evening.
Monday evening you can give.
Monday evening.
See, that's fine.
Very well. That's fine.
We are not putting it on record, so but it is understood that by Saturday evening your note will go to Mr.
Definitely.
Yes, madam.
And both the notes will come to us by Monday evening.
Yeah, definitely.
Would it be Monday afternoon?
We will be filing by Monday afternoon so that it.
We'll try and get it earlier also.
Otherwise, it doesn't reach.
We can give it in a physical copy to the court.
To the court master.
Yes.
We schedule.
We'll do that.
That will be better because here if it is filed here, then that file might
Yes.
9 o'clock, 10 o'clock. So.
That's right, that's right.
So traveling from here to here takes one of the entire route rather than.
We'll do both, we'll upload it and give the copy.
Yes.
Physical copy.
Right.
My lord, now that that's a judicial order, my lord, we can do nothing.
Rather than having any matter as a lead matter, let us have the issues which are required.
Exactly, my lord. Let there be written note, my lord, consolidated.
Are required to be gone into for consideration of interim relief.
Perfect.
Lord,
That's
there
what
can,
we'll do.
Lord, there can be one written note on their side and one written note on our side. We will sit together and prepare a note. They can sit together and
prepare it and we'll file it.
When can it be? By when we can?
My lord, by
Monday we'll.
By Sunday, my lord. No, it's ready.
By Sunday.
Mr. Sibal's note is ready.
Yes, by Sunday.
Just give it to me. We will respond to that, my lord, by
To consolidate our arguments this side, my lords, by Sunday. So by Monday we are ready.
Circulate it to all of us.
We'll circulate to everyone.
No, I had created a whole.
Circulate it to us also.
Yes, of course. We'll be in difficulty if we don't, Melissa.
That's also into confidence.
Continue. Perhaps if the lordship could consider it. Once we decide those issues,
transfers would be covered. All petitions will be covered, my lord, either way.
Discuss it.
Today I think your lordship's only concern.
Let's not, Melissa, discordant voices, Melissa. We'll do a unified note,
Yes.
taking note of
Yes,
everything.
one on each side. Yes.
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 You're from which side?
He's our side, my lord.
We are with Mr. Sibbal's side.
Our side.
Both of us are, although more on this side because of lack of space.
They have,
Some of you appear to be in the aisle.
No, no, Lord.
We are all
They-
firmly on
even
this side
they-
of the
Lord,
mic.
they have
encroached on this side.
If I may say so, it's like a Mumbai train. You enter the court and then you are taken whichever side.
There's a lot dimension, my lord. The middle is sometimes called the cross benches, my lord. They're from the cross benches. They are on the well of the court.
set of petitions.
Lordship may give any.
Lord, our writ petitions, Lord, we have filed the writ petitions, which have been treated as Lord, impeded applications. Now, Lord, just say
That's what we are requesting. Mr. Sibal has also agreed that.
very nice. Lord, only one request. My Lord, from the very beginning of the Joint Parliamentary Committee, I was there, my Lord. I spent my 8 months for that. Just kindly allow me to speak for few minutes after anybody.
Not the difficulties.
At any
I'm not on Mr. Banerjee.
Mr. Banerjee, you would like to address us as a lawyer or as a parliamentarian?
As a lawyer, of course, as a lawyer.
Lord, I'll tell you a lot. Lord,
Lord,
may I say something? Lord, Mr. Banerjee was also not there. Your lordships were also not there. Let me make it clear. Lord, because of several interventions and several petitions, this honorable court directed that let 5 petitions be treated. Rest would be interventionists and they can assist the leading arguing lawyers. So, my lord, that's otherwise it becomes unmanageable. My lord, we have 40 people on this side, 40 on that side.
Very nice. My Lord, I am requesting to give me a chance. 5 plus 1. Just one. Lord, I was not there.
The court has only directed those 5 petitions to be.
Exactly. There was a purpose, there was an intent.
It has not restricted the number of lawyers that would address.
That's right.
And at least in Supreme Court, no judge can do that. We'll maintain, and at least after the live telecasting has started.
Yes.
That's, we'll share our points with Mr. Sibal and Dr. Dhawan. We'll share our points as far as possible so that we don't have to individually address your lordship. Yeah, because let Dr. Dhawan and Mr. Sibal point out the main issues.
So we have lawyers, we have a parliamentarian, we have an academician.
Parliamentarian come lawyer, not only parliamentarian. Lawyer first, then the parliamentarian.
Lord, there are states, my lord, we are also, my lord, on our side curtailing. And my lord, now, my lord, in the intervention applications where, my lord, not considered, my lord, that is a fact. Now, if your lordship would like to hear them, my lord, I can't come in the way, I will not object to it. But that would be breaching the discipline agreed upon.
Many of the writ petitions were turned into IAs.
All the.
Yes, so then those must be heard. Those must be heard anyway, we're consolidated.
Sir, may I submit, sir, that 30% of the around 130 parties, may I just...
1 second. My lord, the Chief Justice wants to say something. Could you?
Yeah, 1 second, sir. May I just say that on the issue of the 5 writ
Teaching us, so therefore he has an.
Sir, may I
He has been teaching us in the academy, so he has that right.
He has not forgotten that fact. So that's
I did not want to say that.
Sir, I have a particular submission on the 5 writ petitioners chosen, sir. 30% of the nearly 130 parties are non-Muslim parties. All 5 writ petitions are Muslim parties. It should not give a polarized impression to the archive.
Nobody is giving any polarized.
No, sir.
Petitioner is a petitioner, but he is a
please allow.
Nor a Muslim.
Sir, please allow the intervention.
No, don't bring this angle at all.
Names have been removed from the title.
Please allow the interveners, if they wish to
is right.
file writ petition, sir. Give liberty to file writ petition.
Would you please?
That's all.
That's not possible, Mr.
Well, Lord, that is the reason why.
Then on what basis these?
There is the name is now Ray validity of.
Sir, let the archive show, sir, a fair picture.
Can at least now can we have your permission to say something?
Yes, of course, sir. Of course, sir.
I think you are saying 2 hours. But do you think that it will be possible in 2 hours?
Yes.
So,
Because I'm worried, Malad, but this is the kind of thing, it's not good. Yes.
But this way, I don't think we'll be able to do it.
With this way, we will not be even in a position to begin.
Yes.
That was the reason 5 plus 5. My lord, I agree with Mr. Sibal. And that was the reason this A religion or B religion that this court considered that the name of the now nomenclature would be Ray challenge to the Waqf family.
We'll grant you 2 hours.
Yes.
We'll grant them 2 hours.
Fair enough.
You decide how to share that time amongst you, sir. As was done by you in that sub-classification matter.
Yes,
Exactly.
Yes, yes.
We did that last time also. We'll do it this time.
Amongst us, there's no problem. We'll divide our time. There's no difficulty.
Lord, there is no issue on our side also.
But it should be done in a fair
Well,
manner.
what we'll try and do is we'll have a consolidated note and we'll divide if at all, Mullah, other council to take some points, some council to take the other.
But sir, there's a third dimension I was indicating. There is a substantive challenge to the 95 Act because the batch of the in-day matters.
We are only considering on the question of interim relief.
Interim relief. Please don't push. That's not on interim relief.
So,
We are also.
you want an interim relief on a 1995 Act in 2025?
Post amendment, there is a consequence which you would like to address lordships in a substantive.
We will go by the earlier order passed by the.
Yes.
May I just-
We are here to argue on interim relief.
May I just point out that
Earlier
we
order
are
requires
also
arrest.
aggrieved by certain provisions of Waqf Act 1995 as amended in 2025. So there is a third dimension. Lordship may give us half an hour so that we can also make our submission. We are also aggrieved. We are also
Will never end.
We are also aggrieved by the present Waqf Amendment Act certain
Whether in the last order that is mentioned.
mentioned in the last order.
No, it's there.
It is mentioned in the last order. That two writ petitions may
Lord, if it is shown, it is shown, my lord. Why are we arguing if there is already a judicial order?
those two writ petitions.
Item 16 and 17.
Item 16 and 17, my lord.
So what is your grievance?
My lord, my grievance is that so far as the certain provisions of Waqf Act, so far as taxation is concerned, section 8, it is still there. Waqf tribunal, which is completely unconstitutional, it is still there. There are various other sections which are completely draconian, which still exist in the statute.
They are existing since when?
1995 and 2025 also.
If they are existing since 1995 and if you are not challenging.
My lord, we challenge it. We challenge it.
When?
We challenged it.
Challenge them when?
Challenge.
Lord, let us not deviate from the order passed. Mr. Jain, please. Let us not deviate from the order already passed.
Challenge earlier.
No interim relief
Court
required.
asked us to go to the High Court. We filed around 140 petitions which are pending in different High Courts, and now we have filed the present writ petition, which is a fresh matter, challenging various provisions, my lord. It was challenged earlier.
Challenging provisions of 95 Act or 25 amendment?
1995 Act as well as certain provisions.
How can we permit you to raise a challenge to the provisions of 95 Act in 2025?
Interim relief
I
here.
appreciate. May I just explain, sir? Just.
At least no urgency for interim
There is
relief
urgency-
There are
there is
interim
urgency
relief,
for
my lords.
So far, sir,
after 30 years.
Lordship, may kindly appreciate. May I just, I am also seeking interim relief, sir. It is there in my petition.
Are you seeking interim relief of the provisions of 95 Act or 2025?
95 Act, section 3R.
That's the common issue which we are.
There is certain deviation, Lordship.
But we argue when your turn comes, the deviation can be argued. It is taken care of in the earlier order.
Saying I must be given half an hour to, my lords, make my points.
We will sit on that date.
Section 3R, my lord, Shamlat Da, village land. That has not been repealed.
Shamlat De, I think is pre-independence act insofar as my learned brother would know it, but
It's in Punjab or.
That's right.
I have dealt with one of the litigations from state of Haryana with regard to that.
Give us some time.
That is a pre-independence act.
Lordship, that's what I'm, Lordship may kindly.
It was.
Don't mix the issues and this.
I'm not mixing the issue. Lordship may kindly
How
appreciate.
can that be interim relief, my lords?
We will not consider any request or stay of any of the provisions under the 95 Act. We are making it clear. Just because somebody is trying to make a challenge to the amendment of 2025 and somebody just wants to jump in and challenge 1995, that will not be permitted.
I think I am not able to communicate what as actually.
Lord, let it be on, my lord, whichever date your lordship considers proper, my lord, Tuesday or
Court asked
Wednesday.
us to go to High Court.
Mr. Jain, please.
They've never had a stay since 1995.
Can I say my lord, one line? He wants to say that we have been waiting for that stay since long, but this court directed us that you go to the High Court and never considered our prayer for 95. I am saying what he is saying.
95 is considered in 2025.
Yes.
That's what he has. Yes, my lord, there is some difference, but he is to be heard, my lord. There is no point arguing that today. That's all I am saying.
Tuesday.
So the intervention applications may be allowed, sir.
Tuesday, fine.
Considered them.
Interim assurance.
Intervention applications are, Mr. Jain is a nodal AR for that, so you have to approach him.
Lord, there are three, I'm one of the nodal councillors.
Mr. Ejaz and Mr. Kanu
For
Agarwal.
interveners, it is Mr. Hey, no.
my lord.
Yes, that-
Writ
Yes,
petitions,
Well, honest,
all
right.
writ petitions
There
converted.
are three nodal councils. There are three nodal councils for the private
Yes,
interveners.
Mr. Kanwa Agrawal, Mr. Aizad and Mr.
Mr. Jain, that third dimension, but interventions, my lord.
No,
They
those-
can give their suggestions, my lord. That's all, my lord.
Earlier writ petitions were converted into intervention
Interventions.
applications, barring 5.
Yes, Mr. Vishnu Shankar Jain is a
That's right.
Yes.
for applicant. So you just ask
Yes.
for ever to contact him.
Lord, can it be on Tuesday?
Yes, Tuesday.
Tuesday, my lord, and the assurance continues because it's only till date.
Yeah, of course, of course.
Learned SG has made a statement.
Yes, yes, my lord. It must continue. Well, it will continue.
The court order says only till, that's why, otherwise I would just.
No, no, that's.
To continue.
He is before the court, you are also before the court.
It possibly even doesn't say till today it has expired, but it is continuing. My lord, that, I can't remain on that technical.
reflected.
Anyway, my lord, it continues. Let's not go into that.
Last order, sir.
Mr.
They are not an issue, not an issue.
Till the next.
The direct solicitor is before the court.
Yeah, that's right.
If somebody, some officer tries to play with technicalities, we are here.
No, my lord, before that, I am there. Don't worry, my lord.
My lord, may I just request, my lord, may I just request one small thing? My lord, five petitions were identified as lead petitions. The rest have all become intervention applications. My lord, I'm all requesting is that 5 petitions may not be limited to 5 senior counsel.
No, but that is decided and everyone has.
My lord, it's not been decided.
Otherwise, then it will not be possible for
Lord, I'm just-
here this side of
One of the 5, my lord, we can't object to that.
My lords, I'm saying this that in previous practice of this court has been to give a certain amount of time.
Thanks.
And then,
Mr. Sibal has said that he will take 2 hours. So we request him that he should have a meeting with all of you and you
Yes.
decide as to how.
I think we have to subordinate our personal thing for a larger issue. Let one or two councils argue the matter.
That's what we say, that it is very difficult to
I mean, there's a-
control the, I'm sorry,
No, I'm
I also
saying-
belong to.
I'm saying we have to suppress our own personal urges.
After 24th November, I will also be that side. But our experience of all the judges who come from opposite court, I think that the bars there are much more disciplined.
That's right.
my lords, if we could combine 5 or 10.
Really difficult to.
I agree.
But I think when, from Madhya Bharat in particular, even the high courts, the decorum is something which is unbelievable because
You also have the experience.
our own
The learned solicitor has an experience.
Coming from Gujarat,
Bombay
follow, my
bench and
lord, Bombay
Nagpur
practice and it's completely different.
Bombay bench and Nagpur bench is like, one is like a circus and one is like a bench with great decorum.
But I must say that.
We always see that.
This has changed now. It never used to be like this.
Here it is, we are taking so much time.
Yes, I know.
Only to fix a date.
On a lighter note, can I suggest, my lord, to remove this difficulty? Please stop live streaming of this matter.
That's what I said.
I've advocated that all for a long
Lord, should we fix the time? Well, why should we fix? Lord, should we fix each hour?
We are giving 2 hours, this side 2 hours to that side.
Correct.
And now, Tuesday, then we'll keep only this matter.
That's right.
But then it should not happen that for A reason or B reason, it doesn't go ahead and then we are left with no work.
No.
No.
No question. No
Lord,
question.
Mr. Sibal may share his note with us today.
Yes,
And we will file it by, my lord, Sunday, my lord.
Yes, Sunday morning.
Since we live at a distance of 16-kilometer distance, I live in 16 kilometers distance.
From here? No, but why? You will be in Lutens?
But that is, I could not be.
No, but you must be in the Lutens.
Yes.
The Lutens is not 16 kilometers. Yes.
My lords.
I can attest to the proof that he's a very good Lutyens. No, but you are living in Lutyens. You are living in Lutyens.
But Lok Sabha also is in Lutens zone.
Yes.
Singhi and Mr. Sipal, that's my distance. I have to go back. Today I will do, again I will go back.
We are all accountable, my lord. We are all accountable in some way or the other.
Constitution. The privilege,
I was not against fight. kindly reconsider, man.
There's already a member of the Joint Parliamentary Committee in the 5 also, ma'am.
Anyway, let's leave.
No, you have already contributed. Now let others.
Coming Tuesday, madam.
Mr. Banerjee, your contribution would be either used by this side or that side. So
Correct.
it will be there.
States also.
Yeah, he's right. He seems to be right. The rest of the states are not having any problem.
No, that's not right. That's not right, my lords.
I will try and echo his sentiments, but he should not be worried. I'll try and echo that.
Grateful, man.
Lord, they may give it today so that we can give them on Sunday. They get enough time.
Need a
Mr. Sival, you can just hand it over to.
time to cumulatively.
No, it is ready. Mr. Sibal has made it ready. You must trust Mr. Sibal's note.
The note I have to.
That note we can hand it over to the learned solicitor.
Yes, we will. We'll circulate, Malad.
Okay, you make the note final by tomorrow evening. Make the note final by tomorrow evening and give it to the learned SG and let the learned SG give it by Sunday evening. Or Monday evening.
Saturday, man.
Saturday we'll be able to give, not tomorrow, Malad.
Okay, Saturday, but then you will have only one day or.
Saturday,
Then
Sunday,
Monday morning, Malad, we can. One day evening.
Monday evening you can give.
Monday evening.
See, that's fine.
Very well, that's fine.
We are not putting it on record, so but it is understood that by Saturday evening your note will go to Mr.
Definitely.
Yes, ma'am.
And both the notes will come to us by Monday evening.
Yeah, definitely.
Would it be Monday afternoon?
We will be filing by Monday afternoon so that it.
We'll try and
reaches
get
your
it earlier
lordship.
also.
Otherwise, it doesn't reach.
We can give it in a physical copy to the court.
To the court master.
Yes.
We schedule.
We'll do that.
That will be better because here if it is filed here, then here that file might.
Yes.
9 o'clock, 10 o'clock. So.
That's right, that's right.
So traveling from here to here takes the entire route rather than.
We'll do both notes, we'll upload it and give the copy.
Yes.
Physical copy.
Right.
Now that that's a judicial order, my lord, we can do nothing.
Rather than having any matter as a lead matter, let us have the issues which are required.
Exactly, my lord. Let there be written note, my lord, consolidated.
Are required to be gone into for consideration of interim relief.
Perfect.
Lord,
That's
there
what
can,
we'll do.
Lord, there can be one written note on their side and one written note on our side. We will sit together and prepare a note. They can sit together and
Prepare it and we'll file it.
When can it be? By when we can?
My lord, by
Monday we'll.
By Sunday, my lord. No, it's ready.
By Sunday.
Mr. Sibal's note is ready.
Yes, by Sunday.
Just give it to me. We will respond to that, my lord, by
To consolidate our arguments this side, my lords, by Sunday. So by Monday we are ready.
Circulate it to all of us.
We'll circulate to everybody.
No, I had created a whole.
Circulate it to us also.
Yes, of course. We'll be in difficulty if we don't, Malad.
That's also into confidence.
Continue. Perhaps if the lordship could consider it.
Once we decide those issues,
transfers would be covered. All petitions will be covered, my lord, either way.
Discuss it.
Today I think your lordship is only concerned.
Let's not, Malad, discordant voices, Malad. We'll do a unified note,
Yes.
taking note of
Yes, one
everything.
on each side. Yes. Yes.
you're from which side?
It's our side, Malad.
We are with Mr. Sibal's side.
Our side.
Both of us are, although more on this side because of lack of space.
They have,
Some of you appear to be in the aisle.
no, my lord.
We are all
They,
firmly on
even
this side
they,
of the
Lord,
mic.
they have encroached on this side.
If I may say so, it's like a Mumbai train. You enter the court and then you are taken whichever side.
Actually, there's a lot of dimension, my lord. The middle is sometimes called the cross benches, my lord. They're from the cross benches. They are on the well of the court.
Third set of petitions.
Malad, you may give any.
Lord, our writ petitions, Lord, we have filed the writ petitions which have been treated as Lord, impleaded applications. Now, Lord, why just say
That's what we are requesting. Mr. Sival has also agreed that.
Very nice. Lord, only one request. My lord, from the very beginning of the Joint Parliamentary Committee, I was there, my lord. I spent my 8 months for that. Just kindly allow me to speak for few minutes after anybody.
Not the difficulties.
At any
I'm not on Mr. Banerjee.
Mr. Banerjee, you would like to address us as a lawyer or as a parliamentary?
lawyer, of course, as a lawyer.
Lord, I'll tell you a lot.
I
Lord, may I say something? Lord, yeah, Mr. Banerjee was also not there. Your lordships were also not there. Let me make it clear. Lord, because of several interventions and several petitions, this honorable court directed that let 5 petitions be treated, rest would be interventionists, and they can assist the leading arguing lawyers. So, my lord, that's, otherwise it becomes unmanageable. My lord, we have 40 people on this side, 40 on that side.
Very nice. I am requesting to give me a chance. 5 plus 1. Just one. I was not there.
The court has only directed those 5 petitions to be.
Exactly. There was a purpose, there was an intent.
It has not restricted the number of lawyers that would address.
That's right.
And at least in Supreme Court, no judge can do that. We'll maintain, and at least after the live telecasting has started.
Yes.
We'll share our points with Mr. Sibal and Dr. Dhawan. We'll share our points as far as possible so that we don't have to individually address your lordship. Yeah, because let Dr. Dhawan and Mr. Sibal point out the main issues.
So we have lawyers, we have a parliamentarian, we have an academician.
Parliamentarian come lawyer, not only parliamentarian. Lawyer first, then the parliamentarian.
My lord, there are states, my lord, we are also, my lord, on our side curtailing. And my lord, now, my lord, in the intervention applications where, my lord, not considered, my lord, that is a fact. Now, if your lordships would like to hear them, my lord, I can't come in the way, I will not object to it. But that would be breaching the discipline agreed upon.
Any of the writ petitions were turned into IAs.
All the.
Yes. So then those must be heard. Those must be heard anyway. We're consolidated.
Sir, may I submit, sir, that 30% of the around 130 parties, may I just...
1 second. My lord, the Chief Justice wants to say something. Could you...
Yeah, 1 second, sir. May I just say that on the issue of the 5 writ
petitions, so therefore he has an...
Sir, may I...
He has been teaching us in the academy, so he has that right.
He has not forgotten that fact. So that's
I did not want to say that.
Sir, I have a particular submission on the 5 writ petitioners chosen, sir. 30% of the nearly 130 parties are non-Muslim parties. All 5 writ petitions are Muslim parties. It should not give a polarized impression to the archive.
Nobody is giving any polarized.
No, sir.
Petitioner is a petitioner, but he is a
please allow.
Not a Muslim.
Sir, please allow the intervention.
No, don't bring this angle at all.
Names have been removed from the title.
Please allow the interveners, if they wish to
right.
file writ petition, sir. Give liberty to file writ petition. That's all.
That's not possible, sir.
Well, that is the reason why.
Then on what basis these?
There is the name is now Ray validity of.
Sir, let the archive show, sir, a fair picture.
Can at least now can we have your permission to say something?
Yes, of course, sir. Of course, sir.
I think you are saying 2 hours. Do you think that it will be possible in 2 hours?
Yes.
So,
because I'm worried, Malad, but this is the kind of thing, it is not good. Yes.
But this way, I don't think we'll be able to do it.
With this way, we will not be even in a position to begin.
Yes.
That was the reason 5 plus 5. My lord, I agree with Mr. Sibal. And that was the reason this A religion or B religion that this court considered that the name of the now nomenclature would be Ray challenge to the Waqf family.
We will grant you 2 hours.
Yes.
We will grant them 2 hours.
Fair enough.
You decide how to share that time amongst you, sir. As was done by you in the sub-classification matter.
Yes, exactly. Yes.
We did that last time also.
Amongst us, there's no problem. We'll divide our time. There's no difficulty.
Lord, there is no issue on our side also.
But it should be done in a fair
Well,
manner.
what we'll try and do is we'll have a consolidated note and we'll divide, if at all, Malad, other council to take some points, some council to take the other.
But sir, there's a third dimension I was indicating. There is a substantive challenge to the 95 Act because the batch of the in-ray matters.
We are only considering on interim relief.
Interim relief. Please don't push. That's not on interim relief.
So, you want an interim relief on a 1995 Act in 2025?
Post amendment, there is a consequence which you would like to address lordships in a substantive.
We will go by the earlier order passed by the.
Yes. We are here to argue on interim relief.
May I just point out that we are also aggrieved by certain provisions of Waqf Act 1995 as amended in 2025. So there is a third dimension. Lordship may give us half an hour so that we can also make our submission. We are also aggrieved. We are also aggrieved.
Never end.
We are also aggrieved by the present Waqf Amendment Act. Certain
Whether in the last order that is mentioned.
mentioned in the last order.
No, it's
It is mentioned in the last order. That 2 writ petitions.
My lord, if it is shown, it is shown. My lord, why are we arguing if there is already a judicial order?
Those 2 writ petitions.
Item 16 and 17.
Item 16 and 17, my lord.
So what is your grievance?
My lord, my grievance is that so far as the certain provisions of Waqf Act, so far as taxation is concerned, Section 8, it is still there. Waqf Tribunal, which is completely unconstitutional, it is still there. So there are various other sections which are completely draconian, which still exist in the statute.
They are existing since when?
1995 and 2025 also.
If they are existing since 1995 and if you are not challenging them,
My lord, we challenge it. We challenge it.
When?
We challenge it.
Challenge them when?
Challenge.
Let us not deviate from the order passed, Mr. Jain, please. Let us not deviate from the order already passed.
Challenge earlier.
No interim relief required.
Asked us to go to the High Court. We filed around 140 petitions which are pending in different High Courts, and now we have filed the present writ petition, which is a fresh matter, challenging various provisions, my lord. It was challenged earlier.
Challenging provisions of 95 Act or 25 Amendment?
1995 Act as well as certain provisions.
How can we permit you to raise a challenge to the provisions of 95 Act in 2025?
Interim relief here.
May I just explain, sir? Just.
At least no urgency for interim relief.
Interim relief, my lords.
So far, sir,
After 30 years.
Lordship, I kindly appreciate. There are interim. May I just? I am also seeking interim relief, sir. It is there in my petition.
Are you seeking interim relief of the provisions of 95 Act or 2025?
95 Act, Section 3R.
That's the common issue which we are.
There is certain deviation, Lordship.
But we argue when your turn comes, the deviation can be argued. It is taken care of in the earlier order.
I'm saying I must be given half an hour to, my lords, make my points.
We will sit on that date.
Section 3R, my lord, Shamlat Da, village land. That has not been repealed.
Shamlat De, I think is pre-independence act insofar as my learned brother would know it, but
It's in Punjab or.
That's right.
I have dealt with one of the litigations from state of Haryana with regard to that.
Give us some time.
That is a pre-independence act.
Lordship, that's what I'm, Lordship may kindly.
It was.
Don't mix the issues and this.
I'm not mixing the issue. Lordship may kindly
How
appreciate.
can that be interim relief, my lords?
We will not consider any request for stay of any of the provisions under the 95 Act. We are making it clear. Just because somebody is trying to make a challenge to the amendment of 2025 and somebody just wants to jump in and challenge 1995, that will not be permitted.
I think I am not able to communicate what as actually.
Lord, let it be on, my lord, whichever date your lordship considers proper, my lord, Tuesday or
Court asked
Wednesday.
us to go to High Court.
Mr. Jain, please.
They've never had a stay since 1995.
Can I say my lord, one line he wants to say that we have been waiting for that stay since long, but this court directed us that you go to the High Court and never considered our prayer for 95. I am saying what he is saying.
95 is considered in 2025.
Yes.
That's what he has. Yes, my lord, there is some difference, but he is to be heard, my lord. There is no point arguing that today. That's all I am saying.
Tuesday.
So the intervention applications may be allowed, sir.
Tuesday, fine.
Considered them.
Interim assurance.
Intervention applications are, Mr. Jain is a nodal AR for that, so you have to approach him.
Lord, there are three. I'm one of the nodal councils.
Mr. Ejaz and Mr. Kanu
For
Agarwal.
interveners, it is Mr. Jain.
No.
Yes,
They are writ petitions, all writ petitions.
There are three nodal councils. There are three nodal councils for the private
Yes,
interveners.
Mr. Kanu Agrawal, Mr. Azad and Mr.
Mr. Jain, that third dimension, but interventions, my lord. They can give their suggestions, my lord. That's all, my lord.
Earlier writ petitions were converted into intervention
Interventions.
applications, barring 5.
Yes, Mr. Vishnu Shankar Jain is a
That's right.
Yes.
for applicant. So you just ask the AR to contact him.
Lord, can it be on Tuesday?
Yes, Tuesday.
Tuesday, but the assurance continues because it's only till date.
Yeah, of course. Of course.
Learned SG has made a statement.
Yes, it must. It will continue.
The court order says only till, that's why, otherwise I would just.
No, that's.
To continue.
He is before the court, you are also before the court.
It possibly even doesn't say till today, it has expired, but it is continuing. Lord, that, I can't remain on that technical.
Last order reflected.
Anyway, my lord, it continues. Let's not go into that.
Last order, sir.
Mr.
They are not an issue, not an issue.
Continue.
Till the next.
The direct policy is before the court.
Yeah, that's right.
If somebody, some officer tries to play with technicalities, we are here.
No, my lord, before that, I am there. Don't worry, my lord.
My lord, may I just request Well, may I just request one small thing? Well, it's five petitions were identified as lead petitions. The rest have all become intervention applications. Well, I'm all requesting is that 5 petitions may not be limited to 5 senior counsel.
No, but that is decided and everyone else.
Well, it's not been decided.
Otherwise, then it will not be possible for
this
side of
one of the 5. Lord, we can't object to that.
Well, I'm saying this that in previous practice of this court has been to give a certain amount of time.
Thanks.
And then
Mr. Sibal has said that he will take 2 hours. So we request him that he should have a meeting with all of you and you decide as to how.
I think we have to subordinate our personal thing for a larger issue. Let one or two counsels.
That's what we say, that it is very difficult to control the. I'm sorry, I also belong to.
I'm saying we have to suppress our own personal urges.
After 24th November, I will also be that side. But our experience of all the judges who come from opposite court has been that the bars there are much more disciplined.
well, if we could combine 5 or 10.
Really difficult to.
I agree, but I think when from Madhya Bharat in particular, even the high courts, the decorum is something which is unbelievable because
you also have the experience.
Coming from Gujarat, follow Bombay practice and it's completely different.
Bombay bench and Nagpur bench is like one is like a circus and one is like a bench with great decorum.
But I must say that
we always see that
this has changed now. It never used to be like this.
Here it is. We are taking so much time.
Yes, I know.
Only to fix a date.
On a lighter note, can I suggest, my lord, to remove this difficulty? Please stop live streaming of this matter.
That's what I said.
I've advocated that all for a long
What should we fix the time? Why should we fix? What should we fix each hour?
We are giving 2 hours this side, 2 hours to that side.
Correct.
And on Tuesday, then we'll keep only this matter.
That's right.
But then it should not happen that for A reason or B reason, it doesn't go ahead and then we are left with no work.
No.
No.
No question. No
Lord,
question.
Mr. Sibal may share his note with us today.
Yes,
And we will file it by Sunday, my lord.
Yes, Sunday morning.
Since we live at a distance of 16-kilometer distance, I live in 16 kilometers distance.
From here? No, but why? You will be in Luton's.
But that is, I could not.
No, but you must be in the Luton's.
Yes.
The Luton's is not 16 kilometers away from here.
My lords.
I can attest to the proof that he's a very good Lutyens. No, but you are living in Lutyens. You are living in Lutyens.
But Lok Sabha also is in Luton's zone.
Yes.
India and Mr. Sibal, that's my distance. I have to go back. Today I will do, again I will go back.
We are all accountable, my lord. We are all accountable in some way or the other.
The constitution.
I was not arguing to fight. Kindly reconsider, man.
There's already a member of the Joint Parliamentary Committee in the 5 also, ma'am.
Anyway, let's leave.
No, you have already contributed. Now let others.
Coming Tuesday, madam.
Mr. Banerjee, your contribution would be either used by this side or that side. So
Correct.
it will be there.
States also.
Kerala.
Yeah, he's right. He's supposed to be right. The rest of the states are not having any problem.
No, that's not right. That's not right, my lords.
I will try and echo his sentiments, but he should not be worried. I'll try and echo them.
Grateful, my lords.
Lord, they may give it today so that we can give them on Sunday. They get enough time.
Need a
So you can just hand it over to.
time to accumulate.
No, it is ready. Mr. Sibal has made it ready. You must trust Mr. Sibal's note.
The note
I
I have
have
to.
That note we can hand it over to the learned solicitor.
Yes, we will. We'll circulate, mother.
Okay, you make the note final by tomorrow evening. Make the note final by tomorrow evening and give it to the learned SG and let the learned SG give it by Sunday evening. Or Monday evening.
Saturday, my lords.
Saturday we'll be able to give, not tomorrow, mother.
Okay, Saturday, but then you will have only one day or
The Saturday,
Then
Sunday,
Monday morning, my lord, we can, one day evening.
Monday evening you can give.
Monday evening.
See, that's fine.
Very well, that's fine.
We are not putting it on record, so but it is understood that by Saturday evening your note will go to Mr.
Definitely.
Yes, ma'am.
And both the notes will come to us by Monday evening.
Yeah, definitely.
Would it be Monday afternoon?
We will be filing by Monday afternoon so that it.
We'll try and
reaches
get
your
it
lordship.
earlier also.
Otherwise, it doesn't reach.
We can give it in a physical copy to the court.
To the court master,
yes.
we schedule.
We'll do that.
That will be better because here if it is filed here, then here that file might.
Yes.
9 o'clock, 10 o'clock. So.
That's right, that's right.
So traveling from here to here takes one of the entire route rather than.
We'll do both, we'll upload it and give the copy.
Yes.
Physical copy.
Right.
My lord, now that that's a judicial order, my lord, we can do nothing.
Rather than having any matter as a lead matter, let us have the issues which are required.
Exactly, my lord. Let
Your Lordship's kind permission, my lords, if I may take the liberty of mentioning item 25, my lords. There was some urgency here. These are medical candidates who've completed their MBBS course, but they are not getting their certificates. They are missing their PG courses and they are not able to get their license to practice. If, my lord, I understand that today it might not reach. So, my lords, if, my lord, in the next 2-3 days, my lords, if,
Next week we'll direct it to police.
my lords, if possible, if Friday is possible,
Monday, Tuesday, next.
my lord, then Monday. Please make it Monday. Obliged.
Well, a similar request.
That's my matter, but I'm the petitioner. Friday.
My lord, then Friday, if my,
You can't start your vacation so soon.
Please go by whatever your lordship declares, Lord. Don't outside ourselves.
my lord, please make it.
Tuesday?
No,
I was saying Friday if it's possible.
Friday, yes.
yes, my lord, if your lordships then.
How you can't start your vacation because we don't know what will be.
My lord, just a 5-7 minutes on Friday, my lord. We will.
We know we have 5-7 minutes.
This is not where fees not 1 year was fixed 11.50, then 8.50, then again
No,
11.50.
that, my lord, we will correct that.
Students want to remain, not pay the difference.
No, that is not correct.
They're going to take time. This is not a matter.
No, my lord, we will, because we are going to show that whether even if we do not succeed, my lord, they have excess with them and they are denying us even our
You
internship,
are appearing for whom?
the medical college.
Not for medical.
Yeah, for the student.
No, we are for the medical students.
Friday.
Most obliged.
Well, a similar request in item 26. This is the challenge, Milos, to NEET PG 2025 exam, Milos, where they are conducting 2 exams for Milos, in 2 shifts. We had challenged that. Your Lordship had kept it specifically for today. Your Lordship have it tomorrow or day after, Milos. The process is at a very advanced.
Thursday, Friday.
Thursday.
Your Lordships, may I kindly please mention item number 32, Millets. Parties in this matter, Millets, had settlement and the settlement had been placed on record by the mediator, Millets. Now, the only aspect that the terms have been complied under the settlement, Millets, the amount which was directed to be deposited with the registry, Millets, may kindly be released in favor of the respondent.
Take a day after.
Day after tomorrow, Millets. Great.
Just one clarification. Originally, when I said, Malats, that the requirement was registration only in 54, I was right. Actually, 1923 Act doesn't have a requirement of registration. There was an order of the court in that case saying that all Waqf properties give a list to us and we will put them up. But the Act didn't have any requirement. So you also may change that from 23 to 54 months.
What you said, 54 was right.
Yes.
Because of.
We always doubt ourselves when somebody says you may be wrong. So, yeah.
We are all human beings, can happen sometimes.
You know, we're all fallible.
Yes.
There's one interesting thing that I wish to point out. Just have a look at this, please. Can you give it to the board? Give it to the other side also. It's very interesting. Yeah, just take it. Now, this is a list taken by us from the ASI website, Mullahs. And you lordships will see now, the moment they are protected monuments, they lose their character as Waqf. So this includes Sambal Mullahs. Item 3 Mullahs. Jama Masjid Sambal. There's a matter pending, declaration made, and the Waqf character goes. So legislation, in a sense, resolves a judicial dispute pending. That's the extent of the impact of this. And this is not the entire list, Mullahs. We only got some. And we've given the serial numbers, Mullahs, in the ASI list itself. Very disturbing.
Yes.
Number two, Mullahs, just wanted to point out that 3D as the section was not circulated in the bill. The bill didn't have 3D. It was introduced in Parliament during the voting. It wasn't even before JPC. 3D and 3E. 3D and 3E. Not in the original bill circulated. No discussion, no time for discussion. Not even in the JPC, naturally, because if it's not in the bill, where would it be in the JPC? So these are very disturbing features, Mullahs, that...
But even in Parliament, there was no discussion.
I'm sorry?
Even in Parliament, there was no discussion on 3D and 3E.
No, it was just when the final bill was passed, they introduced the amendment without debate. Passed. Suspending the rules, inserted 3D and passed. Because your Lordship knows the Speaker and can suspend the rules. So introduce 3D, introduce 3E, get it passed because you have majority.
At the time of voting, it was introduced and passed.
Yeah, naturally, at the time of voting, you suspend the rules, you introduce this just before the voting. It can't be during voting, just before the voting. Yes. The question is that, of course, we can never challenge the legislation on the basis of malafide, as your Lordship has held it time and again, Mullahs. But these are very disturbing features which ought to be taken note of, Mullahs. Of course, ultimately, in the final hearing, your Lordships will hear us on this. But that's number one. The suspension of rule, Mullahs, page number 102. Just note that, Mullahs, in writ petition 276 of 2025.
Writ petition number?
226 of 2020, 276 of 2025. First matter, Maulana Arshad Madani. 276 of 2025. At page 102.
Kindly record his statement that 3D was not discussed in JPC. Nothing turns on that, but kindly record it.
Yes, we have recorded this. Therefore, we are recording each and every proposition.
I'm saying on instructions, Mullahs.
Section 3D and 3 not circulated in the original bill. No discussion, no time for discussion either in JPC or in Parliament.
It's correct.
I'll answer, my lord, whether that can affect the validity of a
So
legislation.
that's a separate issue.
Factually, kindly, my lord.
I'm not saying whether it doesn't. No, I know that, but there is no, in the JPC, 3D is not circulated. I know that. 3D is not circulated. Nor is 3E circulated. Now, let us kindly see 102. May I just read it? Or in the lead petition, page 102. What is the date of this?
Yes.
Now, kindly see, Mullahs, the law minister says that this house do suspend. I of 80. My lord has that? Yes. In page 102. Justice Masida.
You read it out.
Sorry.
I'm sorry, Your Honor. So this House do suspend clause I of 80 of the rules of procedure and conduct of business insofar as it requires that an amendment shall be within the scope of the bill and relevant to the subject matter of the clause to which it relates in its application to. Now just note it, Mullahs, and they suspend it, and then note the date, Mullahs. Wide amendments list number 11 circulated on 2/4. Losses have that date? And this is cleared on 2/4. Suspended, circulated on 2/4, cleared on 2/4.
अच्छा 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 समझ गया मदनी no notice to anybody.
This amendment may be allowed or moved.
You give me a copy.
Yeah, I will give you. No, it's in the petition, page 102. It's page 102. Anyway, just what the impact of that is, we'll see later. Now, Malas, just one other thing. Kindly come to 1995 Act for a minute. Just give it the 1995 Act. Yeah. Yes. Now, just see that, 2025 Act, your losses may take. I know. Amended by 2025. Yeah. Then if you look at the 95 Act, just look at section 4, Malas. Survey. So that's what you want to show? Show the survey. 1995 Act, survey. So previously, Malas, the regime was, there used to be a survey. And after the survey, Malas, the items identified had to be registered.
After survey?
The items identified, that is the Waqf identified, would have to be registered. There was a very, very, very elaborate procedure. Your Lordships will have it in the footnote of the 2025 Act. Preliminary survey of Waqf is removed, Mullahs. And if you look at the 95 Act, you will find that there's a whole survey provision. Your Lordships have the 95 Act or no?
Yes, we have.
The unamended one.
Unamended we don't have.
Yeah, just give it to my Lords.
But then the footnote there is there. Prior to substitution.
Yeah, but what did the survey procedure involve, Mullah? I'm just mentioning that to you. His Lordships have it, no? Now, so therefore, what happens is, page Mullah 6, section 4. So you have to have a preliminary survey of Waqf. The state government, Mullahs, by notification appoints a survey commissioner. Then other commissioners are appointed for the purposes of making the survey. Then every state government maintains a list, and the survey of Waqf shall be completed within a period of 1 year from the commencement of the Waqf Amendment Act of 2013. And if it's not done, Mullahs, then provided that where no survey commissioner has been appointed, a survey commissioner shall be appointed. And then under subsection 3, there's a whole inquiry process. Survey commissioner, after making an inquiry, as he may consider necessary, submit his report. And what is that inquiry? Nature of objects of the Waqf, number of Waqfs, gross income, amount of land revenue, expenses incurred. So there's a whole very, very elaborate procedure. That's all I want to show to your Lordships. Now the survey commissioner is over. It's now replaced by the designated officer. The collector now. That's all, the whole process is over. Right? And then let's to section 5, publication of list. So once the survey is done, section 5 of the 95 Act says that list will be published. Yes. And none of this relates to registration. This is to find out what are the Waqf properties in various parts of the country. And then 5.2 will say the board shall examine the report and forward it back to the government within a period of 6 months. And then 5.3 says the revenue authority shall include the list of Waqf while updating the land records. So there's a whole very, very elaborate process. Then comes, Mulad, section 36 of this very act. Thereafter, the registration is done. Yeah, then 37. Many course are any confused with that. It's always better for them to look at the and leave it to me, non-balance. Leave it to me. I have some experience in
Section 36 of 95 Act.
Yes, of the 95 Act. So there's a survey procedure, then there's a list that is prepared, and then the registration happens, which is under 36. 36 says every Waqf, page 27, whether created before or after the commencement, shall be registered at the office of the board.
Registration is not introduced for the first time in this act.
No. It's been there for a long time. I told your lordship, right from 54. It's just the consequence is only quay the mutawalli. And earlier also surveys were done. Yeah. Survey was introduced in 64, Malad. Registration was in 54, survey was introduced in 64. And that's constantly been happening, Malad, under every subsequent act, Malad, amended. Then, Malad, the decision if a property is Waqf property. Then, Malad, the board itself, section 40. So whatever is surveyed will be registered. For what is left out, the board itself can collect information. And that's section 40. This also removed. Survey removed. Registration requirement remains. 40 removed. If the board has reason to believe that property, if any, arises whether a particular property is Waqf property or not.
You're reading?
That's 40, section 40. And the board was given the power to decide that question on its own. Why? Because the board were consisted of Muslims and elected. And they could call for information and decide if it's left out anywhere. So that was the regime, Malas. Now that's all done away with. Now the power is with the collector. So collector will, what surveys will the collector do, Malas? No, 37. 7A. Yes, I will. Now let's connect this to section 36, 7A of the present act, of the 2025 Act. So that survey provision goes, Malad. And 36.1 says, every Waqf, whether created before or after the commencement, shall be registered at the office of the board. That's 36. So, Malad, and then, Malad, subsection 7 says the following. At page 34. So, it shall be registered. And on receipt of an application for registration, the board should forward the application to the collector So your lordship knows then, Malas, that the survey and all is over.
You're reading section?
Section 36, 1 and 7 of the amended act.
It's amended.
Yes, my lord. So 36(1) talks about registration, no? Every Waqf, whether created before or after, shall be registered. And then 7 says, at page 34, my lords, on receipt of an application for registration, the board shall forward the application to the collector, having jurisdiction to inquire into the genuineness and validity of the application and correctness of the particulars therein, and submit a report to the board. So, my lords, all the survey procedure is just given a go-by to. Then, my lords, 7A. Yeah, it's all being recorded in any case. 7A says, where the collector in his report mentions that the property wholly or in part is in dispute. Now, let's connect this to 3R and 3C. Connect this to 3R and 3C. Can be any dispute raised by anybody. So where the collector in his report mentions that the property wholly or in part is in dispute or is a government property, the Waqf in relation to such property shall not be registered. So if somebody says this is disputed, even if I want to register it, I can't. This is what is called wholesale takeover, Malads, of a community's right. Wholesale takeover. I'm going to. Really, I will. 8. Subsection 8, I'm sorry, Miss Justice Massey has that. It says, in the case of Waqf created before the commencement of this act, every application for registration shall be made within 3 months from such commencement, and in case created after such commencement, within 3 months of the date of creation. And then 10, Malads, which is very, very problematic. No suit, appeal, or other legal proceeding for the enforcement of any right on behalf of any Waqf which has not been registered in accordance with the provisions of this act shall be instituted or commenced or heard, tried or decided by any court after expiry of the period of 6 months. So you don't register me, then I can go nowhere. I can't file a suit, I can't file any proceedings. So my fundamental right to litigate is lost. My property is taken over and I can't litigate on that property. And this is through legislative fiat without a procedure. Nothing can be more violative of 14, Malad, manifestly arbitrary. So now connected to the 83 provision. Designated officer under 3C, higher than the collector. If he says it's in dispute, it's government property. Right, Malaj? Then that dispute, Malaj, takes away the character of the Waqf as long as the dispute is pending and his report is pending. And after that, it goes to the revenue records. And then I have to go to the tribunal. But if it's not allowed to be registered, I can't even go to the tribunal. Because no suit, no proceeding shall lie. And connected to 3R then, because 3C deals with government property and government organizations, panchayats and all. 3R says any dispute. So the consequences of this act are take over the property of Waqfs, take over the community's property, and then don't allow them a remedy also. And by the time the aggrieved party in a particular case goes to the tribunal, then 10 years will pass, and that's the end of the matter. So therefore, valuable property across the country where for charitable purposes, religious purposes, mothers is just taken away. The perpetuity of the Waqf is lost. And the fundamental of Waqf is...
But then, whether this provision even under the earlier acts, the registration was compulsory.
Yes. Yes.
Oh.
This provision was not there, Malas.
No, so whatever properties are registered prior to the commencement of this act.
It was there, it was not implemented.
Beta, we requested you in the beginning itself.
Sorry, my lord, but it's.
We requested in the beginning that we will.
Something troubling, my lord. Anyway, I'll point out when my turn comes.
Thank you. Yes, Malas, your lordship is saying something.
No, earlier the next was also provided for registration.
Yes.
All such works which are registered prior to this commencement of this act, they would not be affected by this provision. Only such of the trusts which were required to be registered but have not been registered, they have been given a breather of 3 months.
No, but if there is a dispute, Malas, then that's the problem. Your lordship is right. But supposing there is a dispute, then what happens?
3D in the retrospective.
3C,
yes.
That makes it problematic. R. 3R, 3C makes it problematic for user. I'm going to read that.
We have 3 months. There is also an onus on the state government to conduct a survey. If the government has failed to conduct the survey, then why should the community pay for it?
Right.
This image registers they again have to submit the details.
Discretion is kind of limitation.
That's why you say is abolished. So, Malas, Waqf by user done away with. On the registration part, your lordship knows registration is required to give the name and address of the creator. I don't do that, no registration. If no registration, no remedy. Where Malas registered Waqfs? I'm talking about registered Waqfs now, Malas. Your lordship asked me that question. If registration is done prior, then I have to give this detail, name and address of creator of Waqf. If I can't do that, not registered. Not registered means the 7A and 10 will come in. And the collector will say this property is in dispute. Apart from that, because 7A says property in dispute. So if property is in dispute, it will not be registered. If not registered, then section 10, subsection 10 comes in. So, Malas, where's the remedy? So you can't, Malas, put the community in a slot, enslave it, don't allow them any leeway, take away their property, don't compensate because it's private property, it's not public property, it's my property, don't allow them a procedure to vindicate my rights. You don't have to go to the tribunal, that I have to go to the tribunal. Until kingdom come, that matter will not be decided. And I guess I'm being facetious. The same thing, Malas, now 3E. Now I've done with 3D, I've done with the others. Now just come to 3E, Malas. Same thing happened as far as 3 is concerned in the parliament. 3E and 3D both. Now, Malas, I've given to your lordships my submissions.
It's a spiral bound note which I gave, Lord. It's in your lordship's note.
I'm not going to read them, Malas, because I've argued all that already. So I just want to show you an annexure. My written note. Kindly see page 18.
Of your note.
Of my written submissions, Malas, which has all that I've argued before your lordships is there.
So you want to refer to the spiral one or
the spiral one?
Spiral.
Nothing is the same.
I don't have annexed. I'm not making an issue. Just give me annexed.
Sure, give it to me. It's there, Malas. Page 18, it's part of the submissions.
Responded to this.
He has already responded.
No, not this. Oh, you got it without it.
Copy, I'm not raising an issue.
No, fine. We have another copy. Not an issue. I'm sorry if that's happened. Kindly see 18, Malas. These are the list of scheduled tribes with Muslim population. I just wanted to point that out because that's what's reflected in 3E. And various states, Malas, I've set out the states also.
Schedule 5 provided.
Malas, most of the submissions I'm not going to other provisions of the Act because that will require further elaboration. These are per se violations, per se. Now read 3E, Malas, when I've done with 3, I'll have to read the section. That's at page 10 of your Lordship's book. Notwithstanding anything contained in this Act or any other law for the time being in force, no land belonging to, 3E, page 10 of the Act, 2025, as amended. Notwithstanding anything contained in this Act or any other law for the time being in force, no land belonging to members of scheduled tribes under the provisions of the 5th and the 6th schedule shall be declared or deemed to be Waqf property. So I've shown you the list, Malas, so they lose their status as Waqf.
In the 5th schedule
And the 6th schedule. This is per se bad. Then kindly come to section 108. No, wait. Kindly come to 108. Now, this is an interesting provision. 108 deals with evacuee property, a gift from partition bullets. Page 79 of the statute that your Lordship has. Now, Now, 108 Malas provision is omitted in this Act, which is, we have a look at the footnote, Malas, what it was. This is in the 2013 Act. The provisions of this Act, at the footnote. The provisions of this Act at page 79 shall apply and shall be deemed always to have applied in relation to any evacuee property within the meaning of clause F of 2 of the Administration of Evacuee Property Act, which immediately before it became such evacuee property within the said meaning was property comprised in any waqf, and in particular any entrustment, whether by transfer or any documents or in any other manner, and whether generally or for a specified purpose, of any such property to a board made before the commencement of this Act, in pursuance of instructions of the custodian under the Administration of Evacuee Property Act, shall have and shall be deemed always to have had, notwithstanding anything contained in any other provision, effect as if such entrustment had operated and vested in such board. So all evacuee property, which is a gift of partition, vested with the board. So now all evacuee property, which is waqf property, waqf, once a waqf, always a waqf, is taken over by the government. Now, Malaj.
No, sorry, please.
No, I won't.
I didn't get your point on this.
Malaj, 108 is eliminated. It's still evacuee property. It's waqf property, Malaj, but it's evacuee property. It was waqf, people left. It continued to be waqf property. Once a waqf, always a waqf. So in 108, Malaj, it says that that property, which was always a waqf, would be given to the board. instead of the administrator would be given to the board. Why? Because it's Waqf property and the board has to administer it. Then 3C will come in.
That may be so.
Yes.
The thing is, it was mandated to be registered.
Yes.
So obviously, if it is registered, then it continues to be a Waqf. How does it go back to the
Evacuee property, Malas, no, it will not be.
No, it would.
It will go to the custodian.
Every Waqf had to be registered.
Right.
So if it is a Waqf, it had to be registered.
I appreciate what my lord is saying, but every evacuee property by law goes to the custodian for allocation.
Not relatable to the Waqf. As such, the principle is it goes back to the custodian.
Yes. Now, if it's Waqf, the custodian will not keep it.
Will keep it. Will go to
That's,
the board.
that's all that I'm saying. I'm saying nothing more than that. It will go.
Even if it goes back to the board, continues with the board in any case.
That's what we are saying, but it will not happen now.
But in any
Because
case, if it
3C
is-
will come in.
But any property which is not registered, obviously as a consequence of Section 3,
Yes.
are
That's right.
no more be a Waqf. That's your contention.
That's my contention.
You have to hear it.
You have to go back to, ultimately we have to go back to 3C. We have to go to 3R. We have to go to Muller's inquiry. All that will come in, Muller's. So basically, these are all interconnected provisions, the object of which is to take over Waqf properties. That's the object. And through legislative fiat, without a procedure consistent with the law. Well, it's not somebody else's property. That's really the heart of the matter. So, Mullahs, now I've done with all this. There are only two things left now, Section 9 and Section 14.
And 23.
CEO, you've already mentioned. That's not mentioned. Yeah, I already mentioned CEO. No, Mullahs, now Section 9 and Section 14. Yes. And then I have done, Mullahs. Now, I mentioned to your lordships that Section 9, if we read it now, that's at page 16, will have a majority, can have a majority of non-Muslims. I know. Yeah. Just 95 Act provision, they were all Muslims. Sure now, yeah, sure.
Yeah, right.
May I, Mullah? Now, let's kindly come to Section 9 and kindly look at the Section 9 as it was under the 1995 Act. And you will find in the footnote, Mullahs, the following members to be appointed from amongst Muslims. You see that at page 17 bottom. Last line at page 16, bottom, Mullahs, prior to substitution, subsection 2 stood thus. Worship has that? Right at the bottom, Mullahs.
The council shall consist of.
Yes, yes, prior to substitution. Right at the bottom in the footnote. That is the previous Section 9, Mullahs. I'm just showing, Mullahs, what the change is. Prior to substitution, sub-rule 2 stood as the council shall consist of union minister, following members to be appointed by the central government from amongst Muslims, namely all of them were to be Muslims, 3 persons who are eminent scholars in Muslim law, provided that at least 2 of the members appointed under subclause 1 to 7 shall be women. That's it. So, Mullahs, all of them had to be Muslim?
Judges. Even judges. Even members of parliament and judges.
Even members of parliament and judges had to be Muslim under the previous dispensation. It is true also of all the Hindu endowments, Mullah. They all have to be Hindu, Mullah. I've given that in my note also. Now, Mullah, if you look at the present section, which your lordships will find at 17 top, Union Minister in charge of Waqf, no reference to Muslim. 3 members of parliament, of whom 2 shall be from the House of the People and Council of States, no reference to Muslim. The following members to be appointed by the central government from amongst Muslim members. So 3 persons to represent Muslim organizations, chairperson of 3 boards, that is 3 by 3 by rotation, so therefore 3 and 1, 4. 1 person to represent Mutawalli, that is 5. 3 persons who are eminent scholars in Muslim law, 8. Correct, Mullah? So the total number of Muslim members are 8. These 2 judges of the Supreme Court or High Court, so therefore 2 there. 1 advocate of national evidence, that's 3. 4 persons of national evidence, that's 7. Additional secretary or joint secretary, that's 8. And Mullahs, the first 3, union chairperson and 3 members of parliament, 12. So it's 12 versus 7. So you can have 12 non-Muslims in a situation and 7 Muslims. And the previous acts are all Muslims. So in other words, the administration also is taken over. Proviso says only about 2 members of excluding shall be non-Muslims. So that's the ex officio members. That's right. Provided further that 2 members appointed under this subsection, excluding ex officio members, shall be non-Muslims. At least 2 and up to 12. At least 2 and up to 12.
So it doesn't say at least, provided further that 2 members
appointed under this subsection, excluding ex officio members,
shall be non-Muslim.
That's correct. Excluding ex officio members. So union minister is ex officio. Other may or may not be.
But then how do you say that there would be majority?
Because we are here, we are 10 only, 7.
So ex officio would be 1.
Only 1.
So the union minister can be both, either a Muslim.
No, it's excluding ex officio members, it says.
Yes.
Shall be non-Muslim. So it will exclude the minister.
Main minister in charge of the work is ex officio.
Yes, he's excluded, Mullahs. He'll be non-Muslim. Then 3 members of parliament.
So the other ex officio is only additional secretary or joint secretary.
That's correct. They'll be non-Muslims, they say. At least 2 of them says, no? Provided.
There is only 1.
No.
Additional secretary or joint secretary.
Above 3 members of parliament also, Mullahs.
They are not ex officio.
No, correct. Correct.
They are not ex officio.
But there are no requirement that they'll be Muslim. That's the point.
Let us read the category one by one.
Yes.
Where the Muslims are
union minister, Mullahs, will not be Muslim.
Either a Muslim or not a Muslim.
No, it says shall be non-Muslim, excluding ex officio members.
Where is union minister in charge of work? A chairperson, ex officio.
Maybe, may not.
Either a Muslim may or may not be.
But that's their choice, Mullah. The point I'm making is that's their choice.
The cabinet doesn't remain same for the entirety.
No. That's not true in any other enactment, any other Hindu endowment, Mullahs.
So that you will examine. You are saying that by this composition, the majority would be
Theoretically. I'm not saying.
Let us examine.
That's right. That's what I'm saying. Now, let's assume that they'll be non-Muslims. Why your lordship is assuming that?
Let us say union minister in charge of work are non-Muslim.
One Mullahs. 3 members of parliament, non-Muslim. 4.
No. What does it say?
Maybe may not be, Mullahs.
Maybe may not be.
So I am assuming, Mullahs, they may not. Mullahs, I am theoretically.
Let us see which are ex officio and which are not ex officio.
Correct.
So there are 2 ex officio.
Correct.
One is
Point secretary.
One is J and one is G.
Correct.
So assuming that there are 2, both of them are non-Muslims.
Yes, we'll assume that.
Yeah. Then under the proviso,
yes,
excepting ex officio, there can be 2 members.
No. 2 must be, Mullah.
Better we will call upon you when your turn comes. Don't show the enthusiasm as Priyanka is showing that side.
I will make sure that I don't remind you of anything while you're.
Let us read it further.
Yes.
There were 3 members of parliament, of whom 2 shall be from the house of the people and
Correct.
1 from the.
They may be non-Muslim.
They may not be.
That's 3. That's 3.
No, not 3. Provided that the 2 members, 2 of the members appointed under.
House and 1 from Council of States. Well, so 3.
No, it doesn't say. See, provided further that 2 members appointed under this subsection, excluding ex-members, shall be non-Muslim. So it doesn't say at least.
Kindly see. Previous provision said 3 members of parliament shall be from amongst Muslims. In the footnote.
So B could be Muslim, non-Muslims also.
That's what I am saying, but he can be non-Muslim. I am not saying.
So let us see where there is a possibility of non-Muslims being there.
Therefore, the possibility is 1 chairperson, 1, and 3 members of parliament. Possibility of being non-Muslim, that's 4.
Yes.
Correct, Malas? Now you come to the Muslims.
3 is all Muslims.
3 plus chairperson of 3 boards by rotation, so 1, 4. 3 and 1, 4, Malas, by rotation.
Then 1 person.
Then 1 person to represent Mutawalli is 5. 3 persons who are eminent scholars in Muslim law, 8. Correct? Now, correct. So therefore, 8 maximum Muslims. Right?
No.
Minimum. 8 minimum Muslims. Correct. When I am assuming that all the others are non-Muslim, that's how I'm arguing.
So 8 minimum.
8 minimum.
Yeah. 8 guaranteed.
Guarantee. That's the only guarantee we have in this statute. No ambiguity. Then 2 persons who have been judges of the Supreme Court.
So B could be either Muslims or non-Muslims.
Earlier they were all Muslims.
I agree. I am not disputing there could be Muslims. I am saying we are assuming now that they can appoint non-Muslims, that they are not prohibited to appoint.
No, but let us see. So that 3, then
3 plus 1, 4, Mullah. Chairperson plus 3 members of parliament, 4.
Let us exclude chairpersons and the secretary.
That's 4, Mullahs. Then you come to 4 persons of national eminence. That's 8.
2 persons who have been judges of the Supreme Court or High Court.
Yes, that's 2. Non-Muslims can be.
Non-Muslims.
So therefore 4 plus 2, 6.
Yeah.
Then 1 advocate of national, that's 7. And then 4 persons of national level, that's 11. That's what I was telling your lordship.
Secretary 12.
An additional secretary, 12. That's what I was saying to your lordships.
Provided that 2 of the members appointed under subsection C shall be women.
Correct.
Now let us see, provided further, that 2 members appointed under this subsection, excluding ex-officio members,
shall be non-Muslim. Correct.
So the number is restricted to 2. It doesn't say at least 2 or it says there are 2 or more.
It's not limited to 2, but that's the minimum, Maharaj. The maximum we can have a guaranteed ones are 3 plus 1 plus 1 plus 3. 8. That's all. Theoretical. I'm not saying that they will not be Muslim.
The second proviso, the word used is 2. It doesn't say at least 2.
Excluding, Maharaj. Excluding the ex.
It says excluding 2. So at the most, if this 2 plus 2 ex officio, it will be 4.
That's correct. That's correct. But they may not all be Muslims, Maharaj. See the previous section in the note, Maharaj, what it was. It's best we appreciate that, Maharaj.
Let's compare it.
Compare it. Let's compare it. Excluding yes.
The same people will make money. It's a preceding thing.
Yeah. All of these were read with the line. I'm going to say, don't let them.
Keep again. Clear.
Now see whether the previous provision in the footnote. Now it will make it clear, Malas. The council shall consist of union minister in charge, ex officio. The following members to be appointed by the central government from amongst Muslims. So therefore, 3 are Muslims, 4 are Muslims, 3 are members of parliament Muslims.
Right, when you say that all these have to be earlier. Now, the only distinction which has been brought about is that there can be 4 people, 2 ex officio and 2 further people. That's the only.
No, my lords. No, your members of parliament need not be.
Therefore, maximum I'm saying 4.
There can be 12 non-Muslims because members of parliament need not be Muslim, my lords. The proviso, it doesn't say that the rest of them will be Muslims.
Proviso also does not say.
Yeah.
Because it is restricting non-Muslims.
I'll let for a moment assume, my lords, what the observation that's fallen from your lordship is right. I'll assume that, my lords. I'll assume that for the moment. If it is right, my lords, then what it means is that they can have at least 4 persons that are non-Muslims.
Yes.
That's what my lord is putting to me. Now, it's a departure from what? From the previous law where everybody had to be a Muslim? Correct, my lords?
Except the ex-officio chairman.
Yes, exactly. Except that one, everybody had to be Muslim. So they have departed from that entire regime. And your lordships are now interpreting to mean that other than these 2, everybody else will be a Muslim apart from the other 2.
So because your argument primarily was that the majority would be.
I see. Could be. That's, I still maintain that, Mullah. Could be. Unless your lordships were to interpret that in such a way that everybody else has to be a Muslim, which is not reflected in the statute.
No, because the board uses second proviso, provided further that 2 members appointed under the subsection excluding ex-officio members shall be non-Muslim.
Correct.
So if the word 2 members would have been preceded by at least, then there might have been substance in your contention that at least 2 and it can be up to all those. But it says only,
all right.
It specifies the word 2.
All right, let me assume that. That's against myself for a moment. Let me assume.
We can interpret it in such a manner that there can't be more than two members except the ex-officio from the non-Muslim category.
Correct. Anyway, according to me, 2 is too many also. But the reason why I'm saying this is that
2 is not too many in 22.
Every
2 is not too many in 22.
every religious endowment, Hindu endowment, does not have one person who is a non-Hindu.
Yes. Scholar, you know the Quran.
Not one person.
You must be aware about the debate going on about Bodh Gaya.
But that Bodh Gaya is Hindus and Buddhists, both.
They are only Hindus.
Both. The place of worship is for both. Act itself says that. I knew that example would come, Mullah. The Act itself says that. But that's the only exception, but the Act itself says it. In all other Hindu endowment, there cannot be a non-Hindu. Same for Sikhs, Mullahs. Gurdwara Prabandhak Committee. Nobody can be who's a non-Sikh can be part of it. So why this exception? Assuming, Mullahs, that we interpret the section in a manner that only 4 will be non-Muslim. We'll assume that. But why should there be 4? Why should they be there at all? If you are giving that privilege to other religious communities, why are you not giving that?
That's a different argument.
I'm putting it like.
It's a different argument also.
No, I'm saying on interpretation, I believe, but anyway, that your lordships can do it after the final hearing. At the moment, my request is nothing should be done till your lordship hears all these matters, Mullahs. Now, it's even worse, Mullahs, as far as the board is concerned. Now come to 14. Bodh Gaya Act in 11.1, it says Buddhists of every sect shall have, notwithstanding anything contained in this act or the rules framed thereunder, Hindus and Buddhists of every sect shall have access to the temple.
It's a place of worship of two.
Because it's a place of worship of 2 communities, both Buddhists and not only Buddhists.
And the composition is here only either Hindu or Buddhist.
No non-Hindu or no non-Buddhist can go there even. So, Mullah, that's the scheme of a secular nation where you allow the community representation within the construct in terms of which the...
What are the functions of the council, by the way?
Sorry?
What are the functions and duties of the council?
Advisory functions. Advisory functions.
Are they given a role to
Yes.
interfere in the management of the particular work?
Yeah, your lordships will see. Advising the central government and boards on matters concerning working of boards and due administration of Waqf. Both. That's section 9, subsection 1.
So, section 5.
Yes, I'm going to.
Any dispute?
They can issue directives, Malad.
So advisory on matters concerning the working of boards
And Malad.
and the due administration of work. So
Administration of the Waqf.
they can only give advice.
No, administration also. 1A, see 1A, Malad.
Advice with regarding to the administration.
Just see 1A, Malad. The council, 9(1)A, council referred to in sub shall issue directives to the boards on such issues and in such matter as provided in subsection 4 and 5. Directives also. And what is 4 and 5? State government shall furnish information to the council on performance of Waqf boards. It's a direct interference in the administration of the board.
I will go to the Chief Justice.
And any dispute arising out of the directive shall be referred to a board of adjudication to be constituted by the central government to be presided over by a retired judge of the Supreme Court.
Substantive dispute.
So, Maharaj, these are huge powers vested in the council.
We will call upon them.
That's right. So now, come to now 14, Maharaj. Now, Maharaj, if you look at 14, all of them are nominated. No election. So all of them, in fact, boards are the entities. Board is the entity which actually administers, and all of them are nominated. Right. I don't have to read the section, but it's exactly the same as the council, Maharaj. The same provision. But except that these are all nominated. Now, let's. And that's all right, but they will be nominated Muslims. No, that's what I'm trying to say to you.
Earlier it said has to have been Muslim.
I'm trying to say that only. You are insisting on something. Earlier it was elected, now it's nominated. That's all I'm trying to say.
Here there is only one ex-officio.
That's right. That's correct. Only joint secretary to the state government. But all this is nominated. Now, let's see the previous section. That is at page 20, in the note. The board or the state, for a state and the national capital territory of Delhi shall consist of a chairperson, one or not more than two members as the state government may think fit to be elected from each of the electoral colleges, consisting of Muslim members of parliament. So even members of parliament will have to be Muslim from the state, or, as the case may be, by the national capital territory of Delhi, Muslim members of the state legislature, Muslim members of the Bar Council, provided that in case there is no Muslim member of the Bar Council or the Union Territory, state government of the Union Territory may nominate any senior Muslim advocate, mutawallis of Waqfs having an annual income of so-and-so. So, and one person from amongst Muslims who has professional experience in town planning, one person each amongst Muslims to be nominated by the state government from recognized scholars in Shia and Sunni Islamic theology, one person from amongst Muslims to be nominated by the state government from amongst the officers.
So this election is only restricted only to one or two?
Two.
One or two.
One.
So it can be minimum one or maximum two to be elected from four categories.
Number of elected members shall at all times be more than the nominated members of the board. Right, Mulad? Page 20, at the bottom of 21. Clause 4, Mulad. Earlier clause 4. At the bottom. Last clause.
Page 20.
Page 21. Footnote. The number of elected members of the board shall at all times be more than the nominated members of the board, except as provided in subsection 3. And you see here, Malaj, one or more one and not more than two members of the state government may think fit to be elected from each of the electoral. That's correct.
So there could be one or two either from members of parliament.
That's right.
Then one or two from the members of state legislature.
Correct.
Then a bar council.
Yeah.
And Mutawali.
Correct. So the point is, Malaj, one, you start nominating the board, which is the central authority, which administers Waqfs. You nominate your own people.
So the power is not with the central government, power is with the state.
State, Malaj, yes. Yes, the government, Malaj. This power is the government, Malaj, either way.
State government.
Yes. Absolutely right. So that takes care of 9 to 14, Malaj. The very scheme of it suggests, Malaj, that you want to exclude us from every facet of activity in relation to the Waqf. So we are here now, Malaj. Anything else? Yes, Malaj, just so that your lordships may note it, I've given at page 11 of my note, Malaj, the spiral bound note, I've given Religious Endowment Acts. Just come to page 11. Even ex-officio members have to be Hindus there, Malaj. There can be no exception. But both the I see you was mentioned earlier.
53.
Page 11, if your lordship notices, Malaj. So, you want to take a minute? You want to take a minute?
Maybe.
Okay. You'll lordships have page 11 of my note. You will see there Religious Endowment Acts, Andhra Pradesh Act, Tamil Nadu Act, Uttar Pradesh Kashi Vishwanath Temple Act. It starts from page 8. The annexure of it is at page 19, Malaj, of these acts. So all of them, even the ex-officio member, have to be Hindus. The idea is, Malaj, it's not about discrimination. Idea is this is part of my right to manage the affairs of the community. So it's part of 25 and 26. And that is all subject to health, public order and morality. None of this relates to that. Your lordship knows it says subject to public health, morality and public order. What has this got to do with it? So just as educational institutions administer their affairs, religious communities administer their affairs. The Hindus do it, the Sikhs do it. Well, why should the Muslims not do it? Christians do it. And this is not secular. These are mosques, these are activities that are directly, the very creation of the Waqf is not a secular act. The creation of a Waqf is not a secular act. It's the Muslim's property which he gives away and dedicates to God. Somebody else can do the one. You want to do the data, this thing? Huh? This 116%.
I've got other data.
Okay.
It's like 5, 10 minutes.
There's no problem, no problem. Malaj, I'm sorry.
Got it, add now I can add.
No, I'm not going to. Malaj, just one last thing. They have made a submission, Malaj, that after Malaj, this amendment, in 2013, there has been a 116% increase in the registration of Waqfs. And the idea being that how can it be between 2013, there's a 116% increase. Right, Malaj? Now we have an answer to that. They have not put it in their written submissions. Now you will deal with it? So my learned friend can deal with it. And Malaj, Dr. Dhawan wants to take a minute, no?
No, just a minute.
Just 1 minute, okay. And then you can do it.
I'll just take.
Okay. I'm deeply obliged to you, Lordship.
Just 1 second.
Yes, Doctor.
My lord, by straining my voice, I might strain your lordship's ears, my lord.
Sorry, we can put up the mic here.
My lord, traditionally when we joined the bar, there were no microphones.
Yes.
We were taught to address the bar in full throat, my lord. Anyway, just three sections that I want to bring to your lordship's notice, my lord.
Now also, when Mr. Ranjit Kumar argues in the adjoining court, we can hear him in this.
My lord, he's in a class by himself, my lord.
For someone else. Lord, during COVID, when we were appearing virtually, somebody said that, Mr. So-and-so, you are on mute. And I said, even on mute, he is heard.
My lord, just 2-3 sections, my lord, and then I will conclude, my lord. My lord, kindly turn to your lordship's book.
Yes, yes, to make an atmosphere light.
Justice Kuldeep Singh and Justice Verma were in the other two courts, Lord. And the summer, the doors were open, so they were listening from inside also, help inside. So, of course, there was no mic those days, 1996, 97. Both those courts could hear my voice. They had to close their doors and they stood.
Lord, there is a real life story. Mr. Dhawan, Dr. Dhawan would be aware. Lord, once Winston Churchill was sitting in his chamber in the parliament. And in parliament, it is believed, my lord, in those days, that in the lobby there used to be telephones to be used by the members of parliament to talk to their constituents in their constituency. And somebody was speaking very loudly. So Churchill asked him that, who is this man and why is he shouting? His PS said that he is talking to somebody in his constituency. Churchill said, ask him to use the telephone.
My lord, my anecdote is, I told Justice Ramanna, as he then was, that I don't suffer from blood pressure. So he said, you give other people blood pressure, that's the reason why. But at any rate, my lord, levity apart, my lord, may I take your lordships to section 104, my lord, which is on page 76
of the new act.
Of the new act. Yeah, page 76, yeah. I will, sorry. Now, my lord, your lordships will see the title is Application of Act to Properties Given or Donated by Persons Not Professing Islam for the Support of Certain Waqf. Now, kindly see, my lord, the original act that your lordships will see on the next page in a footnote. Permit me to read it, my lord. Notwithstanding anything contained in this act, where any movable or immovable property has been given or donated by any person not professing Islam for the support of a waqf, being a mosque, idgah, imambada, dargah, khanqa, maqbara, Muslim graveyard, choultry or muzaffar, then such property shall be deemed to be comprised in that waqf and be dealt with in the same manner as to the waqf, as the waqf in which it is composed. I'll make a point on this in a moment, my lord. Then kindly turn to section 23, my lord. I'll just read, my lord, the now, if your lordships will see that it says there shall be a full-time chief executive officer of the board to be appointed by the state government who shall be not below the rank of so-and-so. Now, my lord, kindly see the original section. There shall be, at the bottom of that page, my lord, there shall be a full-time chief executive officer of the board who shall be a Muslim. I won't read the rest, my lord. There are at least 12 sections of this act which deal with the powers, duties, and responsibilities of the chief executive officer. One more section and I'll make 1 or 2 points, my lord. Now, my lord, kindly come to section 2. This, your lordships, will find on page 5. Your lordships will see that a proviso has been added. Provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, retrospective, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for a purpose similar to a waqf under the law for the time being in force. My lord, I won't elaborate other than judgment after judgment of your lordships, my lord, have indicated that a waqf can be in the form of a trust. And eventually, earlier, my lord, the board decided whether it was to be a trust or whether it was to be a waqf. Now, this was a very important provision, my lord, right from Ratilal, the first decisions of your lordship, 7-judge bench. There has never been any doubt that if your objectives were in the form of a trust, similar, and those are the words used here, my lord, similar to those of a waqf, this will entirely and completely disappear. Now I will make, my lord, two very general points.
I didn't get you.
My lord, earlier, supposing I am a Waqif, my lord, and I create a trust which has objects similar to that of a waqf, it would be in the past treated as a waqf. Now, my lord, many, my lord, Waqifs put their objectives, ultimately, remember, my lord, it's the object of charity, object of religion. Now, if the object of the trust is similar to that of a waqf, and there were a large number of them across the board, my lord. Ratilal, my lord, is a case from Bombay. It dealt with the charity commissioners, and the issue once there was whether the charity commissioners would have control or whether the Waqf board would. And your lordships ruled that if it is similar to a waqf, then, my lord, it is not the charity commissioners who will appoint, my lord, the custodian.
But the board.
The board. Or the board as it then stood, my lord. Now, this is an important takeaway, my lord, because a large number of waqfs are in the form of a trust. What this does is, what was earlier a matter of form has now been removed as a matter of substance. Just 3 points on that, my lord, and 2 additional points I want to make.
What you are trying to say is basically that any trust would not be a waqf anymore.
That's right, my lord. Even if it is similar, even if it is, my lord, trusts are in their own area.
That's right.
There is a distinction between the two. Yes. But if it is similar to the nature of a waqf, it would be treated as a waqf.
Correct.
And there are a large number of such throughout India. Now, my lord, I have 2 more points to make, my lord. My lord, Mr. Sibal has already indicated, and this has never happened, my lord, in the past, of the redefinition of a religion and religious property. Never before, my lord. We go back to the Board of Revenue of 1810, my lord, of the East India Company. They didn't change the nature of the waqf property. Neither 1817 in Madras, nor in the 1923 Act, my lord, nor in the 1994 Act, nor in the 1995. What was the occasion, my lord, for this large-scale liquidation of the very concept of waqf? My lord, no religion in the world can survive apart from belief, practice, property. You take that away and no religion will have any longevity at all. So this goes to the heart of every religion, and it is only the Muslim religion where this property has been dealt with in this way. But that is not my only point, my lord. The important point is, my lord, it's an issue not just, my lord, as far as this is concerned. My lord, we are a secular nation. One of my clients, my lord, in the writ petitions not listed before your lordships, happens to be a Sikh. He says, I want to contribute to Waqf. I believe that this property should not be taken away. This is an issue which goes fundamentally to the question of secularism, Lord. Because Article 25 and 26, and I would add Article 29, the preservation of one's culture. That's right.
Article?
Lord, 29 as well, which is the right to preserve your culture. How would you preserve it, my lord? You preserve it on the basis of your beliefs, you preserve it on the basis of your practices, and on the basis of the property that sustains these beliefs and practices. Take that away, my lord, the entire secular edifice which your lordships, my lord, have built from time to time and time again, my lord, will also become suspect. One last point, my lord. Mr. Sibal has dealt with, my lord, classification, manifest arbitrariness. My lord, when you justify these changes, what is your justification? What your lordships, my lord, have laid down is the doctrine of proportionality. Where is the proportionality? Now they, on the other hand, says there is better effective management. At one stage in the counter, they say certain persons were not registering as Waqf by user. So, my lord, the question that your lordship might put to them is you want to achieve certain goals. It has to have a nexus that's established. Where is the proportionality behind the changes that you are now making in relation to the objectives to be achieved? And my lord, across the board, no justification has been given as far as proportionality is concerned. My lord, I adopt the rest of the arguments.
The pleasure hearing you after a long time.
I know, my lord. Even in my throaty voice. My lord, there's one small point, my lord. This act is in the teeth of a large number of constitution bench decisions of your lordship. Charity, Ratilal, Babri Masjid, my lord, para 1131, which says Waqf by user is a part of Islam. So it's in the teeth of a number of constitutional. Now, my lord, your lordship interpreted in TMA Pi the meaning of the word establish and administer.
It's 1134 paragraph.
1134. That is in M. Sadiq, my lord, the Babri Masjid case.
2021 SCC, page 1.
So, my lord, now, my lord, the question as to whether educational establishments also came in TMA Pi, in para 25 and 26 of TMA Pi. The phrase is establish and administer. I have a right to establish, my lord, under 26B of the Constitution. I have a right to administer. Those rights, it is stated way back in 1954, no legislature can ever take them away. That's all. I'm very deeply obliged.
Very pleased, my lords. So I will finish even before possibly the end. Very pointed.
Bear down your.
It's difficult to navigate what is left over, and I'll try to just give you lots of points without repeating.
Let's all shift.
Incidentally, well, it's the first learned judge who could be heard holding his own court in Supreme Court and other courts came from my state. And the second learned judge,
of course,
there were two learned judges, Malas, who could be heard in other courts.
Yes.
One from Rajasthan in the old days, and then one from Mumbai. Justice Tulsapurkar, Justice Bhargav, who was the uncle of Justice Suresh Agarwal. They are the two learned judges. You could clearly hear them in those days. Anyway, now, Malas, the first point, and I'll make it only point formulas. 3R, your lordship has seen. Just pick up 3 small r for a second. Now, 2 points have already been made in the text of it. Lordship, page 7 of the Act, perhaps. The two elements there are, one, proof of your practicing Islam. And the second is this delightful word, contrivance. So the first thing is, brothers, that you can never apply, look at the word, brothers, and that there is no contrivance involved. It's a recipe for making the applicant visit the offices of the collector or the officer for eternity, trying to prove that there is no contrivance involved. It's the most vaguest, arbitrary, completely whimsical word used to invite terror, control, and endless visits to the government office. Second, people of all religions make religious endowments. All. And India is, planet Earth's most diverse spot. Which other religion, at the point of making a religious endowment, by whatever name called, is asked for proof of that religion's professing and practicing? For 1 year, forget 5 years. For 5 years, for 10 years. Which religion? Point number 2. Point number 3. That brings in directly an article not really directly mentioned, Article 15. This provision goes on the short ground subject to my Lord's discretion of violating Article 15. Textually, it is a discrimination on ground of religion. Religion X and its donors and its creators of religious endowments are asked for proof of their religion, which is directly contrary to Article 15, which Lordship knows very well, brothers. Out of 7 or 6 tests, the first word is religion in 15:1. The state shall not discriminate against any citizen on grounds only of religion, and this is only religious, race, caste, sex, place of birth, or any of them. Religion is the first. And it is singular, brothers, in its novelty. The state is discriminating by using parliament to pass a law, and therefore that law is unconstitutional. Well, my second point relates to the Waqf by user point and goes slightly beyond. It has already been made, I only want to fill up a gap. By its very nature, Waqf by users were largely unregistered. At some point of time, a requirement came to give particulars and register, be that aside for a minute. The sub-point in 3C and all the other provisions here is the access to court point, the remedialist point. Now, my learned friend has already shown to your lordships the arc which connects 3C, 36.7, 36.7a and 36.10. That must be kept in mind. And well, it's a vicious circle that once you cease to be Waqf, you cannot exercise the remedy, principally because you're not a Waqf. So it's trying to catch your tail. Ground.
But please repeat yourself.
This arc is very interesting. Just let us pick up 36. 3C, my lord, has seen dispute. The counterpart of 3C is found in 36.7a. My lord has noted that. There also a dispute means you're not a Waqf. So one principle is in this act. The moment there is a dispute, a Waqf, so-called a Waqf established, a Waqf 500 years old, ceases to be a Waqf.
That's what...
Both 3C and 36.7a.
That's what Mr. Sibal also.
Yes, but I am not on that. I am now on the access to justice. Now, the moment you cease to be a Waqf, there is no question of registration or unregistered Waqf moving a court. And the bar of 36.10 applies in full force. That's why my Lord Management read your worship 36.10. So I say it makes a vicious circle that any dispute, and the dispute can start tomorrow. It doesn't have to be a pre-existing dispute. It doesn't have to be a dispute leading to a decree or a appellate decree or a Supreme Court decree or prior to this date. It can be a dispute started tomorrow. I can start a dispute tomorrow with this. So that is clearly exclusionary. Now, what I'm going is one step further. I heard an interruption saying the 3610 was always there. That is, there is more than a half truth. Please note what was the 3610 predecessor. Give this note. Come on, quickly. This is not a note for reading, but it's just for the quotation I've given you, so it'll be easier. Please ignore all the text. I'm not giving it to the side.
Note at the end. I know you just
Can I read a provision of statute from a note? Yes.
Not note.
Mr. Mehta, I hope that's not your best point, Mr. Mehta.
No, that's
Now let us come to page. Kindly come to page 4. Till now, I have not read the note, but I'm in terror. I'm reading only the provision from the note. Para 7. Now, this is important. Well, let's just don't read it for a minute. Give me miracles. In the 1984 Act, there was a bar of initiation of proceedings.
You're reading paragraph?
Well, it's 7 at page 4 of this note. Just the quotation I'm using it for. Does that not have it? See the underlined portion. Unless such Waqf has been registered. Right, brothers? Now your Lordship will note the next line. The amendment was not brought into effect is an admission and a fair statement by Mr. Mehta at page 36 of his counter, para 55. That italicized statement by me is a quotation from Mr. Mehta's counter, page 36, para 55. I hope I'm clear, Mellis. So a broad ouster clause was never brought into effect according to the counter. Now, Mellis, the next provision quoted is a provision in the 95 Act called Section 87. I hope there's a misprint there, Mellis. That section should be 87. If there's a misprint,
that is correct.
Corrected. I'm grateful. Now, this is another, the wordings are not identical. We are not concerned with that. Again, another kind of ouster. See the underlined portion, unless such Waqf has been registered. Right, fellas? This was deleted by the 2013 amendment. That's why I said it's more than a half truth, fellas. From 2013, this deletion stands. This vicious circle of connecting 3C, 36.7, 36.7a and 36.10 starts only with this 2025 regime. I hope I am clear on my second point. My third point is, Malas, about that ancient monuments where Mr. Ahmadi has made a very comprehensive note, which I will not, Malas, go into. Yes.
This side will have to conclude by 4 o'clock.
I will conclude in
We have already granted more than...
I have started at 3:35. I'll conclude.
No, we don't know.
Well, before that, I'll conclude.
Well, we had said 2 hours, but we are given more. If we continue till 4 o'clock, we will be giving more than 3.5 hours.
I will conclude, my Lordship may not doubt that at all. 100%. Even if I don't conclude, I shall conclude once.
So others are in waiting. So
yes.
Everybody would like to...
Now, let me just say what I wanted to say on this, just for a minute. On 3D, if something is left, I'll try and leave it.
No, not more than 4.
Let's finish. Let's use the time we have.
Yes. Since 20 minutes are left, we thought that Dr. Singh would be generous for others.
My lord, 4 minutes for me, my lord, because I have...
This will take away my 20 minutes. So let me finish as soon as I can.
After that, when I finish, my lord will consider that.
Now, Malas, the 3D, number 1, Malas, 3D, all the other facets of 3D I am not repeating. That has been argued. 3 capital D. Malas, it would, read as it is being read by the government, would even circumvent and impinge upon the Place of Worship Act, 1992. Clearly. Your Lordship reading it differently is something else. I'm not concerned about how Lordship read. That of course can be protected. Lordships can read it. As textually framed and as argued, this non-obstant situation in 3D Superimposing Ancient Act, Monuments Act onto this, well, superimposing 2025 Act on the Ancient Monuments Act has a direct result of affecting even those protected by another special act called the Places of Worship Act 92.
Effect of?
Effect of the Places of Worship Act 1991. I'm sorry, 1. Because something, let us say, a character of a place of worship which is X religion, Y religion, Z religion, is shut off on a cut-off date. Today, by a notification here, for example, for Muslim places of worship, you will create a situation where at least your lordship will have to work it out. Otherwise, on a literal interpretation, it will override that. The second point on that is...
Well, work out what? Work out what? You said that you will have to work out.
No, your lordship, unless absent your lordship's interpretation that the Place of Worship Act protection on a cut-off date remains a Muslim place of worship, a place of worship.
Ancient monuments.
I am arguing Place of Worship Act. I am not arguing Ancient Monument. I am saying if you notify under the Ancient Monuments Act.
According to him, by superimposing
yes,
the Ancient Monuments Act on the by 2000
the declaration under D
also affects the rights available to the citizens under the right to worship Act 1991.
It's not even an argument to be dealt. I'll deal with it.
It is my argument, not your argument. Because you haven't.
It is a pleading.
Yes. It is a pleading. It is a pleading. We'll give that also. Take it out. It is a pleading.
In fact,
because
that overrides all other laws.
A monument, which is a monument which is protected under the Place of Worship Act, can be declared under a notification under 3D. That is the point I'm making.
3D, there is no notification.
3D opens the word notification. Allow me to have my 15-20 minutes. Let me have my fundamental right to say wrong things.
15-20 minutes?
No.
You decide about yourself.
He is not allowing me my fundamental right to say wrong things, Your Lordship. What do I do?
Well, then,
he is interrupting me every sentence.
We don't mind, but then we will not be after
I'm trying to finish. The next point here is Article 15 comes in again. Because on 3D, Your Lordship has chosen one religion in this act. Not Your Lordship, the act has chosen. One religion.
This act itself is applicable to one religion.
That's right. Now this particular... this act applying this interpretation of the Ancient Monuments Act to one religion is what hits Article 15. That's my point. The fact that 3D textually applies the Monuments Act on this act and this act on the Monuments Act is only for one religion. That's Article 15, Malas. Your Lordship is considering prima facie constitutionality and whether to give Malas some interim orders. Therefore, this is very relevant.
Yes.
Now, Malas, this is as far as 3R and 3D is concerned. Lordship may also note that Your Lordship knows the law very well, that Your Lordship doesn't normally grant a stay. But look at the language Your Lordship used in the Farm Acts case, kindly hand over that case. Bernard, give that case. Rakesh, give it quickly. 2021, 1 SCC 590. Rakesh Vaishnav, about giving us, we are not asking for a stay on the whole act. We are talking of the provision Lordship has heard us on. All these provisions. My Lord has said this about the whole act. Kindly hand it over.
This was an unopposed order. We conceded. Let you be clear and honest about it. Justice Bobde's order.
I can't be clear and honest about anything before opening the book and reading the case. Kindly turn to Wallace. Para. Give me that book. Give me this one. Yeah. You don't. Just give me 1 second, Wallace. Para 10, 11 and 14. if my lord comes to 10, let us see what the learned Attorney General said, and let us see that the last interruption of Mr. Mehta was right or wrong. Please turn to para 9. Para 9. It starts at when we put across above suggestions. Got it, Your Lordship, got that? Para 9 starts like that. The learned Attorney General, even while agreeing for the Constitutional Committee, vehemently opposed the grant of any stay of the implementation of farm laws. I don't know what that English language means for us. Next page, continuation para. The learned Attorney General contended that the court should not stay the implementation of the laws. Therefore, para 10. Though we appreciate the aforesaid submission of the learned Attorney General, this court cannot be said to be completely powerless to grant a stay of any executive action under statutory enactment. Even very recently, Jayashree Lakshman Rao Patil. Now come to 14. I agree, Your Lordship doesn't grant it for the asking. But if there is one act, one statute, one case which cries out for certain absolutely sinister provisions requiring to be said, this is it. Having heard the different perspectives, we deem it fit to pass the following interim order with the hope and expectation both parties will take the right spirit attempt to arrive at a fair, equitable, just solution. The implementation of the 3 farm laws, all the laws are listed, last line, shall stand stayed until further orders. As a consequence, the minimum support price in existence before the act shall be maintained. We are asking for much, much, much lesser ones. We are asking for much lesser. Then, Your Lordship's recent judgment on 300A, authored by Justice Gawai, Chief Justice Gawai, just a few weeks ago. I'm not saying that it's all, but just note the citation. 300A.
The Karnataka matter?
Yes, called Bernard Vaz. 2025 SCC online SC20. Don't read it, just bear with me. Kindly note the citation. Court master will do it. Paras are 42, 43 and 56. The important point is that your lordships could have decided on the Karnataka statute about delayed compensation. My lords made it a point in para 42, 43 and 56 to say that what must imbue your lordship's interpretive approach must be 300 capital A. Namely, how you will interpret a provision, what will be the effect of that interpretation if it is expropriatory, and we have shown in detail what is expropriatory. I don't have time to repeat that. It will be imbued by what your lordship calls in those paras 42, 43 and 56. It's not a mere statutory right. It's a constitutional right. It may not be a fundamental right, but it's much higher than a statutory right. That's what your lordship says. So kindly note these 3 paras, 42, 43 and 56. Your lordship has got this thing about increase of trust by 100%, etc. properties. Just note this,
42, 43 and
56. Where is that? It is said, one of the arguments in the counter is that there is a huge surge in Waqf properties. Suddenly, huge surge, explosion in numbers. Just note the answers, A, B, C, D. A, the loading on a portal which they've created for listing Waqfs started in 2013. The loading onto the portal. That is pointed out in my rejoinder at page 5. Lordship may just note it for saving time. Therefore, as the portal was populated over time, the numbers had to increase. Before that, you had no population on that portal. They are treating an increase in the portal population of listing as an increase in Waqfs. An updation exercise. Number 2, the learned Minister of Minority Affairs on 18th of July 2019 at the rejoinder page 60 of Mr. Ayubi's file. Mr. Ayubi's writ at page 60 has the answer to an unstarred question. He says we have increased now and are proceeding day to day on increasing digitization. So what is being prejudicially suggested to your lordships to increase numbers of Waqfs is actually an increase in the portalization and the digitization. Thirdly, there are many properties in a Waqf area sometimes. They were treated as one Waqf property. Now each is listed separately. This is all stated in my rejoinder. So let us not have these prejudicial arguments in the counter that there is again and again a lot of prejudicial arguments are given. That you must have more and more, you are having a explosion. Well, your Lordship should be aware in this note. Just turn to one fact. So all we are talking in the abstract about registration and non-registration. In this note at page 2, extract from the JPC. Just see this for a minute, the note I gave. We are talking in the abstract about registration, non-registered, work by user, etc., etc. 2 figures only your Lordship will note. This extract at page 2, 2 minutes more, 3 minutes more. For the state of Bihar, now the Bihar Waqf Board filed a document before the JPC. It's only extract from there. It is an annexure to the JPC, it's extract from there. Out of 20,000 mosques, only 5.98% are registered. Just note that one line. And
not
second page, which is an extract. And the second line is, on 27,000 graveyards, 3.6% are registered. This is from the Bihar Waqf Board's written submission and annexure to the JPC report. And well, let's note my learned friend's counter with annexure at 195. Where is Mr. Mehta's? Page 195. PDF page 197, please.
Zero.
He says 50% roughly are Waqf by user. The figure he gives is 8.72 lakh properties, of which 4.02 are Waqf by user. Only that one line also save time. His own counter, annexing as part of the JPC extracts, says that. Whereas there are some more things, but I'll give it in a note if necessary. Well, it's one last thing, and after I'm getting it. But it's just these pages, reference your Lordship will not because you have time to see it. The reference I gave last was about the 195 of the counter, where the annexure is given, which says out of 8 lakh, 50% are Waqf by user. Well, there's 2 more statistics that I'm done. Para 80 of Mr. Mehta's counter. Para 80. 1 second. Para 80 of his counter says those works which have not been registered nor have they been found in existence during the survey by the Survey Commission, their claims are not maintainable at this belated stage. This is para 80 of his counter. The emphasis of the word survey by the Survey Commission. Well, as your Lordship will note, the JPC report at page 92 points out that survey is done only in 5 out of 28 states. It's a travesty. Just note the reference, page 92 of the JPC report. My friend's counter doesn't point this out. 5 out of 28 states and 4 out of 8 UTs.
New facts.
This covers JPC.
Just filed a note with new facts.
I have not filed a single note. I am quoting from your counter. I have quoted from your counter and the JPC report. Please don't misrepresent. Please don't misrepresent. Now, 9.3% of the area of the country as a whole is what these 5 states and 4 UTs represent. You do a survey in 9.3% of the area. In your counter, you say that in our survey, we found no registered works.
Not survey.
Your survey is only in 5 out of 28 states. And then you try to shut me out. I'm deeply obliged.
May I just take 2? I'd like to take 2 minutes. Just there's one aspect which your Lordships.
I won't get a turn.
But your Lordships were there's a point where there was some concern expressed by the court.
We don't detain you any time. We are not detaining you on a single day.
I have to seek your lot.
We quite appreciate your difficulty. You have to be at the right time before the other court.
Today, your Lordships can't say that.
But
Can't say that.
Lord, I just want to answer one aspect because your Lord, several questions fell from my lords when my learned friend Mr. Sibal and Mr. Dr. Singh were arguing, was with regard to the mandatory registration requirement. So I just want to place the correct position with regard to that. Plus, there's a 1923 Musalman Waqf Act, 1923. Is the first time, it's not registration, the first time a requirement came for declaration. Under Section 3, a declaration was to be made to courts with regard to Waqf, and Section 5 required some accounts to be maintained. In that act, the responsibility was of the Mutawalli, and under Section 10 of that act, the penalty, Section 10 of the 1923 Act, my Lord may just note, the penalty was 1,500 rupees, and for repeat offences, repeat subsequent offences, 2,000 rupees was the penalty. Section 10 of the 1923 Act. Section 3 is the obligation to furnish information by making a declaration to a court. Section 10, penalty on the Mutawalli was 500 rupees for the first offence, first conviction, and 2,000 rupees for all subsequent convictions under Section 10. Then comes the 1954 Act, which is the first post-constitutional act, which is the Waqf Act 1954. Chapter 4 provides for registration of Waqfs by the Mutawallis. Section 41 of the 1954 Act provides for a penalty of rupees 1,000 for the first conviction for non-registration, and for subsequent convictions, if there is a subsequent conviction, the removal of the Mutawalli under Section 43. The Waqf doesn't go, the Mutawalli goes under that provision. Then comes the 1995 Act. And in the 1995 Act,
what is the provision in the 54 or 58 Act?
In the 1954 Act, Chapter 4 provides for registration of every Waqf by the Mutawalli. Chapter 4 is Section 25 onwards. Section 41 provides for penalty of rupees 1,000 for the first conviction. And under Section 43, if he is convicted a second time, the Mutawalli suffers removal without his rights as a beneficiary going, but as Mutawalli, he gets removed from the Waqf. That's the only consequence. Now, my lords, comes the 1995 Act, which is the present Act. 2025 is an amendment. Now, Section 36 in Chapter 5 provides for registration of Waqf from 1995 till today, till 2025. And Section 61 provides for penalties. The penalty in Section 61 for A to D, A is registration. The penalty for a violation of A to D is a fine of rupees 10,000. And for E, F, G, H, which are most grievous things, which don't have to do with registration, but with taking away properties, etc., is imprisonment for 6 months. Now, even today, even in the 2025 amendment, the penalty for non-registration has been just increased to 25,000 rupees on the Mutawalli. Non-registration does not carry any other consequence except a penalty on the Mutawalli. Even in the 2025, it's only a 25,000 rupee fine, which is imposed on him. So, now please see the definition of beneficiary in 2A. My lord may just note it. This is a very unique situation right from the 1954 Act. The exact same definition of beneficiary is there. And in Waqfs alone, unlike other trusts, not just the people who benefit from it, but the objects are a beneficiary. So if my lord just sees the definition of beneficiary, and from 1954, 1995 and 2025, beneficiary means a person or object for whose benefit a Waqf is created and includes religious, pious and charitable objects and any other objects of public utility sanctioned by the Muslim law. The same definition, 1954, 1995, 2025. So, the beneficiaries can't be made to suffer for the offense committed by a Mutawalli. That is the whole point. The objects of the Waqf don't disappear. Because if the Mutawalli has not gone and registered, or suppose there's some impediment on registration, he was not able to find the records, etc., or for whatever reason it's not registered, neither the objects can go, nor can the beneficiaries who are the COM who benefit from it can be deprived of that. And that is why, my lords, no law, including 2025, has a consequence of Waqf vanishing. Now, 2025, by the other provisions in 3C read with 36, 7A and 10.
7, 8 and 10.
Yes, there the entire Waqf vanishes due to non-registration. That is why, my lords, it's very, very egregious, my lords.
Can I start tomorrow at
Lordship, just hear him for 5 minutes, just 5 minutes.
Just now, notes can
We had requested all of you to share your time with him.
No, just one thing. Our note, the spiral bound note, we had, as your lordship director, we had shared our points with Mr. Singhvi.
You give a consolidated.
No, that is a consolidated note. So your lordship, read that note as our submissions.
This is spiral one is the consolidated note.
Yeah, please read that as our submission.
My submission is the
Yes, yes.
It contains submissions of everyone.
Yes, I have incorporated.
In vacation, we don't want to just search his note and that.
I didn't argue those proportionality, all.
But that may be read.
Commercially, Dr. Singhvi argued.
It's all in the notes, mother.
consolidated note. Mr. Siva's note contains everyone's argument.
Mr. Izaz is prepared. You are prepared.
Yes.
No, my points are in that note. Your lordship may
Just
kindly
let him say a few words at least.
Let Mr. Ahmadi, my lord, give him 2-3 minutes.
Okay, we'll give 5 more minutes. Yes.
That's all.
I leave it to your lordship, Mullahs. I wanted to assist your lordship. If your lordship feels, Mullahs, that...
We know that you all of you are prepared, but
I don't want to say anything.
No, therefore we had requested Mr. Sival the other day that please, your time is over. We will also not give more than tomorrow to the other side also. That they have to...
Exit 2 hours is...
Whatever time we have given it to them, we'll give it to you.
I'm not followed on that.
Ordinarily in the opening,
They have
Mullahs, council takes a
crossed
little longer.
much
to be
beyond
able to-
2 hours.
Because some facts are to be stated. Now, just very quickly, Mullahs.
Yes, please.
May I just very quickly state a few points, Mullahs? I have prepared a separate note.
No separate.
Separate.
Otherwise, you take this note back and give us a consolidated.
Very well. Mullahs. Then I will not go through that. Mullahs, just 2 aspects that I want to highlight. Just, Mullahs, have the act. If your lordship just has section 108 and section 107. The impact on evacuee properties is quite substantial. Now, 108 was already read to your lordship.
Dr.
Yes.
Go on, read it.
Yes, Mullahs. Now, kindly see 107. Does your lordship have 107?
Yes.
On and from the commencement of the Waqf Amendment Act 2005, the Limitation Act 1963 shall apply to any proceedings in relation to any claim or interest pertaining to immovable property comprised in a Waqf. Coalesce it with section 108, which deletes evacuee property. Now, the effect of 107 and 108 together is that evacuee properties are out by virtue of section 108. So therefore, a registered Waqf in relation to evacuee properties by virtue of deletion to section 108 gets obliterated. Now today, my lords, by virtue of section 107, if I want to challenge any such declaration of evacuee property per se, that will be hit by limitation.
That will be hit by?
Limitation, because the Limitation Act applies. So those declarations, my lords, which are age-old, which were protected by virtue of section 108, that those Waqfs existed by virtue of section 108, because the number of evacuee properties which are declared as Waqfs are huge in number. Point number 1. Plus, for paucity of time, I am not elaborating those points. Point number 1. Point number 2, Mullahs. So far as section 3D is concerned, 3 capital D. Plus, I won't read 3D again, but your lordship recollects the text of 3D. What 3D says is that any property which is declared as an ancient monument either under the Act of 1904 or under the Act of 1958, that declaration shall be void. Now, Marad, just contextually, the history has been explained. The Act of 1904 and the Act of 1958 has listed several properties, including, my lords, ancient mosques. Now, at the time, my lords, of the 54 Act, 23 Act, my lords, only applied, my lords, in respect of declarations. So under the 23 Act, all that you have to do is seek a declaration before the court. That's for the first time that the provision for declaration came. The 54 Act for the first time, my lords, made registrations compulsory because it says it shall be shall. Now, even if I have a registered Waqf, under the 54 Act which I have registered, under the 1995 Act registered of any nature, whether it is Waqf by user or otherwise, all of them get obliterated. If on the date of the registration prior thereto, this was declared, my lords, as an ancient monument. So ipso facto, my lords, A, it is retrospective. And second is, my lords, by virtually by the sleight of a hand, my entire Waqfs, all of them which were registered earlier, my lords, completely gets obliterated by the operation, my lords, of section 3D. Now, the reason why, my lords, the argument, the submission, my lords, on Article 15 is extremely important is that there is no similar or analogous provision in any other act with relate to any other relation.
That is what Dr. Singhi also argued.
Correct.
Article 15.
That's correct. So, my lords, this only singles out one particular community. And, my lords, that also happens to 3E, because insofar as tribals, scheduled tribes are concerned, even, my lords, the very same provision, my lords, applies. So that's, my lords, the additional point that I wanted to make. The third aspect, my lords, of this particular of 3D is, your lordships, my lords, under an interim order have restrained any further suits which are impinged upon by the Places of Worship Act of 1992. Now, the effect of 3D is that even those ancient monuments, my lords, which are protected specifically by your lordship's interim order, will all get resurrected, because the government today can say that so far as those particular places of worship are concerned, I will regulate the manner in which the practices are to take place. So today you may say you will not use it for any purpose whatsoever. By virtue of 3D, that is the effect of 3D. So that therefore, my lords, that's an overarching provision. Fourth point, my lords, just very briefly I'll make it. I made my point on evacuee property. I made my point on limitation. Just one more aspect, my lords. The expression practice of Islam for a period of 5 years. And, my lords, that aspect of contrivance.
5 years.
5 years. Now, my lords, firstly, the point has been made that, my lords, in any other endowment act today, if I want to endow a property for the purposes of for a temple, there is no restriction, my lords, that I have to prove that I am practicing that particular religion for a period of 1 year. That's point number one. The second aspect, my lords, is how will you determine this factually? Is there an ascertainable principle by which you can determine this aspect as to whether this person is a follower of Islam or not? For example, my lords, can someone ask me that do you pray namaz 5 times a day? Otherwise, I will not permit you to make an endowment. That's an essential feature of Islam. Suppose some other Muslim is asked, do you drink? Will that be a criteria, my lords, for the purposes of saying that don't have it? And so far as contrivance is concerned, my lords, suppose tomorrow, my lords, someone wants to make a particular endowment. How will you determine, my lords, whether that is contrived or that is not contrived? That's the third aspect. And lastly, my lords, what I want to say is that so far as government properties are concerned, the injunction comes into force merely, my lords, upon a dispute being raised. There is no real formal adjudication which is required for this particular purpose.
That is already elaborately.
So therefore, my lords, therefore, my lords, in sum, all that I am saying is that so far as my lords 3D is concerned, its impact is drastic. My lords, it will apply to age-old mosques, age-old properties, and 3D, my lords, really requires an absolute stay for my respectful service.
I appear in the 5th of the 5 lead matters. Only 4 have been. Lordship, I just have two points to make. That's all, Lordship. Not detailed submissions. 2 points which have not been made so far. Lordship, the first is.
Everybody says that, but then.
Lordship, and I'll keep my word, Lordship.
It's almost 3.5 hours. I'm not objecting, Lord.
No, 3 hours, 45 minutes.
Lordship, it's already been stated.
I have come from Srinagar, my lord, only for this matter because most of the property, Waqf property is there in Srinagar. Please give me.
Lordship,
You include your points in the.
Clarification is listed.
Lordship, it has already been.
2 minutes, I will make question clear as far as Waqf is concerned.
How much time your side? How many? Who are going
We
to
are
argue?
5, but I'll start, my lord, and I'll cover, my lord, substantially, but will not take more than what they've taken. We can
You can't.
assure you.
You should take lesser than that.
Yes, certainly.
So that we should give them some time
The
for
points
result.
which were not brought to your lordship's notice, my lord, half sections, etc. But I'll have to show, my lord, what is
Lordship,
the
I'll
real
just take a minute.
purpose, intent, object.
Lordship, that's a very important point. So,
Please, sir.
I'm better.
Better than his.
Now, there is a Waqf board also. Well, interestingly, one of the state Waqf board is before your lordship supporting this. We will point out, my lord, I'll point out.
Lordship, in a very quick minute, Lordship. Lordship, it's already been said that.
That's the only good.
My lords may grant us tomorrow, my lord, because
No, sorry.
my lord, there are good, my lord, important points which I have taken in
Lordship, mine
application.
is the fifth matter out of the lead
Just
matter.
3 minutes, my lord. I will not take more than 3 minutes.
We had requested
My
all of
lord,
you
on the religious
maximum time in 2 hours.
in the
We have
context.
given you almost twice of that.
Lord, in the context of religious, if your lordship would consider my application, everything has been detailed, my lord, everything has been spelled out in time.
Lordship,
Lordship may kindly give us tomorrow, my lord, 5 minutes.
Please don't do this.
Lordship, 5 minutes, my lord.
So you give your notes.
Lordship, I appear in one of the lead matters which have already been selected as the matter that have to be heard. Lordship, I'll just take
We
2
had
minutes.
requested you to fix up timings among yourself.
Lordship,
Instead of 2 hours, we have already granted you 3 hours 45 minutes.
Lordship, as the youngest member of the family, that's not something I control, Lordship. So I'm just asking for 2 minutes of my lord and judges to make points which have not been made so far.
2 minutes by the clock.
My lord, 2
Very well.
minutes for me also.
Please.
Okay.
I shall be grateful.
Okay. Sir.
Sir, lordship, I
Obliged. Now that that's a judicial order, my lord, we can do nothing.
Rather than having